Good morning. Welcome to today's New York City Council hearing for the Committee on Housing and Buildings. At this time, we'd like to ask everyone to place all electronic devices to vibrate. Moving forward, no one is to approach the dais unless you are announced. Chair, we are ready to begin.
Good morning and welcome to the December 2025 hearing of the Committee on Housing and Buildings. I am Councilmember Pierina Sanchez, chair of this committee. On behalf of the committee and the New York City Council, I'd like to welcome the members of the public who are here today. During this hearing, as we hear testimony from the members of the administration and members of the public, a reminder that members of the audience must remain silent. If you wish to express support for any remarks, you may make the silent approval gesture. Throughout this hearing, you may hear opinions that differ from your own. Decorum and civility must be maintained throughout this hearing. It is essential that even if we disagree, we treat each other with respect. And for any member of the public that would like to testify, please be sure to fill out a testimony slip with the sergeants at the front of the room and clearly indicate your name, topic of testimony, and whether you support or oppose any of the legislation to be heard today. I want to make a note, since we're doing marathon, very long hearings in the Housing Committee. When you are testifying, when the public is testifying, you may not get to the end of your remarks. You may not continue unless I give you permission, okay? That is a procedural, that is a matter of process. I will probably give you permission just to conclude. We'll try to keep the testimony to just 2 minutes today, and I'll try to make sure, we wanna make sure to hear from everyone. But you may not say, I'm going to conclude, that is not allowed, okay? I will have to cut you off, and I have to give, it's just a procedural thing. I have to give permission, okay, as a chair. So thank you. All right. So we will first hear from the administration. We anticipate that will be about 2 hours, and then my colleagues will join and ask questions as they are here, and then the public will give your testimony. Today, our purpose is to conduct oversight into how our anti-discrimination laws are working in the context of cooperative and co-op and condo housing in the city of New York, and to consider legislation that brings transparency and fairness to approval processes. Co-ops and condos are one of the main paths to homeownership in New York City. 13% of occupied homes are in co-ops, and 28% of owner-occupied homes are in co-ops. But co-ops are also unique. Even after a buyer and seller agree on a price, the deal only closes if the board says yes. The board requests tax returns, credit scores, references, and more. And then, in some instances, could take months and say no without ever giving a reason. Let's say this plainly. Discrimination is happening today, and everyone knows it. Brokers, lawyers, and even some board members have admitted in outlets like The Real Deal and elsewhere that bias is real and pervasive part of this process. People of color, families with children, LGBTQIA New Yorkers, people with disabilities, people in certain professions, all can be quietly screened without ever being told why. We have strong fair housing laws on the books, but in the co-op and condo sales context, they are often toothless. Unlike rentals, where advocates can run testing and catch discrimination, you can't really send testers to buy in the and see how the board responds. When the final decision is made in a closed room with no explanation, it is almost impossible to prove what really happened. Secrecy is not a neutral feature of the system. It is the condition that allows discrimination to flourish and go unchallenged. What our bills do and what the bills do and do not. The first bill, Intro 407A, sponsored by public advocate Jamani Williams and many of my colleagues, is the Fair Residential Cooperative Disclosure Law, or the Reasons Bill. It does one very focused thing. It applies only after a buyer and seller have reached a deal. It requires the board, if it says no, to give the buyer and seller a timely, specific reason, and it creates a limited remedy if the board refuses to give any real reason at all. It does not tell boards who they have to approve. It does not change the legal reasons for which a co-op or condo can say no. It does not create personal liability for board members. At least it does not intend to. Fines are modest, tied to the severity of noncompliance and the resources of the corporation. And any punitive damages are only available for willful, repeated violations. We hear a lot of arguments against these bills, and let me address a few briefly. I look forward to your counter arguments when you testify later. We already have laws against discrimination, is one. Laws that you can enforce are not working. Co-op and condo secrecy is precisely what makes our fair housing laws so hard to apply here. We also hear this will open the floodgates to lawsuits. The only new claim is about the failure to disclose, not the substance of the board's judgment. If the board states their reason clearly and on time, they face no new liability. Another, board members will be personally sued and will stop serving on boards. The bill targets co-op corporations, not individual board members, and New Yorkers serve on boards of many other housing entities that already operate with more transparency and accountability. Another one is this undermines board discretion and fiduciary duty. The bill explicitly preserves lawful reasons to deny an application. Discretion has never included the right to discriminate in secret. We know this. Already deliberating, and they know why they vote no. Putting that in writing a few times a year is not an unreasonable burden in exchange for basic fairness. Other jurisdictions, Westchester, Suffolk, Nassau counties, have already adapted similar disclosure laws and timelines. Those places are doing okay. The sky has not fallen. What has changed is that discrimination is easier to spot and harder to hide. The second bill, Intro 438, which I sponsor, is about informed decision-making for buyers. Co-ops can demand exhaustive financial information from buyers, but buyers often have very limited insight into the building's own finances. This bill would require co-ops and condos to provide basic financial information, such as audited statements, so buyers are not walking in blind into risky situations. The third bill, Intro 1120A, sponsored by Majority Leader Amanda Farias, simply sets a reasonable timeline for boards to act on an application to purchase shares. No one should have to put their life on hold indefinitely. And finally, Intro 1475, a bit unrelated, but related in the grander context of fair housing in New York City, sponsored by Councilmember Eric Bottcher, would create a legal framework for shared housing. Legal rooming units with shared kitchens and common areas. In the middle of a historic housing crisis, we are discussing safe, regulated options for single adults and others who can't afford a full apartment on their own. This bill sets clear standards for protection, an important piece of the solution set. I want to end with this. Today's hearing is not a referendum on whether co-op boards are good or bad. It is about whether we, as a city, are willing to acknowledge that a serious problem persists, that discrimination flourishes in the dark, and whether we are prepared to take reasonable, targeted steps to address it. To those testifying in support or opposition, specifically opposition, it is not a productive use of this space simply to oppose no, no, no without offering alternative paths forward, particularly if you agree that there is a problem within our city. If you believe that these bills are not the right tools or there are problems with elements of any bill, then please tell us what you would do instead to ensure that co-op access is not governed by bias or secrecy. Because doing nothing is, in effect, a vote to maintain the status quo, which we know is not fair. Our goal is simple, equitable access to homes, not blocked opportunity. That is what these bills are about, and I look forward to our conversation. I'd like to take this opportunity to thank my team, Chief of Staff Maria Villalobos, Deputy Chiefs of Staff Ben Ratner and Kim Castellanos, Gerard Fernandez, Brenda Muniz, Stephanie Kuzi, and Austin Malone, Legislative Counsel Billy Eck, Senior Policy Analyst Jose Conde, Policy Analyst Dirk Spencer, Finance Analyst Carla Naranjo, and Data Scientist Reese Hirota. It takes a village. We are joined today by Majority Leader Farias, and I will now turn to her for remarks on her legislation.
Thank you, Chair Sanchez, and thank you to the members of the committee for holding today's hearing and providing the opportunity to speak on my bill, Intro 1120. This legislation is about strengthening good management, ensuring fairness and clarity, and combating illegal discrimination within New York City's cooperative housing system by bringing much-needed transparency to the cooperative sale and purchase process. Cooperative apartments, or co-ops, are for many New Yorkers the gateway to home ownership for the middle class. But unlike purchasing a single-family home, buying a co-op requires an additional step: review and approval by a co-op board. And right now, under existing law, a board can simply choose not to respond to an applicant at all. A prospective homeowner can complete every requirement, submit financial disclosures, enter into an agreement with the seller, pay a deposit and down payments, file their application, and still receive no acknowledgement or decision for weeks or even months. Some are left waiting indefinitely with no acknowledgement, no communication, and no decision. And while most co-op boards are responsible, thoughtful neighbors who act in good faith, this legal vacuum allows for bad actors to discriminate against potential buyers. This lack of structure benefits no one. It leaves buyers in uncertainty, creates confusion for brokers and sellers, and exposes co-op boards to claims of inconsistency, bias, or discrimination. My bill, Intro 1120, establishes a clear procedural framework for cooperative corporations in New York City that will remedy this problem. It sets out practical timelines and communication standards that bring structure and consistency to the application process while fully preserving a board's authority to approve or deny any application. I understand that co-op board members serve on a volunteer basis, and I appreciate everything that these volunteers do to keep their building running smoothly. That is why this bill is clearly drafted and is as easy for responsible good actors to comply with. First, the bill would not apply to co-ops with fewer than 10 units. Additionally, there are ample opportunities for boards to request extensions as needed. Further, the timeline for boards to respond pauses if co-op boards do not meet in the summer months. And to be fair, the timeline requirements in the bill do not start until the board deems that the application is complete. The only effective procedural change affected by my bill is that the co-op corporation must confirm receipt and indicate whether they view the application as complete or incomplete. They can then decide, as they can now, whether they unconditionally approve, conditionally approve, or deny an application. This framework ensures timely communication, accurate record keeping, and predictability for every party involved, all while maintaining the discretion and independence that co-op boards rightfully hold. It is intended to formalize good practices, eliminate the potential for discrimination, and put an end to the limitless waiting that so many applicants endure. This bill mirrors the success of near identical laws already enacted in surrounding counties, such as Westchester, Rockland, Nassau, Dutchess, and Suffolk, where consistent timelines have improved efficiency and reduced confusion without disrupting board operations as far back as 2009. In the case of Suffolk County, if they can do it, so can New York City. Even with the majority of co-op boards operating in accordance with the law, discrimination is still apparent in the cooperative housing market. Otherwise, financially qualified applicants are still being denied access to homeownership on the basis of their skin color, religion, nationality, sexual orientation, or other characteristics that should have no bearing on their ability to access housing. Without legally requiring a timeline to respond, applicants don't even have to be denied, just ignored. The absence of a timeline allows discrimination to fester. It keeps New Yorkers who want to buy homes in limbo and apartments that could have been sold. All of these reasons make it abundantly clear how vital clarity and consistency are to this process, not only for buyers and sellers, but for the health of our housing market overall, especially as we find ourselves amidst a housing and affordability crisis in New York City. The time to close this loophole is now. I'm proud to be the sponsor of Intro 1120 because it proves we do not have to choose between strong co-op boards and fair treatment for buyers. We can have both, and this bill makes that possible. By codifying these procedural steps, we strengthen due process, support sound management, and promote good faith communication for all parties involved in the cooperative housing purchasing process. As we listen to testimony today, I would respectfully ask my colleagues to hear the stories of those impacted by the lack of fairness and transparency in the cooperative purchase process and join me in improving the process to purchase a cooperative apartment. I respectfully urge the committee to support Intro 1120 and its advancement towards passage. Thank you again to Chair Sanchez, and thank you to the members of the committee for your continued leadership in advancing effective housing policy in New York City.
Thank you, Majority Leader. I'd like to acknowledge that we've been joined by Councilmember Ressler and Councilmember Hudson. I'd now like to turn it over to our Public Advocate, Jamani Williams, to read his remarks.
Thank you, Madam Chair. As mentioned, my name is Jamani Williams. Good morning. Public Advocate for the City of New York. Thank Chair Sanchez and the members of the Committee on Housing and Buildings for holding this hearing today. Cooperative developments offer an opportunity for homeownership which would otherwise be inaccessible to many New Yorkers. However, a long history of discriminatory practices in this industry, both overt and implicit, have left a gaping loophole in fair housing enforcement. As co-ops are considered businesses, they are bound by corporate law, which requires them to act in the best interest of shareholders. The extent of discrimination is difficult to quantify, but it is estimated to be a factor in almost a fifth of board decisions, with broker agents reporting common code words like quote-unquote NOK or quote-unquote NQ to indicate not our kind or not quite, because a potential buyer can wait lengthy periods only to be denied with no to access co-op ownership after denial. To that end, I submitted legislation Intro 407, which would require cooperatives to disclose to rejected applicants the specific reasons their application was denied. If the co-op board turns down an applicant, the applicant should be told the specific reasons for that denial. This transparency would allow applicants to better understand and address any genuine application deficiencies, and it would further mitigate discrimination, as a secrecy surrounding those decisions fosters an environment in which discrimination thrives. Furthermore, with more than 6,800 co-op buildings in New York City, more than any other municipality in the country, eliminating these closed-door systems would have a tremendous impact on efforts to make homeownership more equitable and accessible, setting an important precedent. Besides the benefits to individual buyers, the transparency also would make it harder to discriminate against a candidate whose financial records are good on paper. It cannot prevent every potential instance of discrimination by genuine bad faith actors, but a written explanation requires a more legitimate or at least specific and actionable rationale for denial. I also want to lift up Chair Sanchez's bill Intro 438, which would require cooperatives to provide financial information to prospective purchasers of cooperative opportunities, and Majority Leader Ferraz's Bill 1120A, which sets a timeline. Hopefully we can work on all of these bills together. These bills would equip prospective buyers with crucial information, moving us one step closer to eliminating a long-standing asymmetry of information. Creating more transparency to the entire application process is critical as we encourage home ownership in our city. I want to thank Chair Sanchez, Majority Leader Ferraz, as well as members of my own policy team for working together on getting these bills to this point. I also want to thank Craig Garian, who are working tirelessly with my team to build a coalition around this legislation. I hope to see them pass this session. I do want to say this is not an indictment of any one specific co-op building. This is a systemic issue that we've seen for quite some time. And I know it's difficult to parse through everything that's going on and how each of these co-op boards work. It is difficult to change things if we don't change things. And so we do have to find a way to how to make the changes that are necessary and still allow the autonomy that co-ops need. But we can't allow the system to continue to work the way it has been working, because I think most folks agree there has been discriminatory practices, whether intentional or unintentional, that have barred a lot of people from this home ownership. So hope for everyone involved. We really take efforts to find the best ways to craft these bills so that they can pass and we can really impact a problem that I think everyone knows exists. Thank you so much.
Thank you so much, Public Advocate. I'd now like to turn it over to our counsel to administer the oath.
Thank you. Please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth before this committee, and to respond honestly to council questions?
Yes.
Yes.
Thank you. You may begin when ready.
Thank you. Good morning, Chair Sanchez, Majority Leader Farias, members of the Committee on Housing and Buildings, Council Members Ressler and Hudson, Public Advocate Williams, and committee staff, and all the folks that were named that are behind the scenes today. I'm Joanne Camaford, Deputy Commissioner of Policy and External Affairs at the New York City Commission on Human Rights, also known as CCHR, and I'll be delivering joint agency testimony on several of the bills. With me today from CCHR is Hilary Scrivani, Director of Policy and Adjudications, and I'm also joined by Lucy Jaffe, the Deputy Commissioner for Policy and Strategy, the Department of Housing, Preservation, and Development as well. I don't want to leave out Michael Sandler because he's here, but he's giving his own testimony. I'm happy to be here with you today. The city is committed to ensuring that every New Yorker has an opportunity to address the discrimination they experience. In 2020 and again in 2025, the city released Where We Live NYC, Where We Live 2025 is a 5-year housing plan that sets out goals, strategies, and commitments to combat housing discrimination and expand housing opportunity across New York City. Goal 1 is to fight discrimination and ensure equal access to housing. This includes commitments for multiple agencies to work together to do a wide array of things. I'm going to highlight 3 that are relevant specifically to this committee. First, to expand capacity to address allegations of housing discrimination with particular attention to source of income discrimination and disability discrimination, including through community partnerships and collaboration with council. To create and implement a strategic education campaign to inform housing providers and housing seekers about the New York City Fair Chance Housing Law, which prohibits discrimination based on criminal history and went into effect January 1st of this year. And third, to educate New Yorkers about the right to be free from discrimination in housing sales and educate housing providers about their obligations under fair housing laws. The plan specifically recognizes the issue of co-op discrimination. Although CCHR and HPD have limited roles in private market transactions, such as co-op purchases, our agencies welcome the opportunity to speak with you today about the city's housing market and ongoing work to prevent and address housing discrimination. As HPD has discussed with this committee many times, the city's rental market has long been in a state of housing emergency and across all types of housing is experiencing extremely low vacancy rates. Where We Live 2025 notes that limited vacancy can intensify discriminatory practices. Cooperatives, or co-ops, as have already been mentioned, are one of multiple types of home ownership in New York City. Owners buy shares in the co-op, which functions much like a corporation, and become shareholders in the corporation. The New York State Attorney General regulates the formation and many of the processes involved in operating co-ops. Co-op members generally elect a board of directors who are charged with ensuring the co-op remains financially stable, resolving conflict, and overseeing operations. The process of buying into a co-op is unique, as the chair has already identified, from other types of housing, and increasing transparency in decision-making has long been a policy focus to address a range of concerns, including, but not limited to, rooting out discrimination. When a prospective co-op purchaser believes they've experienced discrimination in the buying process, they have multiple potential avenues for pursuing a remedy. New York City and state laws prohibit discrimination in rental and sales, and individuals who believe they've experienced discrimination can seek redress for discrimination through anti-discrimination agencies such as the Commission on Human Rights and the New York State Division, as well as in courts. The Commission has actively worked to raise awareness about the wide range of protections in housing that already exist in the City Human Rights Law, including, as I mentioned, the newly enacted Fair Chance Act, as well as disability protections through innovative collaborations and partnerships to reach New Yorkers outside of traditional media channels and government communications. Turning to the bills, I will focus on Intro 407A. Intro 407A amends Title 8 of the Ad Code, which houses civil rights protections. The bill would add a new chapter which regulates how and when housing cooperatives communicate with prospective purchasers when they are denying a sale. This includes mandating a statement of all the reasons that an applicant's offer is not accepted. The bill creates a private right of action for failing to comply with these requirements and authorizes the Commission to address claims related to timelines, disclosures, and other procedural requirements related to sales, and to evaluate all of the potential reasons a sale may have been denied. Intro 438 and 1120A amend Title 26. The former would require cooperative housing corporations to provide approved purchasers with financial information within 14 days of their request, and the latter establishes standardized procedures for cooperative apartment boards, requiring boards to provide a complete application package upon request to applicants and setting timeframes to acknowledge receipt of submitted materials, identify deficiencies, and issue a final decision. The city supports council's goals of tackling discrimination and strengthening transparency and predictability in the co-op application process. While neither agency plays a direct role in regulating these transactions, we look forward to sharing our collective expertise in discrimination enforcement and the housing market to help inform how these pieces of legislation can best achieve our collective policy goals. Our agencies look forward to hearing stakeholder input in order to ensure these pieces of legislation balance stakeholder interests and achieve Council's objectives of eliminating discrimination. And we welcome, as always, the opportunity to work with Council on these important issues.
Good morning, Chair Sanchez, Public Advocate William, and members of the Committee on Housing and Buildings. My name is Michael Sandler, the Associate Commissioner for Neighborhood Strategies at HPD, joined by my colleague Lucy Jaffe, Deputy Commissioner of Policy and Strategy. We're also as Director of Architecture at the Department of Buildings for questions. Thank you for the opportunity to testify on Intro 1475 today. In 2020 and again this year, HPD affirmed its commitment to fair housing through Where We Live NYC, a plan to expand opportunity and choice for all New Yorkers. In order to advance this commitment, we are looking both to innovative ideas and to draw on lessons from the past. Shared housing represents an opportunity to reimagine a historic housing model for the 21st century. Shared housing, which is 2 or more privately leased bedrooms with shared kitchens, bathrooms, and living spaces, has a long history in New York City. By the first half of the 20th century, shared models such as boarding houses and single-room occupancy hotels constituted a substantial and affordable part of New York City's housing stock. They served a wide range of households, from immigrants newly arrived on the city's shores, to young people flocking to the city for factory jobs, to New Yorkers looking for a short-term place to stay as they navigated life changes. However, policies implemented in the mid-20th century intended to improve housing quality led to a prohibition on the construction of new shared housing and a sharp reduction in the existing stock. The loss of this stock coincided with the rise of street homelessness. In the 1980s, realizing the role the model played in housing New Yorkers, the city tried to reverse course and stop the wholesale conversion of shared housing. But the damage was already done and the SRO stock was significantly diminished. The impacts of these policies reverberate across the city today. Per the American Community Survey, between 2013 and 2023, the number of small households increased by 11%, while growth in the city's small unit stock failed to keep pace, growing only 70.5% during the same period. While it is clear that New York City needs housing across all types and household sizes, a growing number of single adults are taking on roommates to mitigate high housing costs and the lack of affordable housing for single persons. This trend puts additional pressure on the city's existing stock of larger homes, as single persons pooling multiple incomes outcompete 1 or 2 income families. Increasingly, roommate shares have been commercialized, and landlords are renting individual rooms in illegally converted apartments, compromising tenant safety by violating fire safety and egress rules and blocking access to light and air. A burgeoning and unregulated market of co-living shows that there is demand for this type of housing in New York City at a variety of price points. Reintroducing purpose-built shared housing models provides a new set of tools to expand housing opportunity and choice to the growing population of single New Yorkers. Intro 1475 will establish clear harmonious living with more kitchens and bathrooms than historically required for SROs to mitigate conflict and increase privacy and fire safety standards that meet or exceed those of traditional apartment buildings. New shared housing will be built based on new regulations which ensure effective tenant protections and high quality and safety standards. On November 25th, HPD released New York City's Shared Housing Roadmap, which lays out a path for reintroducing shared housing. The roadmap builds on lessons learned from past shared housing models and recent efforts to expand housing options and opportunities for New Yorkers. In 2018, HPD launched the Share NYC pilot program to explore potential shared housing models on 3 sites across the city. In the course of developing these projects, we encountered myriad zoning, code, and policy challenges that slowed development and raised costs without improving quality of life. Where We Live NYC's commitment to facilitate equitable housing development bolstered HPD's efforts to overcome barriers to shared housing. The passage of City of Yes for Housing Opportunity in December 2024 removed zoning barriers identified in the roadmap. Today, Intro 1475, sponsored by Councilmember Eric Botcher, advances the roadmap's legislative strategies to allow as-of-right construction of new shared housing and introduces code changes governing its design, occupancy, and safety. The shared housing roadmap and the strategies it lays out are the result of careful research, analysis, and testing over nearly a decade. Research into the legislative history of shared housing provided a strong foundation for understanding the strengths of historic models and the operational pitfalls to avoid. Conversations with shared housing tenants, nonprofit and for-profit co-living operators, policy experts, and other municipalities implementing shared housing models provided context on modern-day operations and best practices. Collaboration with other agencies, including the Department of Buildings, the Department of City Planning, and the Fire Department, as well as partners like the Administration for Children's Services and the Mayor's Office for Criminal Justice, ensured a comprehensive, multi-sectoral approach that examined the model from a variety of perspectives. Formed our legislative approach. Taken together, these efforts chart a path to enable shared housing that ensures robust design, management, and tenant protections. As New York City continues to grapple with growing housing demand, rising rents, and high construction costs, shared housing opens up new opportunities. In central areas where office to residential conversion opportunities are abundant, shared housing offers the potential to not only create more units within a large office floor plate, but to also develop less costly conversions by clustering bathrooms and kitchens around pre-existing, centrally located plumbing networks. Shared housing can also increase tenant protections for thousands of renters by providing them a housing option with separate and independent relationship with their landlord through individual leases and good cause eviction protections. Shared models can also create opportunities for communal caregiving, shared responsibilities, and light touch services for households who may be isolated or vulnerable in traditional housing, but who do not need the depth of care provided by supportive housing. Existing shared housing programs in New York City demonstrate that the model can serve New Yorkers who are seeking a communal lifestyle or who are navigating a transitory phase of life as well. The Ascendant Alley Forney Center Share NYC project, which was approved by the City Council in 2023, provides an opportunity for formerly homeless young adults to learn life skills for independent living while sharing costs and responsibilities with fellow residents and maintaining a support system through communal living arrangements. The Neighborhood Coalition for Shelters Scholars Program provides unhoused CUNY students with stable, year-round housing and educational supports to see them through to graduation. The New York Foundlings Mother and Child Program supports caregiving by providing shared housing for new mothers who are themselves young adults in foster care, where they can finish school, find employment, and learn how to care for their children. The International House in Harlem provides a first home for students and young professionals from abroad who do not have credit scores or other necessary resources to access housing on the private market, and offers opportunities for new arrivals to settle into a purpose-built community. While these models demonstrate the possibilities that shared housing can offer, we want to be clear that this model is not a right fit for everyone. Heeding the expertise from the supportive housing community, HPD has determined that shared housing is not the right fit for most supportive housing residents, and as with all our programs, no one will be forced to live in shared housing that does not meet their needs. Additionally, shared housing is not transitional or short-term housing. It is Class A permanent housing that is not a substitute or supplement to the shelter system, and it will not be permitted to host short-term rentals. Intro 1475, a collaboration between the City Council, HPD, and the Department of Buildings, the Fire Department, brings the vision for shared housing articulated in the Shared Housing Roadmap into reality by proposing amendments to the Housing Maintenance Code, Building Code, and Fire Code. At a time when vacancy rates are at an all-time low, especially among New York City's lowest cost apartments, we need to take a multi-pronged approach to the housing crisis. Shared housing is one of many tools HPD is deploying to tackle the crisis. While not the appropriate model for all New Yorkers, shared housing offers a new option for single New Yorkers seeking communal living at an affordable price. We are grateful for our continued partnership with the Council and our collective efforts to address the shortage of low-cost housing and meet the needs of our diverse residents. We welcome the opportunity to work with the Council to advance this historic legislation and look forward to your questions.
Thank you so much. I'd like to acknowledge that we've been joined by Councilmember Dinowitz. Excellent, thank you. So I will begin with questions. If you want to ask questions as well. Starting with CCHR. Just a clarifying question on your testimony before I begin my line of questions. So you state in your testimony that the city supports the council's goals of tackling discrimination and strengthening transparency and predictability in the co-op application process. Our understanding is you would be the agency that would be enforcing these provisions should they come into law. Do you have a perspective on these provisions in particular?
Thank you so much for the question. I think these four bills, but the three that I'm going to speak about regarding co-op timelines and procedures are spread across different parts of the code. And I think part of the discussion we want to have with you all today is about what are the right mechanisms for redress. So I think, as was identified, CCHR does handle discrimination in the co-op space. We have cases in that space, and we can talk about what those look like. And so the discrimination piece, 100% within our purview. I think one of the things that we've been talking about as city agencies, in which we want to hear from stakeholders about, is the mechanisms of the bill, the timeframes, and the other disclosures, because we are not in the market every day. We are not a housing provider, and we're not a cooperative owner. And so thinking about, are these the right disclosure mechanisms? Are these the right timelines? Those are not questions that we in the anti-discrimination space are really prepared to take a position on. We are prepared to say we abhor all forms of discrimination, and when that shows up in co-ops, that is antithetical to our law and our values. But really, it's the mechanics that are outside the discrimination piece where we really want to work hand in hand with you and stakeholders to understand what is the right approach. And
Thank
I'll
you.
just turn to, since it's joint testimony, I want to make sure HPD has a chance to weigh in if there's anything to add.
Good to see you all again.
Welcome to your weekly installment of HPD at City Council hearings.
We have to stop meeting like this. Nope, 3 times last week. Yes, HPD agrees with CCHR on that. We're aligned.
Okay, so I just want to be super clear. I'm hearing the agency support the intent of the legislation.
Yeah, I think we support the intent, and as I said, to the extent these are about addressing discrimination, we are with mechanisms to ensure transparency, information, empower applicants, whether they're renters or buyers. I think where we are more agnostic and really want to hear from other people is on the timelines and other mechanisms, because I think, as you identified, Chair Sanchez, this is different than a lot of the types of discrimination we see in the rental space, right? In the rental space, you can never consider someone's protected category. What you can and should look at is, can they afford to pay the rent? If you're looking at anything beyond that, it's pretty clear there's the potential for a discriminatory motive. I think in the housing cooperative sales universe, where you're looking at a whole host of financial health and well-being of a business, there are more factors that go into play in looking at cooperative applications. So I think just finding a distinction there between what are the moving parts in renting and what are the moving parts in housing, I think what makes it a challenging area to regulate, but we're not opposed in any way to regulating processes. We just want to make sure that any regulation meets the needs of the buyers, the sellers, and doesn't impose burdens that don't hit on the discrimination piece, right? You can have a lot of paperwork. That doesn't mean you're able to prove discrimination happened if that is not the right documentation, or if there's the ability for entities to paper over what their actual motives were.
Thank you. That is helpful. CCHR, you investigate discrimination across all kinds of housing. You mentioned that co-op and condo discrimination does come to the agency as well. Complaints do come to the agency as well. Can you share how many complaints the Human Rights Commission has received, say, in the last years, alleging discriminatory board denials? What percentage resulted in findings of discrimination, and what percentage or number was denied due to lack of evidence?
Yes. I want to contextualize the answer by referencing something that was in our testimony, which is that individuals have an array of choices where they can go to address discrimination. So people can choose to go to court, where remedies can be endless. People can choose administrative processes like CCHR or the State Division, where there are some more restrictions about what are appropriate remedies. As I stated, housing is of deep importance to the Commission, and in fact, the human rights law was written at a time when people were on their face being rejected from renting or buying houses purely because of the color of their skin. So this is a super important topic to us and really the foundation of the human rights law. Employment cases are the most cases that we receive. In recent years, we in the housing space have had several hundred cases, about 500. Within that, a much, much smaller amount, 10% more or less, relate to co-ops. To complicate the picture a little bit more, a very small number of those relate to sales. The majority of them are about disability discrimination for current tenants. So the failure to be able to have a reasonable accommodation, which I know is something council is very interested in as well. So discrimination also happens in the cooperative space. So I would say that is another high area of cases for us. That is either the board is seeking to rent out a unit or individuals legally or not legally are seeking to sublet. And we've seen voucher discrimination case. As you know, that's also one of our top priorities. Answer to your question is we receive really a small handful of cases about co-op sales, a larger universe of cases related to co-op boards, and when we zoom out, more even about housing. I think before kind of answering the second part of your question, I do want to highlight in recent years during this administration, which I've been a part of 2 administrations during the time that we've been at the agency, co-op and condo sales have been an important part of the education and outreach we do. Our kind of agency motto is, an ounce of prevention is a pound of cure. And so all of our trainings touch upon co-op and condos. We know it is a space that is hard to understand sometimes for applicants, but the processes are complicated. I went to law school. That doesn't mean I understand all the processes. Really wanting all New Yorkers we engage with to know that this is a violation of the law. And to that end, I will say one more thing before I talk about the outcomes of cases. We launched a partnership with the Fordham Real Estate School 2 years ago to specifically train housing brokers, so real estate brokers, and kind of the main face of real estate transactions for many New Yorkers are the management companies or the real estate brokers. So we give folks credit if they come learn about fair housing laws. That's free. We've reached almost 2,000 housing real estate brokers in that outreach. And again, really focused on how do we empower New Yorkers and how do we address discrimination. So turning back to the specific question, which is that we really have had a handful of these cases. In the past 5 years, some of the investigations are ongoing. A few of them have been what we call administratively closed. That means that we are not finding that discrimination occurred, but an individual can still go to court. The reason that might happen is because an individual is saying, I experienced discrimination. And a housing provider is showing a fair amount of documentation that there were alternative reasons that a person was turned away. And so we administratively close that case. That doesn't mean no discrimination occurred. It means we cannot say that it's more likely or not that discrimination occurred. I'll close by just talking about 2 cases because I think they illustrate what we see at CCHR. One was in 2019 based on national origin when an applicant who was perceived to not be from the United States was asked their citizenship status. They were denied housing. That was a case where we found that it was more likely than not that discrimination was occurring. We found in favor of that individual, and they received damages, and there were civil penalties paid as well to New York City. The second case is a more recent one brought by an African-American couple seeking to buy a co-op. They understood that there were no other Black people living in the building and were not on the board, and believed that they were not offered the apartment in the end because of their race. An investigation in that case demonstrated that ultimately the buyer was selected because they could pay all cash. That's a different problem than what we're talking about, but I think that's a really important piece of this picture. Financial salience, which is a challenge for many New Yorkers is piece of the picture. In that case, the records all showed that the individuals had actually falsified financial information and where they had lived before, and we closed out that case because we did not think it was more likely or not that discrimination occurred, again, based on the totality of the circumstances.
Thank you. And could you give us a numeric breakdown of, you said 500 housing cases, about 10%, so 50 were related to co-ops and condos. Can you give us a breakdown of how each of those 50 were handled?
I can give that to you. I don't have the determinations for all 50 today, but I'm happy to circle back with that information. I have only the very few handful of co-op sales, which I've already mentioned, but we can share information for the ones that are closed of what the resolution for those was.
And so the handful that are related to co-op sales, it's like less than 10?
Yeah, in the past 5 years, yes.
Okay. And you said there are other avenues that New Yorkers may pursue. Do you have a sense of housing discrimination case numbers? Like how many are being routed to CCHR? How many are going to courts? How many are going to the state?
I will say something that is really a pure guess, which is that based on the reports that discrimination is occurring, that courts are seeing a higher number than CCHR, but I don't have the data to back that up, and we don't have the ability to have insight into how many co-op cases are taken to courts or to the state division.
Great, thank you. Can you walk us through the complaint process in the Human Rights Commission? What are challenges to proving discrimination in co-op and condo denials? And co-op and condo sales denials.
Oh, got it. Yes. Okay. So the majority of cases that come to CCHR and that are filed by CCHR are because members of the public contact us and they say they think they've experienced discrimination. So when someone contacts us and it sounds like they have a claim that is within our jurisdiction, they meet with somebody to do intake. If there's allegations, if taken as true, demonstrate the likelihood that discrimination occurred. The most common path historically has been that CCHR files a formal complaint laying out those allegations, and the respondent has 30 days to provide an answer, just like in court proceedings. So for every allegation, the respondent is saying, we deny this, this is what happened. Often there's a position statement along with that, so it's like a formal legal proceeding. We have mechanisms at the commission to do what we call pre-complaint intervention, which is to kind of, if discrimination happened in very recent time and is something we think we can remedy, this happens most commonly in SOI and disability discrimination cases, we will reach out directly to the respondent without filing a claim, a formal complaint, and try to remedy the act of discrimination that occurred. So that's the most common process. Then we investigate the case and our attorneys do the investigations to determine the final outcome. We also have a smaller number of cases that are filed by attorneys, and then we pick up the complaint and we launch the investigation based on those allegations, which have the same answer and response formula as our other cases. And then the commission can also initiate its own cases. That's really a handful, but I will say thanks to council and the city of Yes, we will be increasing our law enforcement bureau capacity to be able to do more of the commission initiated investigations. So I think the second part of your question was challenges in proving co-op discrimination. I think several have already been alluded to. Like all cases that come to CCHR, it's very fact specific. So we can have a case where there is a individual shareholder plus the co-op board plus a broker, right? And we have to investigate the actions by all of those actors, and that can be time consuming. We talk to everybody, we take the whole lay of the land. We don't represent individuals, we represent New York City, so we are a neutral investigator in those interactions. So I think one complexity in this area is just the number of actors. A second piece, which is unlike other types of housing, is what was already flagged as the financial obligations of the cooperative board, right? It's a housing provider and it's a business. And so there are different considerations, as I mentioned, than there will be when you're looking at potentially a renter. So I think those are the two main factors we see from an anti-discrimination perspective. But I want to turn it over to HPD to see if there's anything to add.
No, we defer to CCHR on the process for investigations.
Thank you. In other municipalities that have adopted reasons or timeline provisions, there are several that require co-ops and condos to report to their commissions of human rights. Would our Commission of Human Rights be equipped to receive those kinds of complaints or any other agency within the city?
So you're saying that the existing laws require cooperatives to report to their commission. I think I'll just highlight a piece of what we talked about. I think we mentioned Westchester County. I'm less familiar with Suffolk County and the others. I think Westchester County has several hundred co-ops. New York City magnifies that by thousands. So I think we are prepared as CCHR to handle all complaints of discrimination that come to us. In fact, we are mandated. We're a right to file agency, so we do not turn anyone away. I think the same piece I'll go back to that was mentioned previously was that our staff are trained to investigate and look for discrimination. If we are looking at CCHR as a place to be analyzing financials, analyzing disclosures, identifying co-op bylaws, and making good governance decisions, that's a different profile than what our agency currently does. And I don't think there's an agency that is currently set up to do that work. But again, defer also to other colleagues.
Yeah, we'll just add, not only is New York City, obviously our housing market is so much bigger, but co-ops represent a much bigger share of our market than in many other places, so that compounds the scale.
Thank you. I'm going to just ask a couple of rapid fire questions and then I'm going to turn over to my colleagues. Majority Leader, you'll be first, followed by Dinowitz, Ressler, and our public advocate. So you mentioned there's just a handful, maybe you know this off the top of your head, but in the last several years, has CCHR ever had written reasons provided to a complainant to work with in your investigation? Written reasons for a denial and a sale?
Yeah, so in the cases that we have seen, again, the small handful that we reviewed for today's hearing, there are reasons provided. So I know that's not the landscape that we're talking about in the bigger picture, but it is, I think in one of the examples I mentioned, someone was turned away and it's based on finances. I would say financial reasons are the number one thing that we see, and whether that is accurate or not is what an investigation would look into. But we haven't had cases, I think, to put a finer point on the answer to your question, where there's just no reason given or there's what we would call ghosting in the housing context. That doesn't mean it doesn't happen.
So clarifying,
Sure.
Are the reasons that that were provided directly to the buyer before the complaint was filed or provided to the agency as a part of the complaint investigation process?
So I actually think it's a mix that some are told on their face, we're going with another buyer who made an all-cash purchase. If someone thinks that sounds suspect, they come to us and they don't need documentation to come to us, right? Our cases are investigated whether or not there's documentation.
Great, thank you. Do you think that intro, and this is for either agency, do you believe that intro 407 would deter volunteers from serving on co-op boards?
We have no reason to believe that disclosure of the reason alone, as my colleague testified, sometimes that happens as part of the process, is in and of itself a reason not to serve on a board, though that is not something that we necessarily would be directly engaged in, but we have no reason to believe that it would.
Okay, thank you. On Intro 438, the bill requires disclosure, as written, requires disclosure of assets, liability, cash flow, debt, operating expenses, capital improvements underway or planned, reserve funds, and a most recent budget. Do the agencies have perspective on whether this is the right set of financial information that should be disclosed, or whether other items should be included or excluded?
So what we'll say is that we're actually not we can't say for sure that disclosure by the co-op board to the prospective purchasers will be instrumental in helping to root out discrimination. It can be part of the process. We believe that there are, again, these are private market transactions, so I think in our expertise, right, we think that we would want to hear from other folks today on the impacts of what is most relevant to them. And one of the things that we're looking at, and we alluded to this in testimony and in some of the discussions so far, we're always looking at when we're adding new requirements in the housing market, is it what kind of administrative burden is it creating, and does that translate to additional costs? Because the other thing we're often here talking about is the cost of housing in our market. And that doesn't mean that we shouldn't pass important laws, including ones that facilitate transparency and disclosure, just because they add cost. But what we want to do when we're thinking about it from a policy perspective is weigh, is that an additional administrative requirement going to help us achieve our stated goal? And so here, I think the question that we want to hear from other folks as well is the extent to which we think this additional administrative disclosure requirements, to the extent it's not already happening in the market naturally between purchasers and co-op
and I
boards.
just want to clarify, this particular bill is not about preventing buyer discrimination chiefly. It's about making sure buyers have good information as they make one of the biggest financial decisions of their lives, probably at the point of purchase. And so the question for HPD and in the fair housing context is really about risk, or no, it's not about risk. It's really about whether these sets of information are feasible for co-ops and condos to provide to prospective purchasers, and what is.
So thank you for that clarification. And when HPD is involved in co-op transactions, those processes are handled separately. So I think we would be looking to other folks here to testify today, potentially with more insight into the exact documents that would be most helpful and how to sort of think about that list of what normally happens in the transactions and what might be missing that would be important to add.
Thank you. Does the commission have any evidence or have received any complaints alleging that prolonged approval processes have been used as a way to discriminate?
Yes. So from the small universe of cases, that has not been what we've seen. But again, I don't think our cases necessarily reflect the market. And so we don't have any clarity outside of what has come to us, but that has not been the cases that have come to us.
Great. Thank you. I'm going to turn over to colleagues, and then I'm going to come back and ask more questions on shared housing. So first up, Majority Leader Farias.
Thank you, Chair. Just for the commission, a couple of questions. Can you speak to any challenges or even tactics used by co-op boards for New Yorkers or clients that you have experienced, including possible illegal discrimination when looking to purchase a cooperative apartment?
So I think the majority of cases that we've seen, again, a small number, sometimes the questions themselves, and I talked about the one case around national origin discrimination, are discriminatory, right? So it really doesn't matter what is said later on in the process if on its face you're asking particular questions of an individual that are discriminatory. So I think there, like in rentals as well, there's discrimination that is occurring because people don't know or don't want to know what the appropriate questions are and what the law requires and what the protected categories are. But I think beyond that, we have not seen any trend of particular tactics. I think it's a confusing marketplace, and so people feel that they have experienced discrimination. Sometimes there are financial documents that back up that it was a financial decision, and sometimes there are not.
I guess hearing that response, I'm thinking about how folks sometimes, what we're doing here is trying to use legislative action to go back on the claims that we already have that through CCHR to be the remedy for illegal discrimination in New York City, particularly. I guess, why do you believe that people, like members of the public or people, feel like they have been discriminated against, are reluctant to bring claims to either to CCHR, or do you think people just don't know you folks exist, since the numbers that you stated earlier? What actually, and to add on that, what's the outreach? How do people know? What are you doing for people that are looking to purchase in New York City, or even interested to transition from their current housing to something bigger, and to get you folks, accessibility to you folks?
Yeah, sure. So I think I am going to say people know who we are, but I'm going to say that based on the data from our most recent kind of annual reports and the outreach we're doing. So fiscal year 25, we reached more New Yorkers than we have in the history of the commission.
What's the number?
153,000 and three other numbers, over 150,000 New Yorkers. And as I was saying, part of our proactive education strategy, has always been to go in partnership with nonprofits to do trainings on fair chance housing laws, fair housing laws, disability protections, the areas where we see the highest number of claims. And I think increasingly, elephant in the room at this point is that there's a huge amount of mistrust in government. That's always been a challenge. Why do people want to take extra time from their lives where they've experienced something bad to go through a litigation process? That's a personal choice. And I think a lot of people don't want to commit to that action. So people experience discrimination and they move on with their lives. Some people want to come to us, and that's super important. And we are there for that. But we are also, to your question, trying to expand knowledge of both CCHR and anti-discrimination protections. People have a choice to go to court, come to us, or go to the state division. And we work with lots of agencies in the housing space, but also in the employment space, to ensure that people know what their rights are. And then obviously, there are power dynamics in employment and in housing and in public accommodations. And so intentionally over the past 4 years, we have been really trying to target, as I said, real estate brokers and housing providers. And when the Fair Chance Law went into effect in January, we were having individual conversations with member of co-op boards and their attorneys, because people want to understand what their obligations are under new laws. And so we are always more than elated to work with council to get the word out in your districts. And we are more and more doing intakes and outreach in community spaces to address the fact that there's just a huge level of fear and mistrust.
Are you folks... Sorry, go ahead.
I just wanted to add, we're often in front of this committee talking about our work in the rental space, and the demographics of people who are looking to buy homes in New York City are different. And I'll turn it over to my colleague in a moment just to talk a little bit about that. But these are folks who are generally already working with not only real estate brokers but attorneys, and they might see the financial piece of bringing their case to court differently or pursuing other avenues. And I think that's something that we've been thinking about a little bit in this space. And so with that, I'll turn it over to Neil.
Sure. So according to our data from the 2023 New York City Housing and Vacancy Survey, citywide, half of residents in co-op units are white, which is 19 percentage points higher than the citywide distribution of white New Yorkers. Yeah, so the citywide demographics, 31% of New Yorkers are white, 50% of residents in co-ops citywide are white.
And how does that, sorry, this is not my question, but if I may, Majority Leader, and you may have your time back. How does that compare with ownership outside of co-ops and condos?
Pause my time.
I don't have demographics for all homeowners handy, but we can certainly circle back on that front. I would also say that the income for co-op owners, household income, is at a median 122,000, I believe, which is around $50,000 higher than the citywide median.
Got it.
Corporate owners are not unique in terms of the income from that perspective. Homeowners generally, we do see higher income across the board.
Any other additional before I ask the question? Okay.
Thank
Thanks.
you.
Just wanted
Apologies
to
for
make
that.
sure. Is there an average time we have that New Yorkers or clients that you folks see at the commission must wait for a response on an application, or any data that shows us wait times?
So I think I wouldn't want to draw any conclusions from our very small data set on the timelines. I think it differs by cooperative, and the small number of cases doesn't illustrate a timeline.
Okay, so we wouldn't know, or we haven't inquired into any response times, wait times, ways clients are affected financially by some of the delays or the lack of response or unresponsiveness or effects to sellers at all. HPD isn't looking at that. Commission isn't looking at that.
So these are private market transactions, so the information isn't going to be shared in a representative fashion. The Attorney General's office does largely regulate in this space, the formation of co-ops, a lot of the processes. We don't have data to my colleague's point, on a broad enough scale that we'd be able to say. What we would speculate is there's probably very wide variation, both between types of co-ops, size, whether there's a property manager involved or not. So, I think that the anecdotal sort of small sample that we have might not be illustrative. What we can say is that delays in any part of the housing market are of a top concern. They certainly can be financially expensive for potential buyers. So we certainly, agree on that point.
And I'll just circling back to a point that we were talking about earlier that the chair was asking, clarifying question or follow-up question about the demographics of homeowners citywide. Citywide homeownership is 46% white, which is slightly less disproportionately white than in the co-op universe.
Got it. The only last comment I have, I suppose that may be supported with the question. Your responses, at least from what we've seen to me and both to the chair so far, it makes me feel like this package is necessary to make sure we start aggregating some level of data, or at least setting some level of expectation. Even just hearing like the AG's office is the one that will go into those matters. I mean, that's basically saying to us and to members of the public that our agencies are not talking to each other at the cities and state level to try to find other innovative ways to make life better, or make this processes better, or widen the gap, or lessen the gap rather, on some of these demographic data points that we have. And even with the outreach, I immediately think about Housing Connect and the amount of public-private interactions that happen, with purchases that happen. Are those coupled with information from you folks? Are we going to there's just like plenty of spaces where I think we could be doing more. 150,000 people out of 9 million New Yorkers is but a fraction. I understand not all of them are going into cooperative sales, etc. But we could always be better as local governance. There's plenty of folks that don't know who the mayor is, and they're still living in our city. So, it's important to think about it from that aspect.
We could always do more, and your feedback is really important. I did not mean to suggest sort of an absence of coordination or focus on that. That's always something that we strive for and can at times be difficult. The partnership between CCHR over the last couple of years, these teams sitting up here directly actually work quite closely together for the purposes that you're talking about. Same thing with the Attorney General's office, where there's actually an HPD alum, and we really work hard to identify the challenges here.
Yeah.
It doesn't mean that there's not more to do.
I just like in my district alone, the amount of vacant units that are available amongst the many cooperatives that I have not heard from either of the agencies over the 4 years that I have served on what could we be doing to get those vacancies filled by someone that can own that cooperative or someone that can go into it. And like that is really what I'm talking about here. Like there does not seem to be any interest in going out into community in any real effective way or reaching out to boards other than checking a box to make sure they're within compliance or they're non-discriminatory, when we have a real crisis here that we're trying to solve. And it's coupled with boards, you know, really needing support on how to properly manage within their legal system and their management companies to get either these vacancies filled or to make the repairs and renovations or build the coffers that are needed to make those repairs and renovations to fill those vacancies. It's a cycle that many folks are unable to get out of right now.
I think the piece I will just close with on that is that we are 100% excited to work with you and to fill these gaps. I think we are looking for ways to partner with other agencies and also with council members and number one with community groups who really are the trusted partners most often. I think there's some blueprints in the SOI work, right? We are not a voucher providing agency, but we are an anti-discrimination agency and we see a lot of source of income cases. So we have developed partnerships to be in shelters, to be training HRA rather, housing specialists in shelters so that people, if they experience discrimination, know where to turn and they're trained on their rights before the transaction happens. So I hear you and have been talking a lot with Chair Williams from our committee about how CCHR can have more permeable and stronger connections with city council members. So we look forward to working with you on that.
Thank you, folks. Thank you, Chair.
Thank you, Majority Leader. Councilmember Dinowitz.
Can I just start? I'm done. I understand. I know when I'm not one.
You have 5 seconds. Recognizing Councilmember Aviles.
Okay. Good morning. Good morning, everyone. I want to just confirm what I heard in the testimony. You said in the past 5 years, fewer than 10% of your complaints have been related to co-op sales. Is that what was testified?
Yeah, that was about housing, which is the smaller slice of our complaints. Yes, correct.
Okay. I'm sort of coming on from a perspective of like discrimination is already illegal, right?
Co-op discrimination is illegal, yes.
As it should be. And you investigate those claims anytime they're brought to you. You testified that sometimes they go to court or the state agency. Do you know on average how many, over the past 5 years, about how many co-op applications are submitted to co-ops?
I do not have that information, no.
And so you don't know how many are rejected?
No, we are an anti-discrimination agency who people come to us if they've experienced discrimination. We don't hold any housing data beyond what is in our complaint system.
Okay.
These are private market transactions. There is not an affirmative obligation under state law for these to be reported to any agency. What we can say is talk about the volume of co-ops that exist.
So in 2024, for example, there were just under 7,000 co-op sales.
So you do have information.
Citywide.
And then do you know how many?
On the sales, not on the
Not
number
applications.
of applications.
Okay.
Yeah.
I was actually a little surprised to hear you testify that you don't think, I'm speaking specifically about 407, that you don't think that would increase administrative burdens on board members. This is a bill that would, under penalty of perjury, that someone has to sign a statement that they have to write, like an essay detailing every single reason for rejection, under penalty of perjury, with penalties up to $25,000. They have to do it within 5 days. And if they make a mistake, if they forget something within those 5 days, they can't go back and edit that statement. That's all that they're able to use in court. Can you talk more about how something like that does not increase administrative burden on volunteer co-op board members?
Thank you for that question. I don't remember if the way the question was originally framed was as administrative burden versus, as an additional challenge. As my colleague testified, we are sometimes seeing on those limited number of cases that come in that reasons are already provided. I can't rule out that that's not a common best practice already happening when a rejection is provided. I'm not aware that it would require an essay, but certainly the more extensive the disclosure requirement, then sure, the burden would increase.
Right, and now you're talking about, in addition to that, legal fees, perhaps you're talking about increased insurance costs for co-ops to insulate themselves from liability, which they're already, it's already illegal. Like, they're already liable for discrimination, which shouldn't be done. You're now just adding, and then with this bill, it would be adding, again, legal fees, other risks that would increase administrative costs. And those costs, get passed on to the shareholder, right? It's a cooperative, they share in the costs. So now you're talking about a bill to potentially significantly increase costs for every co-op shareholder in New York City, for a problem that is already addressed, I believe, through testimony, through legal means. Discrimination is already illegal. And the other thing you're talking about, by the way, and we have a challenge of this in co-ops, like I joke, volunteering for my co-op board is too much, so I ran for city council. Like that, like the politics here are easier. You already have this problem with getting volunteers, people to do this. We end up in a lot of co-ops in my district having a lot of retired people, which is fantastic, but not necessarily representative of the entire makeup and demographic of the building, because who has time? Typically, people who are retired, and now you're adding additional time, and now you're adding risk to this. So, what do you think the impact to the co-op community would be in New York City, and how would that in fact affect shareholders' ability to manage their own buildings?
So I think actually that what I testified to was the fact that that what we need to do when we think about passing new requirements is weigh those requirements and the burden that it may provide against the potential policy outcomes and goals, and that neither HPD nor CCHR actually is well positioned to speak actually to the specifics of some of the details in the legislation, but that we were looking forward to hearing from folks today who would be testifying who could fill in some of those details. So I think actually the exchange may have been just a bit different.
Yeah. And then, I would imagine if I were on the co-op board, which I'm not, thankfully, thank goodness, that the risk is so high. If I do join the board, or the administrative burden is so high, I may farm out these tasks to a managing company or another company, thus increasing costs. Do you think it would make more sense to say, one, we haven't gotten a number of these complaints. Maybe there are some in court. Maybe there are a lot in court. We don't know. Maybe there are a lot in the state. And to Majority Leader Farias's point, maybe we as a city, need to be doing a better job of communicating with our partner agencies in the courts and the states. And wouldn't it be more prudent to just get more data, get better data, before we increase what would invariably increase the risk for individual board members and increase the costs for shareholders to get that data to ensure we're doing the work to work with other agencies? Would that make more sense? Mike.
So, Councilmember, we collectively are regularly here talking about where we live, the challenges of discrimination in New York City, the fact that we believe it is occurring, and to the extent to which that it is one of our 6 goals within where we live, rooting out discrimination in the private market. I think that we think it is a balance between evaluating administrative burden and ensuring that our laws can be successfully administered, and especially when you're talking about something as pernicious and nefarious as discrimination. So I would say the same thing I said before, which we believe this is an important balance, something that has to be considered deeply, and that's important. That my understanding is there are a lot of people here to testify today, and that I think there'll be more information shared on the details that could help assess that balance.
All right, I would just repeat. I think before we get into the stage of requiring volunteers to put themselves at risk for $25,000 under penalty of perjury and increase costs for shareholders, I think we need a better understanding of the data. And we as a city, as a government, need to be working better with our partner agencies in the courts and in the state to make sure we are rooting out discrimination, which is already illegal, using the legal means already available to us with better data, but without increasing costs and without increasing risks to our shareholders and our board members. And I want to thank the chair for the additional time. Thank you.
Thank you, Councilmember Dinowitz, and we'll certainly talk more in conference, but I just wanted to correct two quick things. You said 5 days for the response required in 5 days. It's 45, or it should be 45. And under penalty of perjury, it's not written to, the bill is not written to single out board members. It's written to single out the corporation after it's made its decision. So we'll talk more in conference, but the intent, I believe, and the sponsor is here, so we can turn to him next. But I believe the intent is to provide a reasonable timeline. Yeah, but thank you. Public advocate.
Thank you very much. Thank you. I'm very much looking forward to this conversation because I want to get to a real solution. One, finances, I think you mentioned someone was X'd out because somebody had an all-cash buyer. I mean, that finances has been a reason that we've seen some of this segregated housing, but that's not what we're trying to get at here today. We're trying to look at people who have the same kind of applications. And also, I just want to mention, I mean, there are laws that already exist, so I agree with my colleague. Sometimes those laws aren't as enforceable, and so we dealt with that when we were dealing with the abuses of stop, question, and frisk on the Bloomberg. Bias-based policing was already illegal. It just wasn't enforceable. So the bill that we made just made it enforceable. I think what we're trying to do here is make some of the things that exist more enforceable. And so first, I just wanted to understand, it just sounds like the entity that has the most information around this regulation is the AG. Is there any other city or state entities that have this information?
Well, the Attorney General's office regulates co-ops and plays a larger role. That's a state law mandate. HPD collects as much information as we can through the New York City Housing and Vacancy Survey, through our own processes. But because they are private market transactions, there aren't currently affirmative requirements on co-ops to disclose things like applications.
And for HRC, I know the number you cited, I think was 5 years. Just anecdotally, do you believe that there's more that people haven't filed with your agency for any number of reasons?
My educated guess is that there are more. I mean, we read the same news reports and statements from nonprofits who are identifying that discrimination is occurring. Just in the cases that we have seen, it has not been, as I said, the elongated timeline or failure to give a reason. That does not mean those things are not happening.
Okay. So just so I understand, does the admin believe that there are discriminatory practices that are happening, whether explicitly or implicitly, when it comes to co-op purchase?
I think the reporting that we've seen signals that it is a problem, and I think that's why we are here to talk about what are pathways to address this type of discrimination. And as my colleague from HPD was saying, what is the balance between what is required to be proffered up by multiple players? Again, there's the board, sometimes there's a management company, sometimes there's a real estate broker, and how do we best find what can be produced to show historic or current decision making, and then how does that translate into a regulatory framework that is helpful to applicants? And I think we've said this already, but just to underscore, we have lots of cases that come to us with lots of paper, and we have cases that come to us with word of mouth, and we can address both of those. I think what we are interested in hearing from you all and the people that will testify after the admin is, what are the things they're experiencing and seeing, and does a statement at the time you are rejected address that? is there some other pathway, as you've identified? We only change things by changing them, right? So what are the tools in the toolbox that maybe find the balance between what we're hearing in terms of the co-op boards, but also our fundamental mandate is addressing discrimination, and so that will always be what we are trying to address.
The bill I have is for 10 units and up. Do you believe that there may be a reason to include 10 units and below?
Yeah, so again, this is not really getting to Councilman Dinowitz's questions about the administrative burden. From the anti-discrimination agency perspective, people understand their rights and obligations more clearly when there are less carve-outs. So we have seen in the source of income space, there used to be 6 units or more were exempt. That was changed to be where there's 2 units or less, which is what the human rights law says for most of the anti-discrimination protections. So that's from an education and outreach perspective. That is not about the administrative burdens, which is what we want to hear from the co-op boards. I don't live in a co-op. I'm not part of a co-op board. And folks in this room and who are testifying are going to have more insight into that. But HPD, anything to add?
We do frequently see carve-outs of different smaller building sizes for various requirements. It is always a tricky balance. There are absolutely economies of scale for larger buildings. Larger buildings are more likely, though not exclusively, to have already have a management company, but we have no reason to believe that the behavior of a co-op board is meaningfully different based on the size. So that is something that as my colleague said, I think more insight from other folks involved might be helpful in sort of weighing that balance.
Madam Chair, I have 2 more questions, Ms.
Please.
Thank you. Also, to my colleague's point, there is, I can see some burdens, and so we're trying to figure out how we lessen those burdens. And so my question is less about kind of, I don't want, in 5 days, I can easily say it shouldn't be 5 days for my bill. I'm trying to figure out, are there tweaks that you can see that will make it, based on the information that you have, less burdensome, like not 5 days, probably not 2 years? So is there, I'm trying to find what the tweaks are that we can make so that the information we're trying to get is, I won't say won't add any burden at all, but won't be as burdensome as people are receiving them right now.
Yeah, thank you for that question. And we talked about this coming into today's hearing and agree with sort of that balance. Like there is a burden that is acceptable to add when we're talking about something as serious as rooting out discrimination, and how do we sort of assess that? I don't think that we have been able ourselves to identify that there's an exact right time period, but as we said, do expect that there are other folks, here testifying, or other people who might be more involved in these private market transactions who might be able to give more specifics. But I think on your general points, we do agree that that's the balance we're trying to weigh.
Yeah, I think adding 1 or 2 sentences of why someone is not discriminated in a reasonable amount of time should not add the type of burden that people are concerned about, at least for my bill. So I haven't looked at other bills. And my last question was, does HRC have the resources needed to really go after these type of discriminatory issues across housing in general?
Yeah, so I think this is where kind of the rubber hits the road a little bit with these bills and why there's multiple agencies testifying. 100%, we have the resources and the will to address discrimination in housing. We have been staffing up under this commissioner. We have an incoming administration who is committed to greater funding for CCHR, and we look forward to those conversations and what that might mean for our agency. I think where CCHR is potentially not as well positioned, as I already discussed, was to the extent we're looking at co-op bylaws and evaluating, are these the right provisions of co-op bylaws? Do these make sense? If we're looking at the finances, those are not things that our anti-discrimination investigators and attorneys are prepared to do. But in terms of rooting out the problem generally and the discrimination piece, 100%. And I think I just wanted...
Just to be clear, so you think you have all the resources you need today?
I think we are taking huge advantage of our resources and can always do more with more. And, we're already hearing ideas for ways that this can better be addressed by the city. And some of that is outside of the traditional ways we've worked. And so we'd have to explore what that looks like. But we are and have been staffing up in order to meet the myriad challenges of this moment.
Well, thank you. I'm super excited about the incoming administration.
And I wanted to just say one solution-oriented thing, maybe, based on the conversation that we have been having about these bills and what they entail. I think there is, a benefit to record keeping of decision making. I think the question is, what is the burden of telling every applicant the myriad reasons that something happened and what the historical denials and applications were versus a more centralized record keeping requirement? Boards should already have their meeting minutes. So if those things are available and there's, speaking on the discrimination piece, a potential investigation can lead to sharing of those documents, that's something that could potentially alleviate some of the burden of individualized communication for every applicant while still getting at some of the big picture concerns.
Thank you. Thank you, Madam Chair.
Thank you, Public Advocate. I want to correct the record that my colleague was correct, that the bill as written does require a written response within 5 business days. And my confusion is that other municipalities require it within 45 to 60 days. So that's my neighbor. All right, Councilmember Ressler.
Thank you, Chair Sanchez. I know that you are walking distance from Councilmember Denowitz's district, so you guys are thick as thieves. I really appreciate the questions from my colleagues this morning and the presence of you all here today. I just would like to go back to understand the data a little bit better on the complaints that you all do receive. And I know the chair mentioned this briefly, but you said employment's the #1 issue. How many housing-related discrimination complaints do you all get on an annual basis? Could you give us the last year or two?
So last year, it's in the housing space, upwards of 300 formal complaints. But there's also pre-complaint interventions, which are primarily in the housing space, and that's another approximately 300 per year.
Okay, so about 600 related potential housing discrimination issues. And can you break down for us between rental market, co-ops and condos, vouchers? Give us a little bit of context.
I can do that. We actually don't track the data in our system by the type of housing, but as I was saying earlier, the number 1 and 2 types of discrimination we see in housing are disability and SOI. Some years it's slightly more SOI, and some years it's slightly more disability discrimination. But
could you put numbers on the SOI?
Yes,
and
I just.
Yeah, I don't know.
Yes, I'm going to look.
I appreciate
that up
it.
For you.
I know.
It's in our annual report.
She's going to tell me. I
Look,
don't have the annual report,
I know.
but I
We're
did
gonna
look up
send
on the
it to you
MMR,
all.
and I didn't see anything useful. So,
what?
there was
That sounds
nothing
that
useful
sounds
in the
not-
MMR. Just to be clear.
Oh, okay. MMR. Okay, so claims, that's inquiries. We get many, many more inquiries than we have claims, just in case you're wondering about that. Total claims in housing, yes. So disability, last year, claims filed, 46 related to disability, 65 related to source of income. So those can break down to be rental units or co-ops. I don't have the breakdown by those two right now.
I don't think source of income discrimination is going to be for co-ops.
No, it is because they also rent. There are
Co-ops that are rentals.
Yes, not in sales, but breaking down within co-ops, that we actually see more cases related to rentals than we do regarding sales. And then the other numbers, retaliation is one that's worth noting.
Beyond no information that breaks down housing typology, like co-ops and condos, ownership, purchasers versus rentals.
So I don't.
Do you have any data at all that could give us indication of how many people filed complaints last year or pre-complaint engaged in a pre-complaint process relating to co-ops and condos?
Relating to co-ops, it's about 10% of the total universe of housing cases.
So 60-ish annually is what you're anticipating?
That's the number historically. But so yes, that's
30 to 60, somewhere in that range.
Yeah.
I'm not sure if it's for the actual complaints or the
and then a much smaller number. It's like 3 to 8 per year are about sales. So
3 to 8 per year about
Yeah.
sales. So look, the reality here is when we have very little data, which it sounds like we do, at least from CCHR, we could probably do a broader analysis of what's filed with the courts, and we could get the AG's office in here to share their insights as well. But at least on CCHR, when we see very little data, we could all look at this and see different explanations. I think that one of my colleagues would probably say that there isn't discrimination happening, and that therefore we don't need to do anything else. I feel differently, and to me, it's the opacity of the process where the applicant doesn't have any indication for why they've been rejected, and so they don't know if they don't have any information to take a case forward to CCHR or in court because they don't have any information at all. Do you think that's the primary, just providing your expertise? I realize that you're speculating, but do you think that that's the primary driver for why we see so few complaints in this area?
I really think it's like there's a more complicated landscape for cases in this area. So I think generally it's a burden to file discrimination claims. So I think that is something we cannot discount. Lots of people experience 10 to 15 examples of ghosting in the source of income situation before they come to us, because at a certain point there's a breaking point, right? So there's people who do not want to report discrimination. They want to get housing and they want to move on. So that is one piece. Oh, now I'm being dinged. There is one piece. I do think that, and I said for the very small number of cases we have seen reasons proffered. So I don't know that providing a reason is going to address what we believe is, in some instances, discrimination. The reason is often tied to finances, right? So as I said, we've had examples where a subsequent applicant gives an all-cash offer based on what the co-op is looking for. That is the reason that is given. Investigating whether that is the true reason is the next step of investigation. But no one, if you came to CCHR and you said, I lost out on this co-op and I believe it's because of my protected category, that's a case we can look into based on your word. So we don't need the documents. That's not to say documents cannot be helpful in an investigation. They're not necessary, and they don't necessarily improve the investigation because it's all about what is written down.
If I was experiencing discrimination in application process, but had no information to back up, if I didn't have data or proof based on the opacity of the process from the co-op board, what had occurred, what would I be going to you with? Like, what would I be bringing forward to say if I don't have some explanation from the co-op for why they've rejected us and our application? I mean, I think anyone who's been through a co-op application process knows it is exceedingly painful. It can take weeks, it can take months, it can take years. It's, every co-op is different. Some co-ops are exceptionally well run. Many are not. And sometimes, it can be painstaking and confusing and confounding to go through that process. I don't know if you've been through it, and I apologize if you have. But I say that as a co-op member, as a resident of a co-op, and who have wonderful neighbors. I'm just being a jerk. So you go through this opaque process, you get no information. How would you go to CCHR or to court if you've got nothing to show for why you've been rejected with your application?
I'm not defending any position. That is the majority of cases of discrimination. In employment, we interviewed you, we're going with another candidate. Like, a lot of times there is no reason given and there's not documentation. That doesn't mean discrimination doesn't occur. And I think what I was saying to Public Advocate Williams is I do think there is a role that record keeping can play in identifying, in particular, are there patterns? What's been going on here? Have these standards been applied equally to people in the past year, 5 year, 10 years, whatever the right time frame is? And there's board turnover and all types of things, finances change, that might influence why decisions are different for each candidate. I think there's like a systems thinking that could address some of the discrimination that is experienced at the individual level. But I think, again, just trying to identify documents alone and writing down the reasons you rejected someone does not mean discrimination is not occurring. And I think I don't want to like set up the premise that if people are writing something down and providing it to you, that means discrimination is not occurring, because then we put ourselves out of business, which would be awesome.
I don't mean to imply as much. I mean to say that when you have real data and information on why a decision was made, you can say this has merit or this does not have merit, and I'm going to pursue action accordingly. When I have no information, it's a lot harder to know how to proceed. So look, I've gone over, and the chair has been very gracious, and I really appreciate it. I'll just say this in conclusion. Making a decision for a co-op board of when to accept an applicant is a momentous decision. If that person who's buying into your co-op, if they fail to contribute the monthly maintenance, if they fail to be a good neighbor, if they fail to take responsibility for their unit, it causes enormous hardship for everybody else. And so these are painstaking and meticulous decisions that a co-op board has to make to the best of their ability as volunteers. And we need to make sure that those decisions are being made on the merits. And we're fortunate that, Chair Sanchez and Public Advocate Williams, who formerly chaired this very committee, are two of the more thoughtful legislators in the City Council and in whatever ex officio role you have. And I know want to identify legislative solutions that work for everybody here and are trying to be thoughtful about how to make this work. But the status quo, to me, is unacceptable. And so we need to do more to ensure that there's accountability and that we're proactively preventing discrimination as much as we realistically can, while working through operational processes that are fair and reasonable for the parties involved. So with that, I will thank you for the extra time.
Thank you, Councilmember Ressler. Just a quick clarifying question, and then I want to, or follow-up question, and want to turn it over to Councilmember Aviles. You mentioned 10 to 15 instances of ghosting before they have a typical complainant brings a case to HCR. I just want to, from your perspective, given some of what we've covered today, do you believe that because CCHR receives few co-op and condo sale discrimination purchase complaints, that discrimination is rare in light of that other statistic that you shared?
So that was specifically talking about source of income in the rental market, and it was an illustrative example. It's not the kind of status quo or the typical case. It was just meant to illustrate that there is a tipping point for most people when deciding whether or not they want to pursue an action on discrimination. We definitely have people who are turned away once for a voucher and come to us, and we work very hard with Unlock NYC and other nonprofits to document and address that. So I think our data does not illustrate necessarily the landscape of everything that is happening. It demonstrates who is willing to come forward to report discrimination.
Thank you. Councilmember Aviles?
Yes. Thank you so much. Apologies if this was asked earlier, but under the guise of, I really hear your point that systems are needed across probably multiple agencies to begin to earnestly address this this problem that we're seeing. Could you tell me, for your agency in particular, what kind of funds would you need and staffing in order to begin to address what we hear and see from many people? I have also been in the other side of the table filling out these onerous applications. What would you need to begin to address this problem from your perspective?
So I will say that I think we've started to address this problem from the perch of CCHR. And I was saying earlier, Councilwoman Aviles, just about the focus that we have put on education, outreach, and training, in particular, people in the real estate space, not talking about co-op boards, but really brokers who are working with many housing providers. So we do hundreds of trainings of housing protections every year, and that's an area where we have worked with council and really want to deepen partnerships. We already work with many community groups to do that. I think based on these particular bills, CCHR is in a good position to handle complaints of discrimination. If we are looking at the entire set of things that are required in some of these bills, which are, did you comply with timelines? Did you produce proper financial statements? Did what you were asking comply with your co-op bylaws? That's a different portfolio than what currently exists at our agency, which is largely in the Law Enforcement Bureau, civil rights attorneys who are doing investigations of discrimination and don't have the kind of regulatory expertise or framework for understanding co-op. So that would be something that would require building out what CCHR can do, and that's not to say there aren't other folks in the city who have similar expertise. And I think there is the opportunity for information sharing, but it's, it's finding the places where there's willingness to cooperate, and then really some of it is time. So I think that's what I'll say about HPD. I don't know if you have anything else to add on that. Yeah,
just
go
to
ahead.
make sure I'm
Sorry.
hearing you. So you feel currently that you have the resources that you need in the current context. If these bills were to pass, you're saying then you need to build out a part of the agency to be able to adequately address the requirements in the legislation.
So I will slightly adjust my answer to say that I think we do have the resources to address discrimination. I think we have said countless times, this is our first time, or my first time before this committee, with the Committee on Civil and Human Rights, we can do more with more. That is not a decision that we are part of making. But as I also alluded to, the incoming administration has made commitments to fully fund not just CCHR, but a number of agencies working in the anti-discrimination, worker justice, housing justice spaces. And so that provides an opportunity for us to talk about what are we doing in this space, but really in the broader framework of discrimination. We've already started to adjust our intakes to be in communities in light of things that are happening at the national level, and to make sure that people can still come to us. And we are constantly adjusting and refining our enforcement practices. We actually earlier this year have reconstituted leadership roles in our law enforcement bureau so that we can better meet the needs of New Yorkers. And as a result, our pre-complaint interventions are growing, and we've taken the time down to resolve those to 25 days from a much higher number several years ago. So we are constantly evolving and using our resources to do the most we can to tackle discrimination.
Councilmember, I'll add, there's a little discussion about this earlier, but we can't say for sure what predict the future and how people would respond to changes in legislation, but there is reason to believe that many of the folks in the co-op buying space utilize some of the other channels for enforcing their rights, including through the courts, and that our understanding of these bills is that this also provides or would bolster that path, and that it's not just about sort of running through one of the agencies. I also, there's been some discussion about the Attorney General's role, and these are serious obligations and requirements that the Attorney General's office already puts on co-op board members. So there are, they regulate the annual meetings, the taking of notes, the keeping of budgets, the potential requirement for an election inspector, the ability of shareholders to examine or review minutes of shareholder meetings, records of shareholders, and annual balance sheet, profit and loss statements, removal of a director for cause or not for cause. There's annual requirements. So that it is a very regulated space in which co-op board members have serious obligations here, and I wanted to make sure that that was added.
Yeah, thank you for that. Clearly, there's a lot of regulation. What is not clear is if there's actual oversight and accountability with those regulations and who is engaging in that. So thank you.
Thank you, Councilmember Aviles. Moving to shared housing for a beat, and then we're going to wrap unless colleagues have other questions. Yep. We'll go to public testimony afterwards. So regarding Intro 1475, do you know, or do we know what percentage of New York's occupied dwelling units, apartments, are shared by multiple families or households, whether these leases are shared or a primary tenant sublets to another?
Yeah, so landlords are not required to report lease information to HPD, so we don't have granular data about the makeup of individual households, but we can look at survey data to give some approximation of this number. According to the 2023 HVS, nearly 250,000 occupied housing units in New York City include a household with at least one non-family member, and that does not include non-married partnerships. So that is some approximation of the number of these. And roommates have always existed in New York, and some unrelated New Yorkers will continue to have roommates. Families are diverse in New York City, but we do know that some roommates live together out of economic necessity, not choice.
Great, thank you. Can you repeat that number again?
250,000 occupied housing units include a household with at least one non-family member, and that's 7% of all occupied units.
Thank you. Voicing some of the concerns from my colleagues and myself included, I would say that in some parts of the city, you wouldn't know that SROs are not legal, that shared housing is not legal. In my district, you can walk around Fordham Road and find se rentan cuartos anywhere. You can rent a bedroom anywhere. So can you help us and council members that have this situation like I do? Can you help us understand what this legislation does for us, particularly how can we make New Yorkers that do live in SROs now that might not be legal? How can this legislation help them to be safer?
Yeah, thank you for that question. I think we agree that that currently shared housing is pervasive in New York City and a growing sector of our housing, but quasi-legal. We see different forms of shared housing that have different types of tenures, different costs. In terms of what this legislation does for existing illegal SROs or quasi-legal co-living, this does not provide a pathway for legalization of any existing shared housing in New York City today. This does not allow the conversion of existing residential units to shared housing. What we see right now is landlords that are renting individual rooms in existing housing, which is taking housing offline that could be available for families. What this legislation does is allow for the creation of purpose-built shared housing, either new construction or adaptive reuse of non-residential buildings like vacant office buildings. Those could be built out as new shared housing residences with modernized code standards.
Thank you. That is very helpful to understand. And so what is the pathway? Should these units be reported by New Yorkers through 311, or how should council members deal with existing SROs, especially those that present unsafe conditions? Existing illegal SROs.
Yeah, I think if there are hazardous conditions in housing, we encourage New Yorkers to call 311 and report that to HPD. We can investigate safety issues and issue violations or vacate that unit if there are immediately hazardous conditions. I think that one of the challenges that we face today with a ban on shared housing types is that there's clearly a demand for this type of housing, which is pushing both tenants and landlords to seek out these arrangements. But there is not a pathway to build this in a safe way. And we see renting of individual rooms and apartments with locks on the doors, and sometimes those locks are access to bedrooms that have a fire escape. And so when we find those situations right now, we don't have a lot of recourse other than potentially vacating that unit, which can leave New Yorkers at risk of homelessness.
Yeah. Thank you. Yeah, and that's the internal locks issue is one that we discussed at length last week, 2 weeks ago. Annually, how many eviction cases are brought against occupants who are subleasing from a primary tenant today? Do we know that?
I think we do not know that. Evictions data is maintained by the New York State Office of Court Administration. We don't have access to that data, and it's also unlikely that OCA would have that level of granular detail about the makeup of households in eviction proceedings. From our conversations with operators of co-living and residents of co-living, if one tenant in a shared living situation fails to pay rent or violates the lease terms, the landlord's only recourse can be to evict all of the tenants in that housing unit. Additionally, tenants that are named on a lease, if you have a roommate share and you have 3 tenants that are named on that lease, they cannot be treated as separate entities in a housing court situation. And in the case of subletters, the primary tenant it's ultimately responsible and accountable for the action or inaction of subletters. If their subletter fails to pay their rent, they're unable to pay the rent to the landlord, that landlord may be forced to evict that entire household if it comes to that.
Thank you. But primary tenants with subletters do have standing in court,
That's
right?
correct.
To evict a subletter. And so you're saying that there is no information that HPD has about how often this happens?
So it's less a data quality issue and more of like a legal structure issue because of, as Michael is testifying, there can be lack of legal relationships. So even if it does end up in court, you're not going to know what actually the cause was of that collection of roommates' inability to pay the rent, and that it was one roommate. That can be not always even clear from a court record.
Got it. Thank you. If a tenant is on a shared lease currently and their roommate has engaged in hostile behavior, what remedies are available to that tenant to rectify their living situation? And how would this procedure change if, rather than sharing a lease, both tenants were renting shared housing units from a landlord directly?
Yeah, that's a great question. So right now, I mean, if there are interpersonal conflicts in a housing unit, whether those are roommate shares, whether those are individual tenants that are leasing each their individual room from a landlord, those interpersonal contact issues, typically would go first to the NYPD to resolve if there's safety or health issues that are happening in between, or any sort of threats of violence between tenants in a housing unit. The next step of then removing a tenant from that housing unit can be quite challenging, especially if each of those tenants are on a sublease from the primary landlord. Sometimes the co-living operator is themselves leasing the housing unit from a landlord and then subleasing each to individual tenants, and that can be a case where it can be very difficult to remove an individual tenant without removing all of the tenants of that apartment. In a new purpose-built shared housing, each individual tenant would have a lease with the landlord and their own independent relationship with the operator of that property. Likely, and what we see as best practices in this space is that there's also a lease rider that lays out community guidelines, which also allows for removal of tenants if they do not meet those community guidelines. So there's an extra level of safety, one through that lease rider, through those independent relationships, where the operator has much more control over removing problematic tenants if those issues arise.
Got it. Thank you. And one last question from me, and I'll turn it over to Councilmember Ressler. So you've testified that this piece of legislation does not create a pathway for conversion of any existing shared housing. But I'm thinking about our conversations and discussions in the basement space and legalization of basements and why it's important that people live there, right? People live there today. They will continue to do so. Is it the agency's position that there shouldn't be a pathway to conversion, or is this something that you would entertain as the agency is interested in entertaining in the future? A pathway to conversion?
We would be happy to work with the council to look into the opportunity to allow for the conversion of existing units to shared housing units. It's a much more challenging situation because you have, just like in the basement space, existing room layouts that might make safe conversions more difficult, like I mentioned earlier with a fire escape that is accessed through one of the bedrooms. So what we're trying to do today is lay out kind of the best-in-class baseline standards for what we think safe shared housing models look like in terms of fire safety, in terms of management practices, and ratios of bathrooms and kitchens to rooming units. So that's what we're doing today. This is what we think is the baseline standard for what we want to evaluate, and then we'd be happy to follow up with future legislation to consider allowing for legalization of existing shared housing, and we would want to do that in a way that doesn't encourage landlords to take existing family housing units offline.
Thank you. Appreciate that response. Councilmember Ressler, followed by Councilmember Dinowitz.
Thank you so much, Associate Commissioner. Just a couple questions. My understanding was there had been city restrictions dating back to the Koch era on new SRO construction that through changes in City of Yes and this legislation we would help to lift, but that there were also restrictions in the state multiple dwelling law. And could you just speak to what are the kind of impediments in state law that make it challenging for us to convert or build new SROs or shared housing, if that's the terminology of the day, here in New York City?
Yeah, that's a great question. So I mean, there's obviously zoning, the city's housing and building codes, fire code, and then also the state multiple dwelling law, all which in some way regulate the construction or operations of shared housing. There were barriers. There was inconsistent definitions in zoning for rooming units, and other barriers like parking requirements that were removed through City of Yes. So that's already been taken care of today through the passage of City of Yes. This legislation addresses what is today in the Housing Maintenance Code essentially a ban on the creation of new SROs.
I thought that there was an exception if it was nonprofit owned.
That's
and
right.
operated.
So when I say essentially ban, it's not a complete
Okay,
ban.
thank you.
There isn't right now in the Housing Maintenance Code.
Right.
There are very limited circumstances where you can build new SROs, and that's really effectively for nonprofit management.
Right.
The state multiple dwelling law, section 248 of the state multiple dwelling law, regulates single room occupancy. There are some things that have made the construction of new SROs challenging that are contained in those requirements, like the requirement for a live-in super. What we're proposing today is to create a new local housing category in the building code, housing code, and fire code for shared housing rooming units that meet all of the requirements of the state multiple dwelling law with at least as restrictive requirements. And so we're proposing a new style with its own management requirements that are as restrictive as what is required in section 248 of the multiple dwelling law. So we believe that you can construct these units and comply with the existing state multiple dwelling law for SROs.
Okay. And then one last question for me. The Deputy Mayor, then Deputy Mayor Glenn and her team, I think, did a pretty extensive analysis on the financing of new SRO construction. And, within the limitations of the time that they had to be nonprofit managed or nonprofit controlled. And my recollection of their findings, which I don't know if were made public, but when I was working with them, was that essentially the operating costs for cleaning and maintaining shared spaces made the cost as much or even more than just building out studio apartments for individuals who were in need of housing. And in addition to that, one of the challenges we've identified in my experience at the Department of Homeless Services with move-outs of people who are homeless is that there's been a resistance to moving into SRO housing and a strong preference to having a studio apartment space of their own. And so just wondering if you could speak to those two items. One, from a financing standpoint, do you think that this is actually more cost effective than building out studios? Secondly, do you feel like we're seeing good data to show that we can effectively effectuate DHS move-outs? Because I think that's one of the, not the exclusive, but it's one of the populations we're trying to serve by expanding shared housing models, that will be able to successfully effectuate those move-outs to help drive down our shelter census and the homeless population in the city.
Yeah, I think those are both great questions. Might take them in reverse order if that's all right.
Sure.
I think just from our perspective, and we touch on this in the shared housing roadmap, shared housing is, we think, an important choice that folks should have. We do see in the market today demand for shared housing units. We surveyed the top 4 operators of shared housing in New York who operate over 125 buildings, even with effectively a ban on them today, which does speak to significant demand for this housing. We have heard pretty clearly from operators of supportive housing and operators of shelter that shelter move-outs are very difficult and that folks that are coming out of shelter are not particularly interested in moving into living arrangements that have shared bathrooms and kitchens. So from HPD's perspective, we don't think that this is a great opportunity for shared housing, except in circumstances where there's a specific population that might benefit from communal living, like our Alley Forney Ascendant Living Project, which is for formerly homeless youth with a focus on LGBTQ youth. So that's a population that we think might benefit from the type of community that this can provide. But overall, we don't see that this is like the way to go for moving folks out of shelter.
Okay.
We think that this is something that there's demand on the market from young professionals in particular that can be met, and that right now those young professionals are pooling their resources and taking up larger apartments that could be going to families. On the cost, We've looked extensively at costs. There was also a recent Furman Center report that also looked at costs, and CHPC reports that looked at costs. We do see higher operating costs compared to other housing. On the projects that we've worked through HPD, there's new costs like cleaning supplies that we're not currently underwriting for in our project, daily cleaning of common spaces. These are new costs that are added to the landlord. We think that these can be offset by reducing, compared to a building that's all studios, for example, there's fewer kitchens and bathrooms, which are big cost drivers in construction. And it's not going to balance out those two things in every single project. We do think that there are some projects where shared housing will be more cost efficient and other sites where it might be less cost efficient, and that's going to have to do with scale, the shape of the site, the type of site. We do think that for office conversions in particular, being able to cluster kitchens and bathrooms around existing plumbing networks could be a big benefit and help that balance.
Those are helpful and thoughtful answers. I appreciate it. I will say that the first apartment I moved into out of college was an illegal shared housing setup, and I met a number of very nice people who shared the bathroom and kitchen space with me, some of whom I remain in touch with to this day. I stayed there for a couple of years. It was a good apartment for me at 22, but it was definitely illegal.
And I had a very similar experience.
I love when we admit to doing illegal things here.
Molly can tell you how long ago that was.
Thank you, Councilmember Ressler. Councilmember Dinowitz.
You know, where I come from, those friends of yours, Lincoln, they're called accomplices for that illegal activity. It's fine. We used to have SROs, right? They were shut down like the 50s, 60s, 70s. Weren't viewed of very positively. It was viewed of as slums or like a lot of crime going on there. Can you talk about that era? What was going on in the SROs? Why they shut down? Very briefly, because I actually have real questions, but and how this would be different, how opening up SROs again legally would be different than in the 50s, 60s, 70s.
Yeah, so I won't give a history lesson on New York, but I think that you're familiar with what was also happening more broadly in New York during the 60s and 70s and what was happening to our housing stock generally and our economy during that time. And I think what we saw during that time was landlord abandonment. We saw high rates of poverty within SROs and lots of challenges with poor housing quality and with safety issues in those housing units that led to the ban. I think after imposing the ban, we also saw in the 1980s legislators desperately trying to keep the SROs that we had because they saw that as we lost SROs, we saw a very steep rise in street homelessness.
So like in this legislation, for example, or in HB now, are there any protections to prevent what happened then? Because it was happening disproportionately in the SROs, right? Like that was happening more there. Any protections in the legislation or in HPD policy now to prevent against what we were seeing 50, 60 years ago?
Yeah, so what we're proposing through this legislation is a much higher quality housing than we saw in the SROs that were built under that Section 248 of the multiple dwelling law that I mentioned before. So what we're proposing is reducing the number of kitchens and bathrooms that can be shared. So going from 6 rooming units to 1 kitchen and bathroom to 3 rooming units per kitchen and bathroom. So much lower ratios there and larger rooming units themselves. So we think that, one, the higher quality standards, in addition, higher fire safety standards than we had in previous versions of SROs. And then also HPD, as part of the legislation, requires HPD to promulgate rules about property management. And we think that those rules also can stipulate things around cleaning and management that will also help in that space.
And this is for-profit market rate development, and will HPD be creating term sheets for subsidized housing, subsidized SRO housing?
So yes, this will allow, as you said, market rate shared housing. On the HPD side, we don't intend to create new term sheets, but we're going to be working over the next year to take our existing term sheets and allow for a shared housing option under each of our existing term sheets, being careful not to create any new incentives to prioritize shared housing over other housing types, but we will allow for an option for affordable shared housing.
Well, that's actually leads to my next question, right? Which is, it's like a week ago, 2 weeks ago. I feel like I see you every day.
Like 9 days.
9 days ago, we were talking about my bill 1433 about more 2- and 3-bedroom apartments You're really making your term sheets reflective of the population. And one of the things that we see all throughout the city, whether you're a developer or an agency or an elected official, is touting the number of units that you are producing as opposed to touting the number of people you've housed. So what protections are there to prevent a market rate developer from saturating a particular neighborhood or community district or borough, well, not borough, but in this legislation, but in a particular community district with SROs to say, hey, look, I've created 1,000 units of housing instead of the 500 I would have gotten by bedrooms. And, in the same mindset, what is preventing HPD, which currently does incentivize unit production? What sort of protections are there against the same thing, saturating the subsidized housing market with SROs, with subsidized SROs?
I'll say a couple of things and might also invite my colleague to chime in here. I think we see right now today in our housing market, shared housing. It is something that there is a demand for. We see sort of quasi-legal co-living operators. We see illegal SROs, and we see hundreds of thousands of New Yorkers who are taking on roommates. So this is something that already exists today in our housing market, and what we're proposing is a version that has additional safety protections and is a higher quality than what we see today. So that's sort of our baseline from this in terms of
that's not my and I get it. I'm not opposing that, the existence of it and the desire for them to be safe. It's a question. It's a legitimate question. Is how is HPD plan to prevent either in the market rate housing or in the subsidized housing a saturation of SROs when the incentive is and has been the production of units?
So I'll start by saying yes, this was a discussion when we last spoke. I would say that HPD did not agree that we are only focused on the production of units. I understand that's your perspective here. From our perspective, this is absolutely something that we think about and are actively concerned about in our design. HPD, to Michael's point, has no intention of changing our term sheets in such a way that we are incentivizing this. And we actually know from our own prior experience that it's not right for everybody. And so we have no reason to think that we're going to, over-incentivize the production of this type of housing. We do think it can, to your point and one of your major concerns, help free up space in other types of housing, which could meet some of our collective goals. And in terms of the market, in addition to the fact that we are responding to something that's already happening and then, in some ways creates an obligation for us to really respond meaningfully, that this is not open to all parts of the housing market. We discussed with the chair that this actually is a limited slice at this moment. It is for housing that is only for housing that is currently zoned as multifamily, but is not currently residential. So there are real limits baked in, and then it's something that we should continue to collectively look at. But we do feel confident that we have designed this thoughtfully, and that our intention here is not to make this the primary response for people. But for those folks who this is the best option, we want it to be available, but most importantly, safe.
Okay, and I know my time's up. I would just say I would love to continue the conversation. Is she throwing the hammer at me? It is the hammer. A great periphery. That it does free up HPD to construct more 2- and 3-bedroom and to incentivize that production. So it's certainly aligned with that goal and the goal of legislation 1433. But also I'm interested in further discussions about how to protect any individual community from the saturation of any type of one type of housing. Because I do believe the incentives are there to just produce unit after unit and not always meet the needs of the local community. I want to thank the chair again for the extended time. Thank you for your testimony today.
Thank you.
Thank you. Thank you so much, Councilmember Dinowitz. And that concludes our council member questions for the administration. Thank you so much for your time today and your thoughtful responses. I will now open up the hearing for public testimony. I remind members of the public that this is a formal government proceeding and that decorum shall be observed at all times. As such, no threatening colleagues with the hammer. Do as I say, not as I do. I remind the witness table is reserved for people who wish to testify. No video recording or photography is allowed from the witness table. Further, members of the public may not present audio or video recordings as testimony, but may submit transcripts of such recordings to the Sergeant at Arms for inclusion in the hearing record. If you wish to speak at today's hearing, please fill out an appearance card with the Sergeant at Arms and wait to be recognized. When recognized, you will have 2 minutes to speak on today's hearing topic of co-op transparency and the associated legislation, intros number 407, 438, 1120, and 1475. If you have a written statement or additional written testimony you wish to submit for the record, please provide a copy of that testimony to the Sergeant at Arms. You may also email written testimony to testimony@council.nyc.gov within 72 hours of this hearing. Audio and video recordings will not be accepted. We are going to start with a remote panel first of one person. Craig Kurian from the Anti-Discrimination Center and the Civil Rights Coalition for Transparency and Accountability, as he has to run, and he worked with the public advocate on Intro 407. So we're going to call you up first, and then we're going to move to an in-person panel.
You may begin.
Thank you, Chair Sanchez. I thank the committee for inviting the Anti-Discrimination Center to share its views of the co-op legislation before you today. I apologize for not being present in person, but my wife had surgery yesterday and I need to be with her. I've been working on and off for 35 years to strengthen the city human rights law, including being a principal architect of the comprehensive 1991 revisions, the landmark 2005 Local Civil Rights Restoration Act, a host of 2016 upgrades to the city HRL, and consulting on numerous other bills. The civil rights bill before you today is Intro 407A, the co-op disclosure law. I have submitted online extensive written testimony that you should have available, a pending polling that shows overwhelming support for co-op disclosure among New Yorkers, including co-op owners who are not board members, a section-by-section analysis of the bill, and an article that sets out the consensus that discrimination is still a problem in the co-op context. In the short time available to me today, I just want to highlight a few points. For all the fear-mongering of the co-op industry, Intro 407A is a simple and straightforward civil rights enforcement bill. Providing reasons for rejection is no more than the most basic transparency. There are many candidates for most dishonest argument against the bill, but a strong contender, unfortunately parroted by a minority of members, is that legislation is not needed, quote, because housing discrimination is already illegal. For shame. The question isn't whether a law exists, but rather whether that law is effective. Because co-ops can't be tested uniquely, the efficacy of fair housing laws is already uniquely impaired. The co-op industry has not adopted secrecy about rejections, as the kids say, like by random. It's a deliberate, well thought through mechanism designed to prevent someone who's been turned down from a home from assessing whether the reasons were.
I'm sorry, Craig. Your time has expired, but I do have a couple of clarifying questions, if you will, and I think my colleague does as well. So you can, in the responses to your follow-up questions, also summarize anything that you wanted to add. But in the vein of claims that are made in opposition to Intro 407, you've mentioned discrimination is already illegal. One of the items that we are hearing a lot is that opponents of 407 say it calls for personal liability of board members. Can you tell us if that is your assessment or your intent in helping with the crafting of this legislation?
Yeah. Chair Sanchez, that's a perfect example. It's not like what my view is. It's just a false statement. So I have to break that down into two parts. Under existing discrimination law, what's on the books right now, individual board members are personally liable if they participated in the Discriminatory Act. Now, let's look at Section 904 of proposed Intro 407A. That is much more narrowly drawn. And again, this is in the text of the bill. Those who are subject to penalties for a violation of the disclosure law, there's only one entity, the cooperative corporation. It's simply a false claim that there is other disclosure violating liability that's available.
Thank you. There are also concerns that the city doesn't have authority to legislate in the area of co-ops. What's your response to that?
This is a claim that's made all the time. It is equally false. The State Court of Appeals, the state's highest court, has made clear that among the limitations on the so-called business judgment rule and co-op discretion is discrimination. It is not protected. The city has been given in co-ops and elsewhere under the human rights law specifically equal jurisdiction with the state, and there is no bar to the city acting in this way. I should also add that there are a number of other areas where a party is required to set out its position and be stuck with that position if afterwards a judicial proceeding is started. That happens with every challenge to a determination made in an administrative proceeding. It happens in the context of holdover proceedings initiated by a landlord. It happens to challenges to denials to ERISA claims and others. This is very simple. Co-ops have the ability to put their cards on the table. They know why they've just made their decision. They should be made to do so.
Thank you. That's helpful. And finally, why is there a sliding scale of fines for violating this law?
Because again, despite all the we're all going to die, the sky is falling rhetoric, there has been from the start in relationship to this legislation a good faith effort to recognize that co-ops do have differing levels of resources, and that there are a range of types of violations. And so that gives the fact finder, it's all capped, but there's a range so that a smaller co-op, a less resource co-op, a co-op whose violation isn't willful is fined much less than one that is well resourced and engages in more egregious conduct.
Thank you. Thank you, Craig. Public advocate?
Yes. Thank you so much for the work on this bill and in this space. I just want to clarify what you were saying, and I think what I was trying to make clear in some of my back and forth with the administration. But it seems like this bill will not create any new liabilities around these issues for co-op owners. What it does is better enforce the law as it stands, because right now, as was mentioned, discrimination is illegal, but we haven't been able to really enforce that because people don't know why they have been rejected and various other reasons. So can you just clarify that point? Is it that we're just making it more enforceable, or are we creating new liabilities where they didn't exist?
No, the liability for committing a discriminatory act is entirely the same. And I'll tell you, Mr. Public Advocate, and I should thank you for your efforts in pushing this bill forward. There's the discrimination liability remains the same, and co-ops, again, by the explicit text of the bill, section 909, retain the right to turn people down for any legal reason they currently have. This bill does not touch on or intrude on that at all. What has to happen is the co-ops have to come up with a truly specific reason, and that will help people who have been denied. In one way, it'll just help because there might be something, for example, about their credit record that they don't know about, but it helps people assess whether a reason adds up or whether it's more likely to be discriminatory. And it doesn't permit down the line, if a Fair Housing Act or a human rights law claim is made, for a discrimination defense lawyer to come up with different reasons well after the fact. So for those 35 years, I've only done pro-civil rights work in a variety of areas, litigation and not. And I can tell you, having cards put on the table and not having people be able to change their reason to come up with different excuses makes a tremendous difference. And just one quick last point. We've heard from time to time, just as co-ops are saying, this is terrible, it's so burdensome to have to say why we did what we just did. We'll be able to get around it. We'll just come up with a whole bunch of reasons. But for anyone who knows anti-discrimination law, the law is very clear that once you start putting forward reasons that are false or misleading or incomplete, a jury is able to conclude that you're lying to cover up discrimination. So I'd certainly encourage co-ops to give true reasons. We know not all of them will, but getting those cards on the table, that's the key thing.
Thank you. Thank you, Mr. Kurian. Councilmember Dinowitz?
Thank you. Thank you. So first, I do, and I didn't recognize in my question, I do want to recognize the public advocate Jumaane Williams, who I think over the years has proven himself to be a good listener, someone who's genuinely trying to address issues. In this case, in the case of the co-ops, as we keep talking about, discrimination is illegal. And there's no disagreement there. I don't think there's disagreement that it's bad. I think there's an assumption by some that the discrimination is widespread and rampant, and an assumption that any time someone is rejected from a co-op, it is because of discrimination. And the goal of this is to say where every single time someone is rejected, it's discrimination, and we are going to put more mechanisms in place to enforce that. Now, I will share one thing. If I'm paraphrasing it wrong, please just give me the shake, a little head shake. But I believe it was testified by the commission, she's given me both, by the Commission on Human Rights, that a co-op board, listing the reasons doesn't elucidate whether it's discrimination or not. The investigation still has to happen, and it doesn't provide any additional information.
That's false.
To them. Well, it's you can say it's false. I'm trying to paraphrase. Excuse me, I'm not done. I'm not done. Excuse me. Thank you so much. I'm just trying to paraphrase what was said earlier. If you're saying it's false of what she said, I think we should talk later about what was in the record, because that was sort of my recollection. But I do want to point at something else you said I'm confused about, that I do want you to answer, and then you can address the other thing that I mentioned, because I do want to hear about it. You had said it's shameful that anyone would say there's personal liability, which I just want to read to you what the bill says, and then you can tell me about what this text says. It says, so the statement required, this is a quote, the statement required by this section shall include a certification by an officer of the cooperative corporation, sworn or affirmed under penalties of perjury. Under penalties of perjury, that the statement is true, complete, and specific recitation of each and all the cooperative reasons each person who participated in the decision to withhold consent has stated that the certifying officer that such a person had no reason for withholding consent, but it's that phrase under penalties of perjury to the individual officer. So can you talk about how that doesn't implicate an individual officer, and then talk about what I heard, what the testimony was from the Commission on Human Rights? Thank you.
Thank you, Councilman. And I wasn't saying, I didn't hear the Commission's testimony, but what you say is consistent with things that the Commission has said in the past. So a better way of putting it is the Commission, unfortunately, doesn't appreciate the basics of what's involved in investigating a discrimination claim. The central aspect of investigating a discrimination claim is looking to see whether a pretextual false reason is given, because it's quite unusual for a defendant of any kind to come up and say, yes, we acted because we didn't like the race or religion or sexual orientation of a particular applicant. So
But isn't that, and respectfully, isn't that what an investigation would reveal? I think one of the examples was when they asked about the citizenship in one of the interviews. That was that was discrimination because of the investigation.
Actually, again, you may have heard the Commission say, we get what comes to us. The point is not that every time a co-op board turns somebody down, it's discrimination. The point is sometimes it's discrimination. And there are two things that are true here. Number one, co-ops are uniquely situated in the market. That is, only co-ops cannot be effectively tested by fair housing organizations for sales that the seller has agreed to and a prospective buyer wants to buy and a bank has given financing for, because you don't get to the co-op board until a contract is signed and a long application is filled out. So co-ops uniquely have insulation from one type of investigation. But the main point is investigations don't happen automatically. Someone has to go forward and decide to do that. And surveys have shown that the overwhelming percentage of people don't come forward. Over 90% of people who believe they've been discriminated don't come forward. And I think it's quite evident that secrecy makes it more difficult because you just don't have any idea. If, on the other hand, a co-op says to you, we've turned you down because you haven't been working at the same job for 3 years, then your broker will be able to say, perhaps, that's interesting. We just got somebody into that building who's only been at the current job for a year. It's being able to assess reasons that allows people to go forward in a serious way. Okay. And so that's those are 2 points. Then the last point is it is absolutely true that the officer has to make statements under penalty of perjury. It's theoretically possible that the state could try to go after that. There's no civil penalty that's involved here. And for the violation of this law, it is set forth in sections 804 and 805. And what it says is that it is the co-op, a co-op corporation that is determined to have failed to timely comply shall be liable, not anybody else.
I think Councilmember Denowitz has some follow-up questions that we'll communicate about offline regarding private right of action, and you want to just say them for the record? You're, yeah.
I don't like these new buttons. I like the new room though. And just the point I think the Commission on Human Rights made, which I think a good analog is, could be the job market, which I thought was very appropriate. But we will. I am interested in continuing this conversation offline, and I know there are a lot of people ready to testify today, so I don't want to take more time. But let's exchange information to continue this. Thank you.
I'd like to acknowledge we've been joined by Councilmember Brewer. And in 30 seconds or less, Mr. Korean, if you could share, of the requirements, this reasons requirement exists in Suffolk, Nassau, and Westchester. Can you tell us about how those co-ops comply with these laws? Are there checklists? Are there, form letters, or are folks putting out, like our co-op boards and board members putting out extensive descriptions for why there are declinations?
Yeah. Westchester, which I'm more familiar with, had to update its law because there wasn't sufficient compliance, but there have to be sufficient reasons. This bill is in fact more tailored to the New York market, and there are really, again, just two things that have to happen, and you need to ask yourself, why is the industry so afraid? You just have to say why you did.
Sorry, Craig. The specific question is how they're complying, or you said that there's non-compliance, but to the extent that folks are complying, how are they doing so? Is it short form, long form?
They're doing so by writing a letter to the person turned down.
So they're writing letters. Okay.
Yeah.
Excellent. If to the extent you have, or there are any public versions of this stuff, it would be helpful, I think, for the committee to consider. But thank you for sharing your time with us. I know this. All the best to your wife, and really appreciate your participation today.
Thank you very much. Appreciate it.
Thank you. Okay, I will now call the first in-person panel. Mary Ann Rothman of the Council of New York City Co-ops, or New York Co-ops, Will Kwan, Tanya Arias, Rebecca Poole, and John Curtis. Yep, and while that panel situates themselves, the following panel will consist of Mike Kelly of the New York State Association of Realtors, Zoila Alonso, same organization, Jessica Adke Elmazi, Yvette Clark Watkins of Long Island Board of Realtors, and Crystal Hawkins Siska of the Hudson Gateway Association of Realtors. For this panel, Marianne Rothman, Will Kwan, Tanya Arias, Rebecca Poole, and John Curtis. If you could just state your name, make sure that's part of your first line, and then go into your testimony. And whoever is ready can begin.
I'll start. Good morning, I think. I get a red light. It's working? Thank you. Thanks for this opportunity to testify in opposition to Intros 407, 438, and 1120. My name is Marianne Rothman, and I'm the Executive Director of the Council of New York Cooperatives and Condominiums, which is a membership organization which for 50 years has provided information, education, and advocacy to and for New York housing cooperatives and condominiums. Our membership includes more than 100,000 more than 170,000 individual units in co-ops and condos of every size and shape located throughout the city and beyond. When a house is sold, the seller leaves and the new homeowner has the privacy of and the responsibility for their own home. When a cooperative is sold, the seller does leave, but the remaining shareholders in the cooperative become the business partners, the neighbors, and the colleagues of the incoming homeowner. Protecting the safety and the financial health of the cooperative and its compliance with all applicable laws is the shared responsibility of all the cooperators, and specifically that of the co-op board. In very small buildings, literally everyone may have a daily role in maintaining the building. In larger co-ops, much of the actual work is delegated to management, employees, contractors, but the responsibility still remains with the board to oversee all projects. These board members are volunteers elected by their fellow shareholders. One major responsibility that the board cannot delegate is ensuring to the best of its ability that all incoming shareholders can carry their financial share of cooperative living and that they will follow the rules and be active participants in the co-op community. We urge this committee to oppose passage of Intros 407, 438, and 1120A that seek to control the admissions process in New York City cooperatives as an affordable form of homeownership.
Did you conclude?
Co-ops are an affordable form of homeownership in our very expensive city. Rejections are few, as we've just heard, with boards trying their best to accommodate prospective neighbors. Please read my full testimony and the testimony of all those here today in opposition to these bills and ensure that they do not advance.
Thank you. Thank you.
Thank you, Chair Sanchez and members of the committee for the opportunity to testify in opposition to Intro 407, 438, and 1120A. My name is Rebecca Poole, and I'm the Director of Membership for the Council of New York Cooperatives and Condominiums. For decades, co-ops have provided middle-class New Yorkers with the route to affordable homeownership. Lately, escalating costs due to compliance measures, risk subrogation, and increasing insurance premiums have eroded that affordability and added to the workload faced by volunteer board members. Advocates for Intro 407A state that co-ops will comply with the law if passed. They are correct. The very nature of a co-op, in which you share your home and financial security with your neighbors, requires compliance. The question before the council isn't whether co-ops will comply, but at what cost and for what benefit. One of the most important tools a board has to maintain the affordability, safety, and quality of life of its cooperative is a strong admissions policy. When shareholders do not make timely payments, break community rules, refuse to participate, or fail to follow municipal laws, all other shareholders must cover the cost, liability, and consequences. This is not a risk that is equivalent to that faced by a for-profit bank or a credit card company giving a loan. Boards must be able to act freely on potential risks they identify when evaluating purchase applications in accordance with existing laws. Intro 407 threatens these board members with the penalty of perjury, a criminal offense. It requires co-op boards to provide a detailed explanation behind the reasons for rejection, citing all negative sources, which may be references or include subjective conclusions based on the information provided. The personal and corporate risk this opens is clear. The legal costs and insurance repercussions are large and will be borne by New York City homeowners. CMYC urges each council member to protect the co-op homeowners and volunteer board members in their districts from unnecessary additional costs and liability. Thank you.
Thank you. Next.
Good morning, council members. Thank you. My name is John Curtis. I am a vice president of a board, 370 Riverside Drive at 100 West 109th Street. And as vice president of the board, I'm also a member of the finance committee. So I speak to the bill, I believe it's 1120A, that imposes strict time frames in terms of responding to an application. Let me begin by saying I'm unaware of the practice of not responding at all to an application. We are very, very conscious of the need to respond to an application and ultimately to render a decision. So the idea, if the idea is to require that a co-op ultimately make a decision and announce it to an applicant, I would be fully supportive of that. But these strict time requirements are unrealistic. It's difficult to be sure when an application is complete, given the complexity of the financial and other information that's required. You often need to go back and ask for additional submissions. That can take quite a while in terms of the additional submissions coming forward. And the idea that ultimately the penalty for missing such timing requirements would be an automatic approval of an applicant is totally unfair. So I urge you to consider very, very carefully this very strict timeline idea of an application, but ultimately a requirement that there be a response without going into the idea of all the reasons being stated, but there be a final response is absolutely fair. I do think that having listened to the CCHR representatives this morning, in terms of pursuing discrimination claims, it seems to me that that is the proper forum rather than individual litigation subject to perjury allegations against individual board members. And I do finally say that having tried to recruit other members to serve on the board, you should also take seriously that it is not easy, and I would submit that for your consideration. Thank you.
Thank you.
Thank you, Councilmember Sanchez and the committee for the chance to testify today. My name is Wo Kwan. I've been on the co-op board member for the past 28 consecutive years since 1997 at 139 East 33rd Street between Lexington and Park Avenue after I moved there in 1995. There are 193 apartments there, predominantly studios and one-bedroom apartments. And since the 2000s, there have been combinations of into 2 bedrooms and a few rare 3 bedrooms as people decided to have families there. I live with my wife and our 2 daughters who have only known this building as their home. I also live with my mom, 89-year-old mom, who shares a studio apartment with my mentally challenged older brother is next door. There's a diversity of culture, religious, economic, and ethnic backgrounds in our community. This diversity is united in that we all want an affordable place to live. Even in the space is tight, but we love New York City. Co-ops have been a long-term affordable, sustainable housing for New Yorkers, for those who have downsized when they get older and on more fixed income, such as my mom, or a starting point for somebody for homeownership, such as myself. I cannot understand why this council is so intent on targeting such an important class of homeowners in this city. We are a not-for-profit corporation that provides affordable housing for many. What metrics are you using to blanket coverage target all the residential class of the co-ops? I'm trying to distinguish between fact and fiction. Are you working with fictitious cases and I talk about the exceptions? Fact, in the 28 years I've been on the co-op board, I can count in one hand how many people we rejected. Of the 325 so, we have rejected 5. Fact, given our nature of the community, there have been a lack of volunteers. Why have we been on the board so long? Because nobody wants to volunteer at that time to serve the community. It's not a specific time that we spend. There's a lot of costs. Any decisions we make, we run through council. That adds to cost. Any documentation we need to have the property management involved, that gets cost. We're already burning with increased local laws and real estate taxes that are increasing our maintenance and assessments. So ultimately, think about this, that if the co-ops fail in the city,
you may conclude. Remember, I have to tell you that you can conclude. You may conclude.
Ultimately, if think about the decision, ultimately, if these co-ops fail, there'll be a tremendous impact to the overall financial health of New York City. Do the right thing. Get your facts straight and not base your decision on a fictitious use case or exceptions. Thank you for your time.
Thank you.
Am I ready? Hi, thank you very much, Chairman Sanchez and the committee for listening to our voices. I had prepared a statement, but I'm going to speak straight from the heart. I'm in a particularly interesting position because I have been board president of 2 different boards. I'm presently board president at 45 Tudor City Place. I'm also chairman of the President's Council of Tudor City boards, which we represent over 5,000 people in my district. but I have also been a real estate broker, associate real estate broker for 31 years in Manhattan. I have lived in co-ops every single year of my 45 years in New York City, and I have served in as many capacities as I can. I can tell you that as a board president, just like my colleague here next door, I can count on half of my hand how many rejections we have had, and the rejections have been solely and only on the basis of financial ability to meet the requirements of the corporation. We attempt to work with our applicants. In fact, we go back to them with questions. Can you improve this? In many cases, we even say, is there any way that you can give us escrow? If we were to approve these 3 measures, which I strongly oppose, you're really going to be tying the hands of the boards to be able to make nuances and treat these applicants on a case-by-case basis. Trust me when I tell you that in my building of 403 units, we probably speak, 100 languages. And I, as a Hispanic woman, has been able to get through several boards from the Upper East Side to the East Village to Midtown, and I have never felt discriminated against. It's a basic formula of can you meet the requirements or can you not? That's really what it is. Thank you.
Thank you, and plus points on time. Public Advocate Williams, followed by Councilmember Brewer.
Thank you so much, Madam Chair. Thank you all for testimony. I waited so I can make sure I'm listening to what you're saying. And I really want to, and we've spoken about for some of you for a number of years on this issue. I want to figure out what the actual concern is, because I've heard different ones. Now, the time frame one, I think, is the easiest one, because I can't speak for the majority leader. I don't know if she's here. I would bet money for her bill, if the time frame was the only issue, she'd be willing to work out a time frame that makes more sense. I can't speak for her, but that would be my guess. And for mine, I've already conceded that 5 days may not be the right number, so we should figure out what number kind of works best. So I want to get to the meat of the issue. So for 407, what keeps coming up is the perjury and liabilities. As I mentioned to Mr. Gurian, there are already liabilities. So is it that you believe this is adding more that doesn't exist? Or is it you're saying there's more opportunities for someone to avail themselves of what already exists because they're providing more information? Because from my point of view, I don't see it as adding. I think these liabilities already exist by virtue of the job. It's just that people have not been able to avail themselves of it because they can't say or they don't feel that they have the ability to say whether they were discriminated against. So you're already liable for this. So I don't think it's creating more. So can you just help me understand if you think it's creating something or it's just allowing more opportunities?
Well, it says it right there in the law, under the threat of perjury and the liability. And we already have, every single co-op has a law firm behind it. We're constantly checking in with our attorneys. And believe you me when I tell you that they do not cut us any slack.
So
they're very, very strict about how we proceed with all of the things that we decide on.
So my understanding is you probably can't perjure yourself now with this kind of the way the application process is. So this is what I'm saying. Like I think it's in the law, but you can't do it now. But I also want to ask: is the biggest concern the punishment for not doing it, or the fact that you have to do it anyway? The fact that we're saying
it's a combination of both,
okay,
because you're adding additional cost, time, and trouble for people who basically have full-time jobs.
So for my bill, I just want to understand what the time is. If you 407, if you've made a decision that this person should not, you're not accepting their bid, or however you want to phrase it, that's already decided. And so what is the extra time of providing that information to the prospective buyer and the applicant?
Tanya, may I
Go ahead.
Thanks. Thank you for the question. So the extra time is in writing the list of reasons based on the specific documents in which you are citing the reasons in such a way so as not to incriminate the board, not for discrimination purposes, but because there are other items where the board might reject, where it could then gender a lawsuit having nothing to do with discrimination. So any rejection notice based on Intro 407 would need to go before council and be thoroughly checked prior to being released, and it could open board members to liability. Currently, there is no threat of perjury. The law requires a individual board member to sign on behalf of everyone on the board, saying that these were the only reasons that were considered in making the decision. It is impossible, really, for one person to know what is in everyone else's minds, what they do. So that individual board member who's signing the certification under penalty of perjury is taking on individual criminal, potentially criminal problems, liability.
I'm assuming I don't have 2 hours and 14 minutes to answer the question.
No, please.
Okay. So the second perjury part, like, I'm willing to try to figure out. I mean, it has to be enforceable. So I want to figure out how we word that in a way that already is encapsulated with the liabilities you already have. So I'm not trying to add additional. I'm trying to make it enforceable. But I would assume you can't lie about certain things, and you have to be honest about what you're saying. But the first part does trouble me, because you should be having those conversations amongst yourself anyway. And so the decisions that you are making, you should already be discussing why, and it should not be for reasons of discrimination. So if we have those reasons, we should be able to provide them to someone.
If I may, sir, thank you. I think a fundamental issue is if, in fact, as your attorney emphasized in his testimony, it ultimately would be the liability of the corporation, then the statement should be made by the corporation and not by an individual member of the board, number one. Number two, rather than stating each and every reason, there ought to be a provision, in my view, that you state the primary reason, which 9 times out of 10 will be financial. We had an applicant once who said, I want to be a member of this co-op because then my rent will never be raised. And we said, well, do you really understand what living in a co-op amounts to? That you're going to have to pay the bills going forward, and yes, your rent's going to be raised, and a lot, and you may be assessed. So there may be applicants who just don't kind of understand what the deal is. And you may have to say to them, we don't think you're really prepared to be a member of this co-op. So, or there could be people who have had a history of being very, very difficult tenants in the past. WASPs who you don't want in your building because they're just difficult to live with. So, I mean, you should be able. I have sympathy with the idea that the board should be able to make an overall statement. We reject you for financial reasons. We don't believe you understand the obligations of living in a co-op. Some simple primary statement might be something that could be acceptable. But the idea that one individual signs for everybody as to every reason that everybody had is a very, very difficult thing to deal with.
Let me just give a closing, and you can say, because I know I'm out of time. So I'm going to take the feedback that you've said. If there's any other ideas, I think a version of this bill has to pass. So if there's any other ideas, I'd love to hear it. I do think the two things are there has to be a reason, and it has to be enforceable. So I'm going to look at what you just mentioned about the corporation and about the primary reasons, and try to see what we can tweak here and there. I think there are some people who just don't want to do it, and we have to really get something through. And I wish the majority was here to talk about her bill. I think the time frame issue is one that we can work out, assuming that the objection is just that we don't want to do it to begin with. Thank you.
Thank you. You may respond briefly, but we do have other questions from colleagues.
Really, really fast. Just so you know, I mentioned before that I had been a real estate broker for 31 years. In my 31 years as a real estate broker, and you can check me on this, I have had literally one case that was evident that it was discrimination. And I was able to turn that decision around in 20 minutes because I had all of my facts. But in the 31 years that I have been in real estate, I can tell you that a great responsibility of putting someone in front of a board lies on the broker that does that. And there is no reason for you to be putting someone in front of a board that you are clearly have not prepared or have not understood the financial position of that person. So there are several steps, and the other thing that I will tell you is that the industry will tell you that it's only 3 to 5% of rejections. And in my case, I have a 98.9% approval rating for all of my applications.
So I'm going to hire you as my realtor.
Yes.
But of interest. No. Well, maybe after this is no longer before us. Okay. Thank you. So I'm going to turn to Councilmember Dinowitz and then Councilmember Brewer.
Thank you. I have similar questions that I had for the administration and for the previous person testifying. Do you have any, I mean, you gave your number. Mr. Kwan, you gave 5, you said 5 out of 325. It's like a 1.5% rejection rate, more or less. Is there any data, aggregate data, to say how many applications there have been and how many rejections there have been? Do you collect that data, Ms. Rothman?
As an organization, we don't collect the data. However, I have lived in a 167-unit co-op for 56 years since it turned co-op. I served on the board 23 of those years.
I know the address on the apartment.
And participated in exactly 1 rejection in those 20 years of board service. We have, in a typical year, 5 to 8 apartments would turn over.
And do you think that sort of data would help us in this conversation, knowing what the rejection rate actually is, to see the numbers we're talking about?
We would love the data. What I have been hearing over the last 2 or 3 hours is that there is no data. It just seems to be a problem that has been magnified over very little data. I'm a mathematician by trade. I have a master's in economics.
Oh, I'm just a normal math nerd, but please.
Yeah, I'm a math nerd. And I like to see numbers. I like to see the data. I would like to, the industry will tell you, if you look, search through the industry, it's 3 to 5% that gets rejected. Mm-hmm. And 99%, and my colleagues can confirm, it's really financial. It's debt to income, leftover liquidity, your credit rating, and your work history, basically. I mean, my building is completely diverse. And it's all based on financials.
I'll answer it. So basically, the question is, we need to make sure that candidates are qualified. The rejection rate is the financial requirements. We changed our requirement from 20% to 25% down, and we weather the financial crisis. Okay, we basically make sure that, because if you don't pay your maintenance, guess what? In the co-op, we have to work on a balanced budget because our mortgage company requires us to operate on a balanced budget. So everything that has to be covered, so the entire community picks up for any arrears. So we need to make sure you're financially doing.
I have 2.5 minutes left, so I don't mean to cut you off, but you know, it sounds like, based on what I hear, we're all in agreement that this is data that should be available. That maybe the co-ops should be sharing this with everyone so we can begin to have these conversations. And ask ourselves, like, is this a widespread problem, or are we addressing real, discrimination, which is a big problem, but are they an individual, or are they systemic? I mean, these are questions we can answer with data. My second question relates to the administrative costs and burdens. Have any of your law firms that you contract or your managing companies provided you an estimate to how much your costs would increase or your insurance costs would increase as a result of legislation like this?
Not yet.
Have they indicated to you in any way, shape, or form that costs would go up?
I think in general, insurance costs are going up.
Yeah.
So basically,
They are going up as a result of this legislation. I just want to be...
All of the legislations hitting the co-ops and condos combined. Like I mentioned, the local laws, all these regulations are choking the life out of the co-ops.
And there are other reasons insurance rates are going up that are outside of the local laws, just to be clear. But the question is, have your managing agents or the insurance companies or your legal teams advised you that the rates will increase as a result of this legislation.
Well,
Yes, yes, and we can get the numbers for you. Not right now, but we
Yes,
can
please,
forward the
and-
numbers to you.
I appreciate that.
thing is that since it hasn't been passed yet, I try to keep my legal fees to a minimum because it runs in the hundreds of thousands of dollars. I only call Jay when I have to.
Okay.
And I could tell you, it's a big nut.
I
in
think
our
something that would be helpful is one, starting the conversations around, data sharing around the
Right.
acceptance and rejection, but importantly, any co-ops, not just those in this panel, but anyone watching today's riveting hearing, just ask, hey, how much would our costs go up as a result specifically of 407 so we can continue to have the conversations? Yeah.
We have a board
It's
meeting on
hard to
Thursday. I'll let you-
quantify, council member, but we would clearly be buying more legal hours of our attorneys.
Well, that's what the estimate, yeah. But
I don't know, $450 an hour, 3 hours per case.
Could have been a lawyer. $450 an hour.
But what's been
than
happening with
babysitting.
insurance the last several years is the insurance companies are more and more risk conscious, more and more aggressive in their evaluation of risk, and this would be one more big piece of risk.
Thank you. Thank you, Chair.
Thank you, Councilmember Dinowitz. And I just want to, just a point, a personal note of my own is my first apartment that I owned was in a co-op, and just Mr. Wade, you're a saint. You're a saint, our president, who has been the president for many years. He's just a saint. But I think, when I think of Mr. Wade and when I hear all of you, right, you are not the actors that we are worried about because you are the good folks. And I know, Marianne, we've had conversations in the lead up to this hearing months ago. It's been a long time. This hearing has been a long time coming since the 2017 hearing. And I just want to reemphasize something that the public advocate said earlier is just, we are most interested in feedback, right? We are most interested in, you're already responding to everyone you said, right? John, right? You said you're already responding to everyone. Share with us how long it's taking you, and let's have that inform, what the response amount should be, because it's not you that we're concerned about, it's those that do the ghosting, that don't respond. And so that goes for everything else. And I just want to, publicly take the moment to thank you for your ongoing engagement on this over time. Councilmember Brewer?
I certainly want to echo the thank you. And I know when you spoke at the beginning, I was with the press conference with the mayor, so I couldn't be here earlier, but I listened on my cell phone. And you said that you would like feedback, that this is important. So I just want to emphasize that. I do not support these bills as they are written now. But I do think that if there is input from you, extensive, that there may be some common ground. One issue I have is I have hundreds of friends who are in co-ops and members who are chairs. Let me tell you, just like you, sir, they cannot leave because nobody will take that job. And so I am concerned about that issue. That's a real issue. And these are the most progressive people I know who are against these bills in this current form because they feel, as you do, that nobody will take the job and that there'll be increased liability, et cetera. So I guess my question quickly to anybody is am I right about this issue of people not wanting to be chairs? And I am concerned because I do get some complaints, not a lot, mostly from, to be honest, HCFCs, which I know you also cover, and Metro-Lamas, where there's problems with the board. Not so many on the nonprofits and the privates. However, the issue of going on a board, you really want good members. You do not want people there who are there for their personal aggrandizement or whatever issue that they have. You want people who care about the co-op as a whole. So my question really is, unless I'm wrong, is it true that this would challenge good board members from being on the board? And if so, how?
I'll speak to that because I mentioned that before. So as I said, because 20 years, even 4 years, I didn't live there. I sublet it when I got married. I had to stay on the board because no one would serve. And Mr. Williams is gone. He said a job. It's not a job. It's a role that we volunteer for because we want to see improvements in our community. We want to have a say in how we run our community. And so, yes, if there's, and in terms of liability, when you talk about just the corporation, when you sue, you don't just sue the corporation, you sue everybody. So the board members we listed, I have to have personal excess liability because I'm on the board that I pay for personally. Even though the board covers the directors and officers, I want to make sure that we're covered. We're serving, it's a liable role. So yes, it'll be a hard sell to get people to volunteer to join to do this role.
Ms. Brewer, I had a really hell of a time trying to get somebody to fill out a vacant place on my board. And I will tell you, part of the reason is, and I agree with you 100%, if there's anything that we should probably have is some sort of minimum guidelines for the people who are going to be on the board. You should have some background in finance, some background in engineering, some background in law. It can't be just a popular thing, you know, that, oh, I have nothing else to do, I'm going to get on a board. This is like running a city. You're basically running a city. And you have budgets and you have, unions to deal with. And this is not for the faint of heart. I don't know how many people I reached out to last year trying to get them to fill in a vacant seat, and no one would go in it. Part of it is the fact that I'm not touting my own horn, but I run a very tight ship. We get applications via domicile. You know what domicile is? It's that. And I insist on my board members responding to those applications within the week. So if they haven't responded within a week, I start sending out emails. This is pending. This is pending. And so it's a full-time job. I mean, I'm a real estate broker. I have some flexibility in my schedule, but for people who are attorneys or architects, it's very tough. And you have meetings and you have board applications and interviews.
So how would maybe, I guess we're mostly talking about 407, but how would these bills impact those who want to serve on the board? In other words, is there a way of figuring out how to pass some form of this that would not increase people's non-interest? Because obviously there's not a lot of interest now, and I don't want to make it worse.
They would see it as a higher risk, because now you're talking about, threat of perjury.
Okay.
And it's a criminal offense. Right. So I have to tell you, I've been on boards from the East Village to the Upper East Side. Most people want to have a diverse building. They just want a safe building, because if you're not paying your maintenance and there's a high percentage of arrears, the banks will not like it. The banks will not lend to you.
Right.
The attorneys won't like it. They will advise their clients against buying in the building. So there are serious implications to you not being able to meet that financial obligation. So that's basically what it is.
I think all three bills, but especially for 07, will have an outsized impact on co-ops and condos, co-ops and participation on boards. And as Tanya stated, there are other considerations beyond just the liability on board members. Not being able to ensure that new purchasers can meet the financial requirements of a building can have detrimental effect on every single person living in there, the existing homeowners, and they're rarely given consideration in this conversation, but they are the reason for the admissions policies.
Okay, all right. Thank you. So all I'm saying is please participate in ongoing discussions, because I can tell you, knowing what's going on, that some of this material may pass. I'm just saying, I'm telling you. So the question would be as much input and then see how it flies. Thank you.
Thank you, Councilmember Brewer. And thank you to this panel. Thank you. Yeah. We will stay in touch. Okay, next up, I'm going to call, I think you already know, but Mike Kelly, Zoila Alonso, Jessica Adke Elmazi, Yvette Clark Watkins, and Crystal Hawkins Siska. And whoever is ready can begin as soon as they would like.
Good afternoon. Yeah, we're definitely in the afternoon. Good afternoon, Chair Sanchez, council members, public advocate, I don't think is here anymore. My name is Michael Kelly. I am the Vice President and Director of Government Affairs for the New York State Association of Realtors. We are a 61,000 member real estate trade organization with members across the entire state. I'm going to direct my comments today primarily on, and I have some notes, but I probably won't refer to them, primarily on trying to clear up, I think, some misunderstanding about the legislation before you today. So specifically on 1120, I want to be really, really clear about what this bill does and doesn't do. So let's start at the beginning. The bill would require cooperatives to provide all applicants to that co-op board the same application. That's it. The bill then would require the cooperative to respond to an application within a 10-day window with a response. And this is the significant change from current practice today, because this does not happen, as I understand it. The board would then have to provide that prospective applicant with the response, whether their application is complete or incomplete. And if it's incomplete, how is that application incomplete? Importantly, the time for the co-op board to take action on that application does not begin until the board has received a completed application. And that's, I think, important to note. Once the board has received all the information they need to take up that application, they then have a 45-day window to respond to that applicant. If the board needs more time beyond that 45 days, it automatically, per the legislation, has a right to a 14-day extension. Beyond that, the board and the applicant, if they decide they're working together to reach an agreement and get all the information they need that the board needs to take up that application, they can come to an agreement to extend it even further.
Thank you.
Thank you.
I'll ask some clarifying questions at the end of the
Of course, thank you.
Yeah.
Thank you. Good afternoon, Chair Sanchez and members of New York City Council Committee on Housing and Buildings. My name is Zoila Alonso, and I am a realtor and licensed real estate broker based in Jackson Heights, Queens. I am here to speak on behalf of the New York State Association of Realtors, a 60,000-member statewide real estate trade organization. NYSAR is fully supportive of intro number 1128 by Councilmember Ferreris and the 3 bills on today's hearing calendar. We believe Intro 1128 offers the clearest path forward to address the lack of transparency in the process of purchase a co-op apartment in New York City. Countless stories have been told regarding how the lack of the response and injurious nature of practices by some cooperative housing boards have harmed potential buyers and sellers in our great city. As a realtor, I have witnessed firsthand how the lack of a requirement for boards to respond to an applicant has harmed New Yorkers. This loophole allows co-op boards that don't want certain people in their building to simply not consider an application, leaving otherwise qualified applicants in the dark indefinitely. Intro 1120 also better serves consumers who is lawfully declined can move on with their housing search. Having a co-op board sit on an application for several months puts home buyers at a distant disadvantage as they face potential mortgage rate expirations and loss of application fees. While NYSAR also supports Intro 407, we are concerned that the lack of a timeline component within or in conjunction with that legislation would simply permit unscrupulous boards that wish to illegally discriminate against an applicant to simply sit on an application. We are supportive of requiring boards to provide a written reason for denial, although we believe Intro 407 is flawed in its current form. And while we agree with Intro 407's intent
please conclude.
To combat illegal discrimination, we hope you recognize that imposing fines on co-op boards does nothing to provide access to housing. In conclusion, NYSAR encourages this committee to advance Intro 1120 and seeks its passage before the full City Council. I appreciate the opportunity to testify and thank you for holding this important hearing. Thank you.
Thank you.
Good afternoon, everyone. My name is Jessica. I am a broker specializing in
co-ops for over 24 years, averaging 100 and 150 co-op transactions per year. I can say with confidence that co-ops affected by this bill are going to be the exception and not the rule. It is important to humanize the issue for both the applicant and the co-op, and as the co-op is a community of shareholders whose largest asset is often their home, their caution is understandable. One problematic applicant can cost the shareholders a significant amount of money and disrupt quality of life. But evidence from nearby counties to the north of the city for over 6 years and to the east of the city for over 10 shows that without the success of transparency bills and reason bills without lawsuits. When it comes to denials, I can say with my own experience that a majority stem from the realtors, buyers, and attorneys not doing due diligence to ensure that the applicant meets the posted financial requirements when the co-op has those requirements posted. As a listing agent, I flagged roughly 40% of the offers as not meeting co-op requirements, and those offers are turned away before they can even reach the board, where a clearer standards and better communications can benefit everyone. When it comes to timeline, the average co-op transaction takes 75 to 115 days. Yet in the past year alone, I've seen transactions take 6 to 12 months from contract to close, leaving the seller and the buyer financially and emotionally stuck. Reasonable timelines paired with transparent decisions benefit everyone involved. Again, delays are the exception and not the rule, but when they happen, they could be costly and devastating. The co-ops there are co-ops that don't even allow contracts to be sent out until the pre-board approval happens. That means there's a preliminary application before you can actually do your board application, and sometimes you can be waiting 1 to 4 weeks for preliminary approval and then send out a contract to wait another 3 to 4 months. A point of clarity that some things that had been said earlier, that a seller accepts an offer and an application.
Please conclude.
Thank you. An application can be processed only one at a time, so I think there was some misunderstanding about reference of a cash transaction supplementing over a mortgage. That's incorrect. When you go into contract, you can only proceed to the board application with that one transaction, so we're not floating multiple contracts with different terms. Also, Councilmember Dinowitz, there was a point that you had made earlier that I jotted down. Issuing an approval or a declination letter is not burdensome to the board as it's required in order to get to the next stage. An approval letter or a declination letter is needed to go to closing. So what we're finding in areas that do have these transparency bills, and in fact, it's just a checklist. Approved, or if denied, the checklist is checked off. And that's pretty much it. The other thing to keep in mind, because we need to humanize this for not only the buyers, the sellers, and the existing shareholders, I understand the concerns about proposed maximum fees, but any potential penalty is far less costly than a class action lawsuit brought against a co-op by a bad actor. And I can tell you as someone that specializes in this line of work that that is really not, that is the exception, not the rule. So there's a lot of co-op members coming up here talking about how they're doing it, and we're thankful and appreciative that they're doing it that way, but there are a few bad apples, and it's not doing them any service. Thank you.
Thank you.
Hi, good afternoon. Learns. Good afternoon, Chair Sanchez and council members serving on the Housing and Buildings Committee. My name is Yvette Clark-Watkins, and I'm speaking to you all today on behalf of the Long Island Board of Realtors, a 27,000 member trade association for real estate professionals from Queens, Nassau, and Suffolk County, of which I'm proud to call myself the Secretary Treasurer and President-elect. I wear many hats as a realtor, but also as a mother of twins in college. I'm active in my community in Adderley Park, Queens. Realtors across Queens are strongly in favor of Councilmember Farias's intro number 120A, a key step forward to bring much needed transparency to New York City's co-op market. This is not really about realtors and the application packages we put together for our clients. This is about the buyers and sellers we serve and the families and households with dreams that are put on hold whenever a transaction is delayed because a co-op board has not acted in good faith. With no current requirement for boards to respond to an application in a timely manner, New Yorkers are placed in a higher risk of falling into financial limbo than their suburban neighbors. Deals with dreams fall apart, but also this would not happen if we had timelines. We have all shared with our colleagues stories of our problem co-op boards, of clients who got the runaround and will always have to wonder, did they not get into the co-op because of their credit score, or was it because of who they are? Currently, when a co-op board does not want certain people to live in their building, they simply do not respond. With all that New York City has worked on to better address fair housing, it is simply bad for business that, most of all, bad for New Yorkers that we allow this co-op loophole to persist. Intro 120 is not asking for our clients to be accepted in a development where they cannot afford to live. A responsible realtor is focused on helping clients find a place.
You may conclude.
Thank you. Where they belong based on both their finances and personal desires. Our clients, your own constituents, deserve better fairness and to know when to move on with their search for another home. While Long Island Board of Realtors also supports Intro 407, the issue remains a well-financed co-op board may still sit on an otherwise qualified applicant as a backdoor form of discrimination. Fines are a useful tool in the right circumstance, but they still will not provide consumers with fair access to housing. As a professional realtor and leader in LIBOR, I speak for my members when I implore this committee to advance Intro 1120 and seek its passage before the full council. I appreciate this opportunity to testify before you today. Thank you.
Thank you.
Good afternoon. Thank you so much, Chair Shantes and the distinguished members of the council. My name is Crystal Hawkins-Siska, and I am with the Hudson Gateway Association of Realtors. We cover the Lower Hudson Valley, which is Rockland, Westchester, Putnam, Dutchess, the Bronx, and Manhattan. I'm originally from the Bronx, from the Fordham section. Yeah, that's right. And I currently do live in Westchester County and cover the Bronx for real estate transactions. I actually sat on a committee that helped advance this similar legislation in Westchester County, and many of the same arguments were made there. And I can tell you unequivocally that the results for the public and for the shareholders were resoundingly in the favor of all, as opposed to the fears that are being laid. The same fears were laid there, and I could tell you that they came to be not. I'm a full-time real estate agent, which I think is important because the average realtor does somewhere between 4 and 5 transactions, and everybody here is really a practitioner. My team does about 50 or so transactions a year, with about 20% of those being co-op transactions. So we do have a high level of understanding about how this works, and I'm here to support Intro 1120 as a positive step in the right direction, because it is true. Cooperative housing plays a critical role in New York's homeownership landscape, and ensuring that prospective buyers have access to clear, accurate, timely information about a building's financial health and governance strengthens consumer confidence and supports the long-term stability of the cooperative model. You know, having worked in real estate for many years, I've seen firsthand how a lack of uniform standards and transparencies in some cooperative application and the review process creates opportunity for inconsistent treatment.
You may conclude.
And at times, discriminatory outcomes. While many boards do act in good faith, there are opaque practices, like it was spoken here, and unclear criteria that can allow buyers, whether intentional or unintentional, and can influence the decisions. So the Hudson Gateway Association of Realtors looks forward to continuing to work with policymakers to ensure transparency measures strengthen cooperative housing and to preserve role as accessible and stable. And the thing is feelings aren't facts and data is important. And one of the things that we were able to do is provide for the Westchester County legislators actual data, because although it was shared that it's like 3 to 8% through our MLS transactions, we were able to show that somewhere between 10 to 12% were being rejected, and we could actually drill it down to certain buildings where it was like 15 to 16% rejection. So we are your front line, and we're looking to collaborate to give you the information to make the right decision for homeowners and shareholders alike in New York City.
Thank you. Thank you so much. Before I turn to questions, I want to go to Mike and see if you had anything that you wanted to add about our understanding of Majority Leader Farias's bill.
Yeah, thank you. I appreciate the opportunity. So I just want to be clear. At the end of the day, that clock on the 45-day time frame does not start until there's a completed application. Beyond that, the board can ask for an extension. If the applicant and board meet and need more time, they can both agree to do that, and that's in the law. After that time frame is expired, the burden is upon the applicant to raise their hand, essentially notify the board that their 45-day time frame is expired or any extensions, and then the board is put on notice, and they then have 10 days to respond. And if and only at that time, beyond that 10-day window, again, the board has not responded. And by the way, let's be clear. It's not responded with a yes. It's a responded with a yes or a no. So we want to be clear that we're not, this legislation doesn't require boards to say yes. Obviously, we, respect the ultimate right of the board to decide what's best for their shareholders and their fiduciary responsibility to them. Then the board has to give them a response. If they don't give them a response in that time frame, they've deemed consent to the sale, and the injured party can go to a court of jurisdiction. So that's essentially how the legislation works.
Thank you. Thank you so much for that. It's very helpful. So I have a couple of questions from the majority leader who had to step away. But I first just want to jump on one of your last points, Ms. Crystal, about the data. So this information about the rate of declination you said in your data was 10 to 15%, much higher than what we've heard earlier today. So do you have specific information about New York City rate of declinations?
So we will be interested in collaborating with you on that, because right now our data for Manhattan, like what I was speaking about was Westchester specific, our data from Manhattan right now is incomplete, but we do have a lot more data for the other boroughs, for Bronx, and definitely from Queens that we could start sharing. To give you some context, what that looks like is when a property, and of course, this is for properties that are actually listed on the open market. Like, I can't talk to you about what's going on behind closed doors. Like, I don't know. But what I can tell you is that if they're working with a real estate agent and it goes into the multiple listing service, we can see the days on market. Like, how many times has it come off and gone on, right? Did it expire out, right? And then they had to relist. So when you start collecting, then you're able to see patterns of rejections or ghosting on deals. Like, how long did it stay in contract? Like, that's a big one. And it actually expire, right? And did it actually even close? Because then we could look at that. That is something that we'd be willing to work with you to look at what it looks like.
Yeah. I really appreciate the use of ghosting in this professional setting. I thought it was only in dating. But that's really helpful and would be helpful for the committee to consider. This is a question for all of you, and then I'll go to the majority leader questions and then our colleagues. Have you seen, and if the answer is yes, could you give us a sense of scale? Have you seen the same board treat applicants inconsistently?
Yes, I have.
And what are some examples of how?
So there's a particular building in Queens where we had a cisgendered female applicant who presented in a masculine manner, I guess you would say. And when she applied to that board, she more than met the requirements that stated for their debt to income ratio that they were looking for at the time and income. And she was over $500,000 annual for her income, single, going into a one-bedroom. And it took us 4 months to receive rejection for her, of course, without reason. We applied to a different building nearby, and within the normal time frame, she got into that apartment. Now back to the original building, we had another applicant who was interested in the same apartment. When it came back on the market, we put in the application, cisgender male, lower income than the initial applicant, and they got in within the normal time frame. The acceptance was quick.
That's helpful, and if anyone else wants to jump in with examples, those will be helpful as well. I'm going to just ask a couple of questions on behalf of the majority leader. Well, I guess I stole her question, but a different version of it. Can you speak to challenges your clients have experienced, including possible illegal discrimination, ghosting, or no response? What are some of the clues that your client has been your clients were discriminated against? And if you have anecdotal information or the association collects this information, are there reasons that you think people don't come forward after they've been discriminated against?
Okay, so I think we have to remember that there is, in the application process, when you purchase an apartment or you're attempting to purchase an apartment, there's a lot of non-refundable fees before you even get to that board interview. And then when you get denied and you're maybe waiting for 1 to 3 months to get denied, there's not only the financial undertaking of going down a route of trying to advocate for oneself, it's very difficult to find an attorney who will advocate for you because they don't want to make an enemy of the board. Okay. And then on top of the emotional drain of being locked in there, it's not only the buyer, the prospective buyer, it's also the seller. The seller's selling, they need to go somewhere. They don't know what's happening. There's people that have been in situations, again, exception, not the rule. I just want to say that as somebody that specializes in this. But when it happens, it's unfortunate and it shouldn't happen at all. So you have these exceptions where you have people just completely contractually hijacked because they're under contract. They're extending their loans because that comes at a fee. You have to extend your rate. You keep extending. You can't get a declination letter from the co-op and you can't get an approval letter. You just get no response. And then you can't get out of your contract because the seller's attorney wants to hold your escrow. So it doesn't happen a lot, but it happens enough that you have realtor members that are actively in this line of work that are here putting themselves out saying, we got to make sure this doesn't stop, it doesn't continue.
Thank you. It's very helpful. Do you have, as individuals or again, as the association, any of your associations, do you have the average amount of time that your clients must wait for a response? What's the longest amount of time that you've had? What's a typical response? And how do these timelines, I mean, you touched on this, but if there's anything you want to add on how these timelines affect the sellers and the buyers?
Typical response time is usually going to be from the time you submit a board application for, these very high functioning co-ops, like most of them are, anywhere from 2 weeks to 60 days, depends on when you submit your board application in the cycle of their interview. But most co-ops allow for like a monthly interview. So whether you make that month's interview, you might get to the next month. I have had co-ops not respond. We waited 7 months for a board interview. That's, again, people are hijacked and then you can't get a response. Exception, not the rule, but it happens.
I would like to just mention a personal experience with one of my buyers, which was very disheartening. When we started the process, found the building, submitted the application, checked all the checklists, and it took probably over, I want to say, 90 days to get even an acknowledgement. And that was just going back and forth with the attorney. What's the response with the management company? Then the lender letting us know that rates are going to expire, where the buyer kind of will get that increase. And when we finally did get the acknowledgement past the 90 days, then application, nothing was missing, still got rejected, still got denied, no reasoning. And it kind of checked what the building was requiring from credit score, reserves, everything, employment. So that right there was where it was really eye-opening to see the time frame and also the rejection and the denial for no reasoning.
Thank you.
When they should have probably been able to pass the board.
Thank you.
I know your last question was how come you're not seeing that many complaints? Honestly, to be frank, they're just trying to find some place to live, right? So usually as soon as they receive their rejection, you still have the process of getting the escrow funds released so we can start hunting again. So usually they're so focused on that, they're just happy to be in their apartment and they've moved on with their life.
Got it. Thank you.
And you were also, I think what I also heard you ask was about possible forms of discrimination that we've seen. In my 22 years, I've seen a run of the gambit. It does vary from building to building. And once again, I want to highlight there are great co-op buildings. And I can tell you in Westchester County, once the law was enacted, those buildings who were great actors, their property values went up because they stood out against those who were not acting properly. But I've seen it specifically in the areas of age. So a lot of young buyers, I don't know if you know, but right now the average age of any first-time home buyer is 40 years old. Is where we are right now. However, there's those who have been successful who are under 30, and I've seen that challenge. And sometimes it comes out as they don't have enough work history, but they yet have income and assets, and some of them literally have funds from their parents. So there's that, right? Then also, too, one of the saddest spaces where I actually see a lot is more of a hardship circumstance, which is when a person who is the heirs of a co-op. That is one of the hardest and roughest situations, is when the family is trying to sell the co-op and then they have to keep paying month after month the maintenance fees, and they cannot sell it. In my career, I've had multiple properties that have actually gone into foreclosure trying to sell because they've had repeated individuals, some of them even paying cash, that were rejected, right? And I'm speaking into the New York City space. And what I can tell you is that with similar legislation like this that passed in Westchester County, one thing that came out, which was not a discriminatory practice based on any protected class, was how many co-op boards were rejecting the applicant because they didn't like the price. But they felt that it was selling for too low. And then once in Westchester, there was a reason, and the checkbox reason was sales price or value believed under market. We were able to start recovering those deals. We were going back. If there were higher sales in the building, guess what? We raised the price of the purchase price and put a seller's concession to make room for any renovations that needed to the apartment. So in that case, the legislation caused declinations to now become reversals because we matched what the board needed.
Yeah, that's really interesting and really helpful. And you couldn't do that without the information being provided. For Westchester, I was exactly going to ask you just that. In the declinations that you analyzed in Westchester, what were those reasons?
So before the law, it was purchaser didn't qualify. It was very generic. It didn't give any reasons. Now, since the law, it's like a checkbox. It could be like one of like 5 or 6 answers. It could be assets do not meet the threshold of the cooperative. The credit score does not meet. The value of the property is insufficient, or insufficient work history, and then sometimes they put an asterisk because sometimes it's because of how the letter was written. So literally, we just go back and get the employer to write it in a different way that actually matches what the board needs. But it's kind of straight away on that. And what I also want to share with you is I really appreciated that a lot of the board members are volunteers, right? And I want to speak to this about engagement, because I think we're all volunteer leaders ourselves, right? So this is a epidemic that is across the board. It is not germane or just specific to co-op boards in New York City. It's across the board where people don't really want to volunteer their time. That being said, when you have clear processes, because we saw this in Westchester, when you have clear, definable rules and processes, when you have to get things done, it actually changed the makeup of the board, because when people knew what was expected in a very clear, concise way, they actually gave more of their time because they knew not a lot of their time was going to be taken away. Okay, so I think that's really important to know. And I hope that answered your question.
Yeah, that's very helpful. Thank you. This is my last one on behalf of the majority leader, is whether this bill should consider any different flexibility for smaller co-op boards or boards that don't meet in the summer. And then I'll turn it over to my colleagues. Do you want to fight to see who goes first?
No, it's not a fight. Gail wins.
Okay, Gail wins. So Gail and then Eric.
Yeah, I'd be happy to answer that. The Intro 1120 specifically, we were grateful to work with some of the larger co-ops in Queens and Manhattan as well, to hear their perspectives on the legislation. This isn't new. This conversation about co-op transparency began in the early 90s when, at the time, it was New York State Attorney General Robert Abrams had a departmental bill submitted in Albany to address this exact same issue, this timeline, this responsibility to provide a response to an applicant. So we've been at this a really, really long time, over 20 years, engaged with state lawmakers, city lawmakers, trying to find common ground and really to make sure that we're putting in place something that works in the real world, for the boards as well. So part of that was hearing from the co-ops. Intro 1120 was amended several years ago to address that summer month concern about boards not meeting. So there are extensions provided in the legislation that allow for that, where they don't have to adhere to that 45-day timeline during the summer. And the second thing is we also heard the concern that some smaller co-op boards honestly just didn't have the bandwidth. They didn't meet as often, and so they are carved out. So if you're a co-op board of 9 units or less, 1120 would not apply to you.
Great, thank you so much.
Thank you.
Councilmember Brewer.
My question is, for obviously, I never go to Westchester and I don't know anything about the island, but my question is, does this time frame for 1120 match what you think is working in your different jurisdictions? That's my question. In other words, I think when we heard earlier panel, there does seem to be consensus on some kind of answer, maybe the checkoff that you described, but some kind of answer and some kind of timeline. But there are other issues that people have concerns about. But that seemed to be generally accepted from the earlier panel. So I just didn't know how, is this same in other jurisdictions?
Well, I think the reason why, honestly, it passed so easily in Suffolk and Nassau, there are not a lot of co-ops there, right?
Mostly private houses, yeah.
Correct, and primarily, low zones. So single family, you don't have a lot of multiples. So we don't have the same data set that Westchester does.
Okay. Thank you, that's helpful.
So yes, the timeline was extremely helpful. So just like in New York City, in Westchester County, co-ops are the default or de facto affordable housing. It's a way to get into home ownership, especially in Westchester County. So before, and I remember when I first started real estate, a co-op transaction was at least 6 months, on the ready. And my longest transaction was 1 year, 2 months, 3 weeks, and 2 days. I'll never forget it, right? That I can tell you, right? But they were definitely somewhere between, I would say even in Westchester, still 4 to 5 months. That is half now. Because if you're working with a good lender, because remember, the buyer has to go through the whole process with the lender to get a commitment letter, right? Once they get the commitment letter, that's when they could put in their application. And in Westchester, it's 15 days. You put in your package.
That's what I want to know. What is the amount?
So it's 15 days
right.
In Westchester that you have for the board to, or for the management company to respond to either say it's complete or you have to cure some defects. Then once that goes in, they kind of get another 10 days. But I have to say, since this has gone in, they've been a lot quicker. And then once the board package is considered complete, it's 45 days. And I can tell you, within the good actors, they are getting them done in less than 30 days for certain. So the process is now only 3 months, if not less.
And I should know this, but in Westchester, there are more co-ops than there are obviously on the island.
Yes.
People, I assume, still have houses and live in them. But
yes. There's a significant co-op
presence in Westchester County, but not like the city, but still.
Yeah, right. Not like the
Not
city,
like
but
the
we're your
city.
close second is what we are.
All right, thank you.
Thank you.
To respond to one thing you had asked, a standard co-op timeline, just so you understand, in a contract, it's 45 days to get a commitment and usually 10 days thereafter to submit your board application. So that timeline is already structured in our boilerplate contract. So this almost replicates it just to reinforce it.
It's not the law, but it is a practice, is what you're saying.
Correct.
Here in New York City. Okay. But there's no penalty if people don't make it because there's no law.
Well, then they're in breach of their contract.
Breach of contract.
Yeah.
Okay, thank you.
Great. Thank you, Councilmember Brewer. Councilmember Dinowitz.
Thank you. First of all, you are welcome back in the Bronx anytime. I think especially Fordham. Very, very sad to lose you to Worcester. So just like a clarifying questions. First of all, I think what Chair Sanchez asked is right. Any data you could provide, which we still haven't been provided with, I think would be very helpful in understanding. But it's a testimony that any time a listing is removed from a website, it's because the co-op board rejected them.
So in our data, like I'm specifically speaking about the data set in Westchester County, when it came to the co-ops, almost always it was because of, like, when it came off, like went into temporary status or pending status, it's because they were in a contract, right? And then it comes back on the market because they were rejected.
And that's the same answer for, like, if it's in contract for a certain number of days, it's because of the co-op board, right? Like,
If it's in contract for a certain amount of days, let me make sure I'm clarifying what you're asking me. You're asking me if it goes into contract on the multiple listing service, you're asking that's in regards to what the co-op board is doing.
you had shared that we can see it's been in contract for 1 million days, and then you said it was because, or you didn't say, but the implication was it's because of the co-op board. I'm just kind of clarifying, just for us, it is definitively, if that happens, because of the co-op board.
Something must have happened for for the apartment to come back on the market. So we don't have the exact data, but what I do see on our MLS is how many apartments are in our listing for over 100 days. And that's where you can probably tell we need kind of the timeline to kind of shorten these, co-ops to kind of move quicker in the market. So that's kind of something that I wanted to mention, that we don't have the data, but going on the MLS, when I'm searching for apartments, why is it on the market for so long? It could go on the contract, then it comes back on the market. And the only thing we could assume is that, yes, it was denied, and what the reason is for it, we won't know.
There is data points we can extrapolate. So what happens is something gets listed in our inventory. It has a start date. It's a list date and expiration date. That's our listing timeline. When we go under contract, it changes the status, as Crystal said, and it goes to a pending status. And then we have not only the days on market, so the time it took to go into contract, but then how long it's been under contract. From the time it goes under contract, you have one of two results: closing or back on the market. When it's back on the market, you can, depending upon what multiple listing service you're referencing, we will give a reason: board denial or bank denial. So we can pull those.
Do you have that?
We do have that. Yeah.
And then just, regarding something you said, I do think there's a distinction between an approval or denial letter and then what the legislation says, which is each and every reason for withholding consent, no more than 5 business days, penalty of perjury.
Right.
Like, there's just, I'm sorry?
So that's 407.
Yeah, I'm talking about 407. Yeah.
So
just because you mentioned that I
called you out.
Call me out. Yeah. But by the way, and I do want to add credit to the chair again. It's really important we do that. She is rivaled by, I think, no one in the council in terms of listening and hearing everything when it comes to legislation. So these are important conversations we have during hearings, but I do want to clarify the distinction between an approval letter or a denial letter and what the legislation is proposing. And in my view, the legislation 407 that's being proposed is significantly more onerous and strict than certainly what's in Suffolk, but even what's in Westchester. The penalties are different. The things that are being asked are different. Can you speak with specificity about some of the differences between what 407 is requiring, incorporating some of what you heard about administrative costs, legal fees, all of the fees we have in New York City, and what the actual legislation was in Westchester, Nassau, and Suffolk?
So I like to talk about administrative fees. So in Westchester County, what we saw is that administrative fees actually went down. And the reason being is because essentially the co-op boards did not like the process not meeting the burden of what the law was. And what was revealed is that with some buildings, the bad actor was the management company. So they needed to change the management company. And in that, due to technology like, board packager and all these kind of things, there's things that cost less money. because we're in the technology age. I mean, we can scan a PDF on our phone and upload it somewhere. So that's changed the game in that space. So that definitely went down. So I wanted to answer specifically about administrative fees. And also, too, when we first had the legislation was first passed in Westchester County, and Mike could probably talk more about this, we had more onerous penalties. When it got passed the first time, that was taken away, and then actually it came back in. They're like, no, we got to beef this up. So it's like only like $1,500 for the first offense, then like $2,000 for the next offense, $2,500 after that, and I think that's the tiered approach to any kind of financial penalty. So that's definitely different than what's being proposed.
Also, to your point, the transparency element, giving that reason also puts the responsibility of not doing the realtor or the buyer not doing their due diligence, and it takes away superfluous and over the top lawsuits and allegations and people going online when you're being told, well, no, our debt to income requirement was 30% and you came in with 35. That's why you were denied. So that transparency element, co-ops are New York's entryway to homeownership.
Yeah.
Okay, and a
Sure.
lot of times people don't know what they don't know. So they say, I have a pre-approval, I'm good. And there's a lot more to it. And there's a lot of, unfortunately, and I'll take responsibility, there's a low barrier of entry in our industry. And sometimes the realtors don't do their due diligence. And then the attorneys don't. They just slap deals together. And then it gives a burden onto the co-op that they don't deserve. So being able to say you were declined because you have a 400 credit score, it's crystal clear. And you can't turn around and sue somebody because of that.
That goes to one of your other questions about the differences between some of the legislation as proposed here versus what is in Westchester County. So it is actually written into the legislation in Westchester County that each co-op bill each co-op had to provide written on their public-facing website and on their applications exactly what the requirements. You have to say you need this many years of work history. You need to have a credit score that is this amount. You need a debt to income ratio on the back end of this amount. You need, 5 years of reserves or 1 year. All of that is outlined actually in the legislation. So that worked in coupling, and it actually helped us all as practitioners, because we knew right up front we could get these people done. But when we don't know, we're fishing, because we may have had someone go in and get a 750 credit score and maybe their DTI was 22%, right? But then we have the same person, a similar person with a similar profile, and they don't get accepted when we're like, well, why? It was just like the other person. So that's one of the other differences in the legislation.
And I think also to cut through the minutia brings you right back to 1120, right? We're just looking for a timeline. That's it, right? We're not asking for anything else. It's just, because I have a transaction now in the Bronx where I have a seller who might not be able to sell the apartment. I know, I could go on too. I graduated from St. Nicholas of Tolentine, grew up in Concourse Village, so yeah. But
They're all
now I'm
mine.
in
Okay.
Queens. Yep. But all of that to say, I have an apartment now in the Bronx where the seller has financial issues, had to move out of the state to move back in with family. We have been waiting 4 months to get feedback from their board that they used to be the president of, right? And this is them helping them, right? They said they're expediting on their behalf. We're still at 4 months waiting to get feedback. So 1120 is very simple. And all of that to say, there might not even be an apartment by the time we get our acceptance because they don't have the funds to continue to pay the maintenance.
Great. Well, thank you for this panel. I think panels so far are rivaling the amount of time that we spent with the administration. So thank you for your time, and thank you everyone for your patience. We're going to go to the next panel. So the next panel is Bob Friedrich, Warren Schreiber, Alicia Fernandez, and Jeffrey Mazel. And I apologize for any names I mispronounced. Bob, Warren, Alicia, and Jeffrey. Whoever is ready may begin. Okay.
My name is Bob Friedrich, and I'm president. And I'm president of Glen Oaks Village and co-president of the President's Co-op and Condo Council, representing presidents of the largest co-ops in New York, and we advocate for co-op justice. Volunteer board members are elected to co-op by co-op shareholders, and many serve on local civic associations and community boards. They are in the business of approving residents, not rejecting them. Intro 407 requiring reasons for rejection will end, and this is really important for you guys to understand, will end admissions flexibility for all applicants. Buyers whose financials are borderline will no longer benefit from a co-op's willingness to get them over the hump by offering flexibility in the admissions process. Whether it's accepting an applicant's credit score that is slightly below the co-op's requirement or permitting a co-signer to push the application across the finish line, flexibility will end, as treating one applicant slightly different than another would expose the co-op to costly and punitive litigation, make it impossible to get vulnerable applicants to yes instead of no. It was introduced because of perceived discrimination in co-op housing. But let's be clear. For discrimination to actually exist, 3 extraordinary conditions have to take place simultaneously. Number 1, co-op owners would have to elect a majority of inherently dishonest individuals to their board, which means a typical co-op board of 9 would require 5 colluding board members to break the law and discriminate. 2, the co-op's management company would have to be part of the law-breaking cabal. And 3, all of these individuals having a fiduciary responsibility to act in a lawful manner would have to bring the co-op's attorney into the ring of complicity and collusion to achieve this unlawful applicant denial. The hierarchy of checks and balances in a co-op is why there is no evidence of systemic discrimination in co-ops, and we heard that today from the Human Rights Commission. Intro 407 threatens the very housing access you seek to protect and harms the very applicants you are trying to help. Losing flexibility in the admissions process will mean the difference between rejection and acceptance for many vulnerable applicants, and for them, I urge you to reject this misguided bill in the name of co-op justice. Thank you.
Thank you.
Yes, go.
Good afternoon, Chairperson Sanchez, members of the committee, Councilmember Dinowitz. Thank you for staying here with us. My name is Warren Schreiber. I serve as co-president of the President's Co-op and Condo Council. I'm also president of the Queens Civic Congress, and I am president of my own co-op in Bay Terrace, Queens. I strongly oppose Intro 407. While the goal of transparency in the co-op purchase process is understandable, Intro 407 is deeply flawed. If enacted, it would impose unreasonable burdens, legal risk, and administrative cost on volunteer co-op boards, the very individuals who work tirelessly and without compensation to manage and preserve affordable housing for New Yorkers. Now, I'm going to put the testimony down because I want everybody here at the table with me, all of my colleagues, these are volunteers. Even our legal counsel, he works pro bono for us, works pro bono. We are volunteers. We get up early in the morning. I'm usually out of the house by 6. I go over to the gym. I come home. My first call is to my co-op superintendent. First call in the morning. That's at 8 in the morning. 9 o'clock in the morning, I call my property manager to find out what's going on, what happened overnight, what type of complaints have we had, what are we facing. I have been president of my co-op for almost 27 years, which shows that I am a glutton for punishment. But in those 27 years, we have denied three applications. One of them was because the applicant, and I was the first one to identify it, was taking out a subprime mortgage. And I had never seen anything like it in my life. And for those of you who might remember, the bank was Countrywide, which no longer exists because they went out of business because they were in the subprime mortgage business. The other one, we had somebody who was actively in bankruptcy. They were in bankruptcy at the time they came to us. And the third one, the individual, they did not meet our financial requirements by $25,000. They were short $25,000. There was no way that they could ever make up that amount. If they did, they would be more than welcome to come back to us. But what 407 does, it puts us in a defensive posture because we have to...
You're at time, so you may conclude.
Okay, sure. So with that, I thank you, and I just want to say that we work really, really hard. We're all volunteers, and I ask that you take this 407 back to the table and come up with something we can all live with. Thank you.
Thank you.
I wrote here good morning, but it's actually good afternoon. Chair and members of the committee, my name is Jeffrey Maisel. I'm an attorney. I practiced in the co-op and condo space for 40 years. I represent over 25,000 units of co-op and condo housing. I'm the member of 2 bar associations, co-op and condo committees. I live, eat, and breathe these issues every day. We talked about collaboration before. I personally went to then council member Jumaane Williams' office over 7 years ago and met with a staff member and explained to him the problematic nature of the bill. You can't have volunteer board members subject to perjury, subject to legal fee provisions, right to supervisions. There is liability here. That person who spoke initially completely misspoke and misled this committee. There is liability. Doesn't mean you did something wrong, but it means you're exposed to potential lawsuits. Every time an investigation is started by a city agency, you have to call your insurance company, and they count the number of claims. There are deductibles. You have to hire your lawyer. So there is exposure, and there's tremendous exposure in this bill. I sat down with his staff member for hours to explain what I'm talking to you about today, and we went to the hearing in November 2017, very same issue. He didn't change one word and did not incorporate one word of what I said. Instead, I heard the gentleman speaking to this committee before, who was not in the co-op space. I've handled over 10,000 closings. I meet with hundreds and hundreds of board members. I live these issues. I get calls every day on this issue. And to sit with a city council member and not take one word of my suggestions it was outrageous. I deal with a lot of council members. They call me usually, and I give them what's going on in this world because I have my ear to the ground. So the bill, as you heard, I just also want to say on the timing bill, the difference is we were met with and collaborated with Mike Kelly and Jessica and people here today, and they did take many of our suggestions. Although I'm not supporting that bill, it is much more palatable. The Reasons bill is a non-starter and a disaster for co-ops.
Thank you. You said 7 years, but that's at least 8 years.
2017, so that's
Yeah.
8 years. I was a lot younger then.
Me too.
Yeah, we were all there. Yeah. They look the same. I got older.
Thank you.
No, you didn't.
He had hair then. Okay.
No, he didn't. No,
I
he
want to
didn't.
make sure the record reflects he had hair then. Okay. Thank you.
Good afternoon, Chair Sanchez and committee members. My name is Alicia Fernandez. I serve as the treasurer of the Queensview Housing Cooperative in Long Island City. It comprises 14 buildings and is home to approximately 2,000 residents. I'm here today to highlight the pressing difference between a co-op population in New York City that has 450,000 units and the constant comparison to that of Westchester, Nassau, Suffolk, which is a fraction. I don't have exact numbers, but the $450,000 number is from Gothamist. The 3 bills currently under consideration would cause additional risks for New York City co-ops. Lenders and insurers will not want to absorb this risk and will either pass these costs onto shareholders or just deny coverage and funding. I'm part of a group, I'm part of this esteemed group, the President's Co-op Council, but I'm also part of the Coordinating Council of Cooperatives, which represents most of the Mitchell Llamas in New York City. And I invite any council member that wants to join us the second Saturday of every month where we meet. And one of the big topics is that certain co-ops are being denied insurance coverage altogether. No commercial property insurance is available due to aging infrastructure, due to outstanding liabilities. I'll also mention that at our co-op, we process 30 applications a year on average. We have one of the best acceptance rates and turnaround times. Jessica Akte-Matsi, that was just here as a realtor, is one of our top realtors. We pride ourselves on this process. I'm very personally invested in the process. And I'll say that I think rejections are often due to a lack of education afforded to buyers, meaning they come to the table, they don't understand the DTI calculations, they are not savvy about shopping for mortgages in the marketplace to lower their DTI calculations. They don't understand the need for the reference letters. We have a very comprehensive package, and it challenges them. So I think perhaps it would better serve all of us if our efforts were focused on not this punitive bills with fines and perjury penalties, but maybe if we could cooperate together to develop a system where we're actually facilitating and expediting these applications versus just punishing bad actors. Thank you.
Thank you. Appreciate that. On Intro 407, this question is for Jeff, but really any and all of you. I hear you. I've heard a lot of folks pointing to this issue of the personal liability. These are volunteers. We are volunteers. Is there a different way? And I think the public advocate may have asked a version of this question, but is there a way to write enforcement of a provision like a reasons requirement in such a way that it's not bringing us personal liability, but it is, having some accountability for the board? Because again, you all, and probably many of those boards that you represent, many of those co-ops you represent are the good ones, but there are bad actors out there. And so how do we get them without subjecting you all to more
There's bad actors everywhere, okay? Again, I deal with dozens of boards, and at least on my watch, there's no discrimination because I won't allow it. They're professional. I mean, we're licensed. Property managers are licensed. You know, I heard the testimony before, like there's some secret society going on. That's an absurdity. It's fantasy. The co-ops are working in daylight. They're professional entities. They're highly sophisticated, well-run entities. Now I'll answer your question. Not all of them, but
yes.
You know, well, we try. We all try. And they're volunteer boards, and they're elected boards. And let's not forget that. They're elected like you guys are elected. So people chose them, and if people don't like them, they could vote them out. As far as liability goes, the problem with 407, and let me start with that, is it increases the layers and levels of exposure to the board members, starting with the sworn to statement. I've taken polls. I go to about 10 to 20 meetings a month. I have a really fabulous life. I sit on Zoom in my basement for hours. And I take a poll. Who would sign a sworn statement? I have not seen, nobody would. You have to be insane. You might as well just publish your social security number. So that's one level of liability. Makes no sense. The way it's written, the document has to be drafted almost like a court pleading. And you heard the gentleman in the beginning, boards change their minds because there's some sort of conspiracy going on and they'll find something later. Absurdities, really, really silly testimony. In Westchester, you check the boxes, and I've seen the form. It's a very simple form. I don't like some of the boxes. There's a right to sue, so you can get your civil penalties. I would eliminate civil penalties. There's no reason to have civil penalties in this format. How about education? You heard the Human Rights Commission talk. They teach the brokers. They teach this one. How about education for board members? And if something is wrong, and it doesn't have to be punitive, have education courses for board members so they can learn what they can and can't do, which again, as counsel, I do teach them. But, and I've taken sensitivity training because, the world is changing and it's good to keep up. So instead of banging them over the head, say, you have to take a course. Not a terrible thing. There's legal fee provision, and no one's mentioned that. A legal fee provision means I can get an aggrieved applicant, and I can sue the board, and I can get legal fees statutorily. That's a tremendous, powerful tool for an attorney. Attorneys will gather these cases and bring these slap lawsuits because they'll get 1,000, 2,000, 3,000 because there's a legal fee provision. That's what you put in the most extreme types of law of statutes for extreme behavior, not for a volunteer board member who maybe made a mistake or needs education. And on top of that, again, to have a person have to put their name on a rejection is not fair to those people. It's not fair to the board. The board acts as a group, and it's a group decision, just like minutes are a group document.
Can I just add to that just briefly? We heard the Human Rights Commission say that there was a handful, and she finally defined it as 10 over a 5-year period, and she couldn't even define if there was actual discrimination. She just said that was the whole pot of cases she had. So what we're trying to do here is pass a law where there's virtually very little. We can't even define it because there is no systemic data to show that there is discrimination, and then create all these other problems. But you're talking about, you're saying that some of the problems you're hearing are from the co-op board members. Let me tell you, and this, you really need to take this very, very seriously. When a person comes to a co-op, the co-op is looking to bring that person in. That's what we do, co-op housing. So there is a lot of flexibility that the co-op works with. We have an older senior resident. We'll kind of look at things to try to get them across the line. If you pass this bill, I guarantee you that if the credit score says it must be 650 and somebody comes in with 649, they're not going to be approved, because what's going to happen, as Mr. Jumaane Williams said before, we're going to look at the reasons, and now we can go back at the others and see if you did the same thing. So we allowed a 75 or an 80-year-old woman to come in who had a 649 credit score, and now somebody else is coming in with a credit score of the same thing, although we require 650. We're not going to allow her in because we're not going to take the chance that, oh, you allowed that person in with a 649, but you're not allowing that person in. So that flexibility will come to a complete halt. And I'm telling you, what's going to happen is that any flexibility is going to be gone totally. So those vulnerable, the ones who are making a lot of money, there's no problem. They're always going to get approved. But those vulnerable applicants are going to be denied because the co-op is not going to take a chance of somebody coming in and saying, you granted that person the approval with 649, but you didn't grant that person. So we're just going to not approve anybody, and that flexibility is so important in a co-op environment. And this bill, I'm telling you, I've been on the board for 40 years. I'm the president of the largest garden apartment co-op in New York. That flexibility will come to a screeching halt. Please be aware of it, because it's those vulnerable applicants who are going to really be affected.
Okay. Well, thank you so much to
Thank
this
you.
panel. Appreciate your testimony. Gary Martin, Michael Bonfiglio, Nathan Lichtenstein, Meg Goebel, James Sparks. There are free drinks at the end of this. Just kidding, there aren't. I'm sorry. I got kids. I can take it. Whoever is ready can begin.
Good afternoon. My name is Gary Martin. I live and have lived for 35 years in a cooperative apartment that I own in Brooklyn. My wife and I have raised our family there. As I think I said, we've been there 35 years. It's a small building. Certificate of occupancy shows we have 5 units. I've been the treasurer of the co-op for 25 of the past 35 years on a volunteer basis. I'm here to tell you that I oppose these bills. Why? We just elected a mayor who ran on a platform of, let's make the city of New York more affordable. These bills will make the city of New York less affordable. They will increase transaction costs for buyers of co-ops. They will increase transaction costs for sellers of co-ops. They're going to make the operating costs of co-ops go up. That doesn't make the city more affordable. It makes it less affordable. I got 2 minutes. I can't go through all of my reasons. I'm just going to focus on 407, all right? No co-op is going to turn down an applicant if this bill passes without first drafting a letter, running it by a lawyer, having the lawyer say, it's okay, it won't get you into trouble, or at least it minimizes the chances of trouble. Lawyers are not free. They're really expensive, especially the really good ones. Insurance companies, when they find out that they're going to have an increased risk of litigation with a co-op, even if it's meritless litigation, they're going to raise their premiums. Co-ops are going to have to consider increasing their coverage. And beyond that, the individual owners of co-ops are going to have to consider increasing their own personal liability insurance, because when the lawsuit comes, it's not going to just name the co-op. It's going to name everybody else in the co-op who might have participated in that decision. Every other point I'd like to make has been covered extensively, I think, by other people. I've been here all day listening. So I'm going to stop right here. I'm going to say thank you, and please vote no on these bills.
Thank you.
You're welcome.
Good afternoon. My name is James Sparks. I live at 645 West End Avenue, and I'm on the board there. As a treasurer, I'm concerned about expenses too, and that's basically why I showed up today. And I thought I would address my remarks to 438, which is disclosure of information to purchasers. If a good broker is working to sell an apartment, they have most of this information. They have our financial statement. The minutes of our meetings are available to the purchaser's attorney. What are the other ones I had here? Excuse me. Anyway, I went off script and I lost my way already. But our data is available to a purchaser before they sign the contract. For them to be able to ask for current information from a corporation that works on a fiscal year, not a fiscal month, week, or day, to produce information is kind of speculative. And it really wouldn't do them any good at that point anyway, because they've already signed the contract. And it's probably not possible to renegotiate. Why should the seller renegotiate once the buyer has made their commitment? So if we do produce the information, it's got to be reviewed by attorneys, accountants. Our accountant could provide information. Our attorney charges us $585 an hour. If it involves our capital project, which is one of the things that we disclose to the brokers, our engineer charges $400 an hour. It could happen in such a way, as has happened recently, where in the middle of someone's application process, the complexion of a project we're working on changed dramatically. And they could have already requested the information. A second buyer could come in after that with this new information and get a completely different answer from me 2 weeks later. So I can leave it at that. This has been a long afternoon, but I think you get the gist that I'm not sure what this can do for people who are concerned about rising maintenance and assessment charges, which is what I understand this bill was originally introduced for. Thank you.
Thank you so much.
Hello, my name is Meg Goebel, and I am the secretary of the board in which I live, 75 Livingston Street. I also am a real estate attorney, and for 40 years, I have represented buyers, sellers, and small to mid-sized co-ops. Since there doesn't seem to be a lot of data, I mean, I can just give anecdotal evidence that in the 40 years that I've been involved in the co-op sphere, I could count on one hand the number of rejections. And as for rejections that are motivated by some illegal discrimination, I personally have never been involved with that. And I did represent small buildings and mid-sized buildings in Manhattan and Brooklyn. The chairman asked for suggestions. Just don't tell us what's wrong with this. How could we make this better? So I want to limit my remarks to that. Instead of a reasons letter, since the commissioner of the Human Rights Commission said they don't get a lot of complaints, if you give a rejection, why not then advise the purchaser? These are your rights under the New York discrimination laws. You could go to CCHR, you could go to the state, you can file a private lawsuit. This way, the co-op will be accountable. They will have to present their reason, as opposed to trying to formulate a reason. The gentleman who spoke before about flexibility, this is very critical in the board that I sit on. We try to make a way to get someone in. So if it's like requiring an escrow or whatever, because we want new people and we want to be fair to our neighbor, the selling person. So just one additional suggestion on the timeline for applications and getting a response. I would just ask the committee, the council, to take notice that the standard co-op form contract, which is used in 99.9% of the transactions, 6.3 allows a provision that if the does not act by the scheduled closing date, there's automatically an additional 30 days added. And if the co-op still does not act, either party is entitled to cancel the contract. So the brokers and people who spoke about people getting stuck in deals for years and whatever, they have not read the co-op contract. There is an out. But in terms of the timeline bill, to have it deemed accepted, the buyer is deemed accepted, that seems to be an extreme remedy. Thank you.
Thank you.
Thank you, Councilmember Sanchez, and to, I guess, who remains of the committee for the opportunity to testify.
They're all listening online.
Good, all in spirit. My name is Nathan Lichtenstein. I'm the proud president of the 315 West 55th Owners Corp. We're a 42-unit co-op in Hell's Kitchen in Council District 6. My husband and I have called our building home since 2018. I've been on my board of directors since 2020. Co-ops make up the second largest group of owner-occupied housing in New York City and are the housing class most readily purchasable for under both $800,000 and $400,000. Co-ops provide long-term, affordable, and sustainable housing for New Yorkers. We've listened to some members of this committee go on a fishing expedition with CCHR and HPD and come up either empty-handed or inconclusive with data. Why is it that this council is so intent on targeting an important class of homeowner in this city? From walk-up buildings to those with white-glove doormen, co-ops are among the only corporate owners of housing in this city who do not have a profit motive. Our motive as a corporation is to maintain our homes. Would this council tell a single-family homeowner that they are required to consent to the sale of their home within a certain amount of time, or it will be done so automatically? There's no way. Intro 1120 is just an overreach into the private affairs of New Yorkers. Would this council require a single-family homeowner to turn over every receipt detailing each dollar they've spent maintaining their home, or to outline what work they think their home might require in the future? Again, there's no way. Intro 438 is going to expose sensitive information to an outside party without any real legal framework. Further, it's uniquely shifting the burden of personal responsibility in co-op purchases away from the buyer, their attorney, and their real estate broker, and it's pushing it onto the seller and the co-op. Would the council subject a single-family homeowner to threats of perjury and financial penalty when declining an offer to sell their home? Again, there's no way. The Federal Fair Housing Act, the New York State Human Rights Law, and the New York City Human Rights Law all may I close out?
Please.
All prohibit housing discrimination. Intro 407 will not make housing any more equitable in the city, but it will disincentivize the volunteerism that is desperately needed to run our buildings. Co-op owners are homeowners. We deserve to be treated equally as such. Before we enact new legislation, this committee needs to shore up its data and, more importantly, engage with the co-op community. Thank you.
Thank you.
Hello, my name is Michael Bonfiglio. I wanted to thank the council for allowing me to speak. I'm a treasurer of the Building and Sunset Court Association in 4002 7th Avenue in Brooklyn. I've been on the board 20 years now. I'm opposed to all three bills being proposed, but especially Bill 407. In the entire time I've been on the board, every attorney we've worked with has always advised us not to put specific reasons for why we're denying someone, because it opens us up to liability. And there, people don't want to volunteer when there's added liability. I heard other council members say that it doesn't increase liability, but it surely does, because once those reasons are down, it could invite lawsuits. Those lawsuits don't necessarily have merit, but they could happen anyway. Right now, we're having an issue with lawsuit that is involved with a dispute between two tenants, and the whole board's gotten roped in, and because of that, our directors at operatives insurance canceled on us at renewal, and now our new fee is double. So these do have real consequences, and just want the council to take that into consideration. Thanks.
Great. Thank you. I just have a clarifying question for Nathan. On 1120, did you say that this is an overreach into private affairs because the bill would force sales?
So my understanding of 1120 is at the end, there's a forced consent to sale if the board fails to act, or at least in a draft that I read. Is that correct?
I don't know. That's why I'm asking you. Yeah. Yes.
That's
Okay.
So
It would be deemed.
it's
Deemed approved.
It's deemed approved, right? So
Okay. Well, it's deemed approved when the buyer and the seller have agreed and the co-op has not responded. Was that everybody's interpretation? You can
Correct.
add. Okay, great. Thank you. That's helpful, and something that I'll take back to the bill sponsor as a concern that I certainly understand. Okay. I think your echoes of other concerns is very clear. So I want to thank this panel for your time today. Stay for the drinks. Just kidding. Mitch? Next up is Mitch Levine, John Viteri, Melissa Mark Shin, Allison Mason, and Stuart Saft. And if there's folks in the overflow room, come on in. There's space here for you now.
Is there anybody in the overflow room? No. Okay, great.
Wonderful. Stephanie Spadaro, John Koza, and Carol Baird. We're getting to the part where we're trying to fill in seats. Carol Baird. Okay. Jill Eisner. Brittany McKenzie. Joseph Garcia. Excellent. Okay, and whoever is ready can begin. Oh, you're gonna have to fight to the finish. Oh, just kidding. Just kidding.
I'll bring her back. We called her first.
Cool. Can I start? What's your name now? Okay, I'm sorry, Joseph. You're after Brittany. I didn't see her stand up, so you have to switch. Sorry about that. But you're up next, Joseph.
What's that?
You're up next. Yeah, sorry, I didn't see her stand up when I called her name. Next panel. Yeah. Sorry about that. No, I mean, if you're still here, you're the diehard crew. Okay, whoever's ready may begin.
Good afternoon. My name is Melissa Markshee, and I'm here to express my opposition to intros 407, 438, and 1120. While it would be disingenuous to say discrimination in housing in New York City doesn't exist, and the reasoning behind these bills is well-intentioned, it's equally disingenuous to paint all co-ops with a wide brush and not fully consider the financial ramifications to current co-op shareholders when our city is experiencing an affordability crisis. For the last 19 years, I've served as a board member and currently serve as the board secretary of a modest 26-unit co-op on the Upper West Side. In that time, we have never once been unresponsive to an application, and we have rejected exactly one applicant upon learning in their interview that they intended to use their apartment as a short-term rental, which our bylaws prohibited. In our building, many shareholders, especially seniors on fixed incomes and young families, already struggle to manage with rising costs. Taking this into account, our board meticulously manages our finances through a lens of affordability. The cost of managing a building obviously increased from year to year. However, insurance premiums have skyrocketed. Ours increased 51.7% from this year over last year, a figure I confirmed with our broker this morning, who also informed me that he can't project how much our insurance will go up, but will absolutely go up if these bills are enacted. These bills will only add to the burden of maintenance by increasing insurance costs even further, and create further strain of affordability for our residents who are not wealthy. The proposed requirements would expose co-op corporations to frivolous lawsuits while also significantly raising the shared legal expenses that every shareholder would bear. The mandated justifications for applicant rejections will expose individual board members to legal risk, and the 10-day response requirement and automatic approval of an applicant for non-adherence is unreasonable. Living in a co-op is a social contract that can't be forced by bureaucracy. All of these create onerous expectations on volunteer board members who have families, jobs, and responsibilities. We already act efficiently in responsibility because our community expects it, not because of penalties.
Thank you. Did you conclude?
I did not conclude, but that's okay.
Do you want to conclude?
I would just say that in conclusion, proposals 407, 438, and 1120, while well-intended, duplicate existing fiduciary obligations and add unnecessary costs for co-op residents, many who live on fixed incomes. Given there are other outlets for recourse, including those outlined by CCHR, I respectfully urge you not to move forward with these bills. Thank you.
Thank you.
Okay, let me do this way. Okay. Hi, my name is Mitchell Levine, and thank you, by the way. And I have to commend the City Council. This hearing has been extraordinary, really. The amount of information, the civility. I think if all government operated the way you were operating now, we'd have a far better society. It's an aside, but really, it's remarkable. I'm Mitch Levine. I live in a co-op in the Upper West Side, 630 units. I've been on the board 41 years. In 41 years, we have rejected 2 applicants. We work tirelessly as a board, and we are a self-managed building, but we work tirelessly as a board to make sure that applicants understand what our requirements are in advance of applying. We don't want anybody to be rejected, but we do have requirements that ensure the fiscal stability of our building, and also that the person that's coming in understands that they're moving into a community, not to a single family home. A lot of people don't understand what a cooperative is, and it's important that when we do this, that they understand that, and that's what their responsibility to the entire community is. These bills will cause distress financially. They'll cause distress in getting board members to agree. I know, although I was a past treasurer, but I'm not currently an officer of the corporation, I would not sign that document. Anything that says I'm responsible for ensuring that no discrimination took place under penalty of perjury, a criminal offense, is something I could not even abide by. And I can't speak to what my other 9 members would do. I mean, we assume that we are operating in good conscience and we explore everything that goes on. There's no application that does not get full consideration by 9 members, right? As well as our managing agent who tells us when we're coursing into an area that's not appropriate. I will oppose it, but I will say, if I may continue, I think the missing part of this is education. I think that what goes in the application is of critical importance, and every board should be required to have a list of requirements to go into the House. Unequivocally, they should spell out the timeline. We tell our applicants that they have 2 weeks to apply. We have 2 weeks to get the application to the board, and then according to the cycle that we have in terms of when we're meeting, it could be any place from 15 days to 45 days in addition to that. However, when we actually interview the applicant, we say to them all the things that they're responsible for. If there's a question about the finances, it could take as much as an additional 15 to 30 days to get the documentation that we need. Our objective is to accept every single applicant that comes to our building. And we tell our brokers to make certain that they share with their client exactly what our requirements are. I think that the overall intent is fine, but the mechanism that you're using, the penalties, the timelines, I don't think it works, and I think it's going to burden co-ops and it's going to change the way we function. I know certainly it would in ours.
Thank you. That's very helpful feedback. Thank you.
Does this work? Okay. Hi, thank you for giving us the opportunity to testify. My name is Carol Baird, and I'm a retired children's dance teacher who bought a co-op apartment in 1993 at 645 West End Avenue that has 73 apartments, and I just recently joined the board. And I've seen that a co-op is kind of a microcosm of a city democracy with much shorter term limits. And it's difficult when a larger government entity passes laws that may sound important, but have a detrimental effect on the smaller entities that have to comply with them. And since my building was converted to co-op apartments in 1984, real estate taxes have risen 3,400%. Insurance costs, often due to legislation passed by the city, have risen 3,380% during that same time. Inflation during that time was 204%. So the city coffers have certainly benefited from co-op owners. And a key word that gets bandied about is affordability, but the council wants to pass legislation that puts a bigger compliance burden on co-ops without a discernible thing. And I, as everyone else, worries about frivolous lawsuits. I'm worried about being a board member now. I actually called Jumane Williams' office over a week ago to ask what the reason was behind the proposed legislation. No one got back to me. So I also emailed. I got no response. So I called the New York City Commission on Human Rights and asked them what recourse was available after being rejected by a New York City co-op board, not for financial reasons, but for discriminatory reasons. They were very helpful. They gave me all kinds of information on how to file a complaint and also referred me to 2 other city agencies that could help me. It is also my understanding that the last time that similar legislation came up in New York City, the Commission on Human Rights testified that there was no real basis, which I kind of heard today when I heard they had 10 cases over 10 years. Can I conclude?
Please.
Okay, so I urge the council not to pass legislation that makes it more expensive and onerous to live in a co-op apartment in New York City. There are already regulations in place to combat discrimination. It seems like what we need more of is outreach and oversight on the legislation that exists rather than additional legislation.
Thank you.
No green light.
No, that's it. Red's fine.
Oh, okay. Hi, my name is Jill, and I live in a co-op, and I'm going to speak to Intro 438 and to one of the unintended consequences to this bill. It opens the door for lawsuits on capital plan changes. Co-ops juggle multiple local laws, every day a new one, where we have to investigate how to upgrade to comply. And we look at multiple solutions and options. And those could be in our meeting minutes. And if we issue that to a prospective buyer and we don't follow through, we can be sued. How is that in this law? Planned products don't always get executed. Why is this discriminatory? We plan to do our windows for 8 consecutive years, but things like backflow preventers, which has never been used in the history of the city, which we had to put in our basement, which is ugly, had to be put in. We had to replace our boiler. We have local law, whatever, 87, 88, 111. So the windows were pushed and pushed. But I'm going to get sued because I didn't follow through on a capital plan. This is just, it's just not fair. My co-op is 33% senior citizens, 21% receive STAR benefits. It's all studios. And these people can barely afford living on Social Security to pay their maintenance. And now they're going to be subjected to increased director insurance costs, to increase, we're going to have a legal fund reserve, a legal reserve fund now, which we've never had before. I find this very gratuitous. I think that Bill 438 needs to be totally rewritten. I'm not quite sure what it's trying to achieve at all. And I'm very proud that my council member and none of the other council members in the surrounding districts, nor Gail Brewer, is supporting this bill. Thank you for your time.
Thank you. Next.
Hi, good afternoon. My name is Brittany McKenzie. I'm the Policy Director at the Fair Housing Justice Center. Thank you for the opportunity to testify on Intro 407. We urge the Council to pass this bill and reject any amendments that would weaken its core purpose, transparency. Co-ops offer one of the strongest home ownership opportunities and pathways in New York City, with over 450,000 units that support long-term stability and generational wealth. But too many applicants who do everything right, secure financing, sign contracts, submit full applications, are rejected with no explanation. This secrecy creates an environment where discrimination, intentional or not, is unchecked, can thrive unchecked. The harms are very clear. First, secrecy shields decision makers from accountability. Second, it makes enforcing fair housing protections extremely difficult. Third, rejected applicants have no idea whether the denial, was fair or discriminatory. And fourth, this opacity discourages qualified and often unrepresented New Yorkers from even attempting to buy in a building where they are not the demographic norm. 407 is very simple, 407A. If a co-op board denies an applicant, it must provide a written reason for the rejection. That's it. Similar laws already work in Westchester and Suffolk counties, and the co-ops there continue to function just fine. Opposition to this bill isn't about real burdens. It's about preserving a privileged status quo that keeps many New Yorkers out. This is a pivotal moment for City Council to stand firmly for civil rights, fairness, and inclusion, and to say that discrimination behind hidden closed doors is unacceptable. While this won't transform the housing market overnight, it will finally bring clarity to one of the most opaque barriers to home ownership in our city. 407 is practical, achievable step forward. It sends a clear message: no more secrecy, no more exclusion, and no more allowing discrimination to hide behind closed doors. Thank you for your time and your commitment to housing justice for every New Yorker.
Thank you. Thank you so much. And I just want to make a general statement because you guys are the diehards. If you're still here, you really mean it, right? So thank you. But again, arguments, I hear a lot of arguments that my co-op or we don't do this, which isn't compelling to me. I won't speak on behalf of other council members, isn't compelling to me on behalf of the bad actors that do exist. So I just want to call that out because a lot of good information is being shared and a lot of valid, I mean, all the concerns are valid, but valid concerns are being shared that we can use to tailor anything that does move forward. I don't know what will move forward. I'm not the speaker. But I just want to, highlight that specific concern. And just Jill, since you said you don't understand the reason behind the financial disclosure bill, it's not a bill that is about fair housing. It's a bill that is about making sure that prospective buyers, because it's my bill, prospective buyers have the information that they need. I'm really glad again that you and your board do the right thing. I personally have been declined the ability to review minutes, right? To review. So I, for one, am not saying that this is the set of requirements that should exist in the bill. The bill is a draft, right? And this is why we're having a hearing. But even though you and individuals here don't hold back information from prospective buyers, it's a real big problem when somebody's making the biggest financial decision of their life up to that point that they don't have information. So again, welcome feedback, but this bill is crap. That doesn't help, right? I need constructive feedback from you all so that we can get to the right part of this version of this bill. Yes, we'll go 1, 2, and 3.
So the part that I didn't get to cover is that I don't remember her name, but the woman representing CCHR made a valid point that there really isn't enough data to justify many of the provisions in all three bills, and we're giving you data by saying we've rejected one person, we've rejected 5 people, we've rejected. So I don't think that necessarily it's anecdotal when it is actually valuable data when you have enough people testifying to the fact that this is not happening in their buildings.
And you would not be giving us that data if we didn't have this hearing.
Right, no, absolutely. But my question then also is, what data are you relying on? Because it seems like many people, particularly Councilmember Dinowitz, basically said there isn't data to support it. And it would make sense to me that a bill would be crafted based on data, not to collect data.
Well, these aren't all my bills,
I know.
but I said at the hearing 2 weeks ago, where we were similarly still here at 6 p.m. It's 3 p.m., y'all. It's early. But when we were listening to testimony around the short-term rental bills, that I am completely against those pieces of legislation, but I don't shut down debate, right? I think democracy thrives when you're able to express what you believe in, what is your data, and all of that. So I do believe that there is a problem here. We know it anecdotally, but broadly anecdotally. And so your information, the information that we heard from the different associations of realtors, really help us to start to understand. And maybe the bills, go in the direction of helping us collect better information than what we have today, or maybe we have debate now that allows us to collect more. But really, that's what this hearing is about. For you all who are the most dedicated, it's about collecting information from you all about where we can go if we go anywhere from here. Please.
If I may, the issue that you had brought up specifically about information, the Attorney General's office, which does not broadcast what it really is intended to do relating to regulating co-ops and condos, but really has a voice in that. And I think the lack of information and education, once again, is what's prominent in this. If you had that information and you called the AG and you told them you couldn't get the information that you requested, then they would initiate an action to ensure that your board provided you with whatever is required under the law. There are laws that currently exist, and you're right. They don't have necessarily the teeth, but even those that do have the teeth, the reason why that there's no application of it is because the people remain uneducated. And I'm a former teacher, so education is the way I believe movements are made. People have to understand what their rights are. They have to understand how they can avail themselves of those kinds of rights. And I think that that's what the responsibility of the council is in terms of insisting, because you represent the city government. The city government should be providing this information on a much broader scale. We as board members are required to take courses and sign off that we understand what discrimination is. We understand what sexual harassment is. The same thing should be true of all board members, by the way, to accomplish the same goals that you want to accomplish. Then every single board member will be required to take it and sign off on it and say that they understood now what the law is, and they will be held accountable. So there is a way of doing it without being so onerous that we are all testifying because we're concerned about our way of living in our co-ops. This is not about an issue of anything other than we are inclusive, by and large. Maybe 95% of the people are inclusive in the way they consider everything. There are always bad actors. There are people that pass red lights. There are people that drive drunk. I mean, that's just simply the human condition, and this is where we are. But to basically put such an onerous burden on a class that is attempting to do the right thing, and then even not only that, but causes legal, penalty of perjury in the context of a law, or automatic recovery of legal fees, which is an avenue how all the lawyers who are not good players gather classes in order to accomplish not anything for anybody else other than lining their own pockets. And you're enabling that. So I laud your goals. I really think it's important. But I think that you have to approach it in a way that we're not the bad guys. We're not the bad actors. We have to be acknowledged that way.
Thank you. Thank you.
I still don't understand why changing capital plans, which happens all the time, this building, I'm sure when you built this room, I heard it's brand new and you love the buttons, or that's what Dinowitz said. I'm sure that it didn't happen perfectly. I'm sure you had to change, the guy that did the floor, the lights, the ceiling, it was delayed by 6 months. And in that time, a new councilman came in, and all of a sudden we can be sued for that because there's a change in the capital plan. That's in your law 438. That's what I don't understand. I think that the unintended consequences of covering everything can hurt, and you don't even realize that. And a lot of laws that are passed, I know up in Albany, because I follow a lot, I'm very close to my assemblywoman, they have to retract them and rewrite them because of the unintended consequences. So we're trying to tell you that that part should really be looked at because capital plans change every day.
Yep, that's great feedback.
Thank you.
Appreciate it. Yep. All right. Well, thank you so much to this panel, and thank you for sticking with us. Joseph Garcia, still here? Yeah. Corinne Arnold, David Fitzbury, Matt McClanahan, and Jordan Barowitz.
Can I have as much time as that first guy who spoke?
I will allow you to conclude when your time is up. Just want to call a couple more names. Mestawet and Dialalu, Clifford Dupree. Seeing no one rushing to stand. Jerry Moore Murray. Yvonne Pena. Jesse Horwitz. Brendan Cheney. Yeah, right. And Ariel Hirsch. Julian Parker. Oh, Ariel. Yes, Ariel's here. No, not Julian. If Julian is here, not yet. Okay. Next one. All right. And whoever is ready can begin.
Okay, my name is Joseph Garcia. I'm a board member, vice president, and shareholder of 4077 Owners Corp. on the west side. It's a nearly 100-unit co-op with many retirees, seniors, and widows. Although conceived with good intent, I'm here to express our concerns in opposition to 3 bills, as thorough consideration of downstream consequences point to a disastrous outcome for the nearly 1 million New York City co-op residents. With respect to Intro 407, it imposes nearly impossible constraints in the admission process that discourages board service, which I should emphasize, and has been emphasized before, is a voluntary, elected, unpaid, uncompensated position. The existence of this bill has already caused deep concern among our current board members, and co-ops will spend excessive legal, insurance, and administrative fees to assure board members, or assessments will be farmed out to third parties. The consequence will be increased costs, which will be passed to shareholders in less diverse, less equitable, and less inclusive communities. Intro 438 mandates release of unofficial documents, estimates, or statements to prospective purchasers. It will stifle discussion of pending costs, as mentioned earlier, that are imposed by New York City, New York State, or the federal government. The consequence will be reticent boards adverse at playing a co-op at risk for litigation simply for being responsible and proactive. Intro 1120A imposes unrealistic timelines and impedes the fiduciary responsibility of co-op admissions. It effectively forces boards in some cases to consider inaccurate, inconsistent, incomplete, or fraudulent applications. The consequence may be forced acceptance of irresponsible individuals, some of whom could threaten the environment, finances, and even safety of vulnerable co-op residents. New York co-ops are a shining example of how well communal housing functions when managed by and for the people. Despite the tone of the bill's authors and some of its supporters, the human rights reps, as testified earlier, have confirmed that discrimination by co-ops is virtually a non-existent problem. Given these concerns, we respectfully urge the Council to reject Intro 407, 438, and 1120A.
Thank you. I thought you were going to take more time.
Well, I can, so, but I'll wait until later.
Okay, thank you.
Hi, Chair Sanchez, member of the committee. Thanks for holding this hearing and for the opportunity to testify. My name is Ariel Hirsch, and I'm the Director of Policy and New Projects at UHAB. We work with about 1,200 HDFC affordable cooperatives in the city, and we really appreciate the initiative of the council in holding today's hearing and encouraging transparency in co-op decision making. I think we share many of the same goals. We also, spend a lot of time with HDFC co-op boards, helping them to make transparent, consistent, and equitable decisions in compliance with all of these laws and more that we're talking about. I think we agree that many of the issues that we're naming here do in fact exist, and there are a real variety of actors. That said, I think the stock of HDFC co-ops specifically is a little bit different from so many of the market rate co-ops that these intros are directed at. Similar, these are volunteer board positions, but substantially differently. These are led by working class people of color, many elders, similar, and also folks who are experiencing real difficulty and hardship, as you well know, complying with a lot of existing local laws and regulations. These are portions of our affordable housing stock that are much more likely to house people of color, immigrants, and other marginalized groups with lower incomes than market rate co-ops. We also have some interesting research that indicates that HDFC co-ops are more likely to accept voucher holders compared with other kinds of housing, subsidized and market rate. This slightly different pool of housing, I think, really, in this case, deserves some differential treatment here. And we would recommend that HDFC co-ops be carved out of Intro 407, Intro 438, and Intro 1120. I will submit more testimony with further details, but I think the sort of compliance differences here include that we have HPD, sorry, may I continue? We have HPD Oversight, and a regulatory agency that is tasked with specifically overseeing the operations of HDFC co-ops, both ones that have regulatory restrictions with the city that are active, which I see are already carved out in many pieces of the legislation, in addition to those that are not. We also have a large sort of financial and regulatory cliff coming up in 2029 with the expiration of the damp tax cap, which over 80% of HDFC co-ops receive, and that is a real moment to bring HDFC co-ops back into larger regulatory compliance in close coordination with the agency and stakeholders. And I think that there are many ways to achieve those aims for this specific population on that sort of timeline, with this larger focus on regulatory sort of restrictions, tax abatement, carrot stick, all of those kinds of things together, and would really like to talk more with the council about achieving those goals for this specific population within that framework.
Thank you.
Thanks for the time, always.
Thank you, Ariel.
Good afternoon. My name is David Fitzhenry. I'm a real estate attorney. I am a member of the City and State Bar's Co-op Condo Committee. I'm the current chair of the City Bar's Co-op and Condo Committee. I'm an adjunct professor teaching a course on co-ops and condominiums at law school. I'm appearing today not in any of those capacities, but only because to echo the concerns that I've been hearing throughout the community and with respect to my clients. My firm currently represents approximately 150 co-op and condo buildings across the New York area. I think the intentions of these bills are noble. They're in the interest of justice. They fight discrimination, but unfortunately, it's not necessary. It's not necessary because there are already avenues for recourse at the city, state, even the federal level. That being said, even if it was unnecessary, I might be able to support it if it caused no harm. Unfortunately, it does cause harm. And it's multiple ways that it causes harm. One, we've already discussed today. This will result in significant increased costs for all co-ops across New York. It will have increased insurance premiums. It will have increased legal fees. And it will also have increased management fees, administrative fees. That's undeniable. It will also have a chilling effect on the spirit of volunteerism that every co-op relies upon. As far as the purpose of 407A is to deter bad actors. Bad actors will not be deterred by this bill. If they are willing to break the law and discriminate anyway, They are not going to be deterred by signing a sworn statement, lying about the reasons for rejections. Currently, most applications, may I finish?
Yes, please.
Most applications have an interview process as well. And those board members have the ability to reject someone based upon an interview that they did not like. They didn't like the cut of someone's jib. They didn't like what they wore. They didn't like their attitude. All of these things are legal, permissible reasons. These things will be used as a pretext by bad actors to simply deny people. This bill does not accomplish what it is designed to accomplish. Passing this bill will only result in increased cost and less affordable housing, which has been a recurring theme throughout the day, that affordability is the biggest issue the city is facing in terms of housing right now. Thank you.
Thank you.
Good afternoon. My name is Brendan Cheney. I'm Director of Policy and Operations at the New York Housing Conference. Thank you for the opportunity to testify. New York Housing Conference strongly supports Intro 407. The legislation uses a common sense approach to help prevent discrimination in co-op sales. There are reports of discrimination in co-op sales, and co-op boards should not continue to be allowed to operate in secrecy and perpetuate housing discrimination. By simply requiring transparency in the reasons for blocking a sale, co-ops will be less able to quietly discriminate and deny people the opportunity to buy into a building and enter home ownership. We have made recent strides fighting against discrimination in housing. We successfully fought for a state ban on source of income discrimination against renters. We fought for equitable production of affordable housing with our New York City Housing Tracker, and the City Council passed the Fair Housing Framework and City of Yes. It is time to level the playing field and fight discrimination on entry into homeownership. We strongly support this legislation and urge the committee and the council to pass this legislation before the end of the session. Thank you for the opportunity to testify and happy to answer any questions.
Thank you, Brendan.
Thank you, Chair Sanchez. I have to say I'm very impressed by your patience, and I'm very thankful to you for asking for collaboration. I'm Matt McClanahan. I'm the treasurer of the 310 Apartment Corporation, a 77-unit co-op. I've lived there for 25 years. I've served on our board for a year and a half. And I would love to collaborate with you. But I have to oppose 407 for 3 reasons. The problem is unproven, the enforcement is disproportionate, and the remedy I don't think will work. So let me go through them. As a gay man and a member of a protected class, I've seen no discrimination. Now, I know that is unmoving to you, that you said earlier that you're not moved if I stand here and say I'm one of the good guys and we don't discriminate, right? But what I see today in the hearing, I just have to push back, because the earlier comments from people on the council, from people on the committee, were kind of like, everybody knows there's a problem here. Everybody. And I always have to answer that with, really, everybody? Buddhist monks in Tibet know there's a problem? Because you know, like, I'm part of everybody, and I don't know there's a problem, right? I understand your concern about the opacity. The city has done no serious investigation. There's been no statistical analysis. We saw today there's no data collection. There's not a lot of evidence of discrimination. There's not a lot of evidence of systemic discrimination, right? And if the problem is unproven, any enforcement is disproportionate. The 5-day each and all reasons standard, affirmed under penalty of perjury, it's way too heavy a burden on volunteers. We already struggle to fill board seats. Oh, may I finish? I promise I'll talk faster.
Please.
At our last 2 elections, directors ran unopposed, partly because of all of the work we're having to do with all of these local laws that have come through, which are all well-intentioned and important. If you add personal criminal liability to this, you're going to weaken a volunteer governance model that makes affordable co-ops work. And the last thing I have to say is I think the remedy will be ineffective. You're not collecting any demographic data with this bill. You're giving a letter to one person, an individual letter to one person with a list of reasons. Without demographic data, it's going to be hard to expose discrimination patterns. You can't detect disparate treatment if you don't track who's being treated differently. Real anti-discrimination enforcement requires data, demographic information that reveals patterns, not just individual rejection reasons. I urge you to find another way to work with the Commission on Human Rights to collect optional demographic data from people as a part of the application process. The boards should not be involved in collecting this data. It should just be collected as a part of the application process. That's the foundation for any serious discrimination investigation. Find out if it's a problem, and then we should probably, and then if it is a problem, then we really should do something about it. And you'll know where to look, because you know what? You'll have the data. So that's my opinion, and thank you very much for allowing me to speak.
All right, thank you. Thank you, Matt. I want to go back to you because I promised you extra time.
So are you going to ask me, or do I have extra time? Go ahead.
Extra time to expand on anything that you wanted to.
Okay, good. Thank you for this extra time. I want to emphasize that there's really been no hard data here that's been presented. It's really hearsay. When pressed for numbers, the numbers were very scarce at best. And in fact, I have a question for you. For those realtors that came up here and who brought these examples of discrimination, which have not been documented, why did they not point those applicants in the direction of the Human Rights Committee? There would be actual numbers there. And so I have to conclude in my profession as a scientist that there are lacking information, and therefore the claims are unsubstantiated. And you know, if it's unsubstantiated, then why are we even considering these measures? Okay.
Thank you. Thank you. And so I will respond to you all to please continue to send your examples from your co-ops, how many rejections over however long you've served on the board. Have you personally witnessed, and what reasons, if you want to share that with us? And we're going back to the realtors with the same information. We're going to go to the Attorney General, request this information. We're going to go to as many sources as we can because anecdotal information is helpful, but not enough.
They clearly did not receive the education that's been advocated for board members, and they really should be encouraged.
I have to say, and this is really important, anecdotes are not data. They're a kind of information, and they can begin to tell a story, but they're subject to all kinds of bias and all kinds of confirmation bias, all kinds of interpretive problems. If this is a problem, we need to understand what it is. And I'm totally in favor of that, because if there is discrimination, I would want it to be rooted out. Having been a victim of discrimination in my life, which is nothing compared to the stories of, I'm sure, some people, I hated it, right? And I would never want anyone to go through that.
Yep. Thank you. Thank you so much to this panel. Really appreciate your time and for sticking with us. Julian Parker, Eric Blaha, Tabitha Ward, Lucy West. Let's see how many seats. Logan Fairs, Amber Schwartz, okay, and whoever's ready can begin.
Good morning, Chair, members of the committee. My name is Julian Parker. I'm the founder of Solid Ground and a Robin Hood Foundation Blue Ridge Labs Founders Fellow. At Solid Ground, our focus is on converting underused office space into deeply affordable shared housing for New York's essential workers. These are our teachers, childcare providers, nurses, and social workers, the people who keep the city running. I'm sure you understand the severity of the housing crisis, so I won't go into the data there. What I will say is, for single adults trying to stay rooted here, the current system doesn't work. The legislation in the shared housing bill is one of the first real structural steps toward closing that gap. It recognizes the way people actually live today and finally unlocks a housing type that meets that reality with dignity. But I want to highlight something that the shared housing roadmap expresses very clearly. What makes shared housing work is not the floor plan. The key to success is how the space is managed day to day. New York has already seen what happens when communal housing is managed poorly. When there are no standards or oversight, even well-meaning operators can inadvertently create conditions where discrimination goes unaddressed, support breaks down, and residents are left unprotected. Many residents, including myself, have experienced versions of this in today's unregulated co-living environment, and those outcomes aren't inherent to shared housing. They're the result of gaps in standards, oversight, and the day-to-day management practices that keep buildings safe, clean, and predictable. The strength of this legislation is that it begins to surface and close those gaps. It sets a regulatory foundation so the next generation of shared housing is consistent, transparent, professionally run, privacy protected, and built on clear, enforceable standards. The people running these buildings will need to deliver on those standards in the way residents actually need day to day. That includes things like real bathroom privacy, personal fridges. Sorry, may I continue?
Yeah, you may conclude.
Personal fridges and pantries and predictable mail access for long-term stability. They must manage these homes with the discipline and efficiency that ensures public dollars go further, not forever. And at the end of the day, the point is to create homes that actually support the people, keep the city running. Homes where stability, dignity, and opportunity are the norm, not on just day one, but year after year. This work is not in isolation. We're prepared to help convene or join any working groups of operators, tenant advocates, labor partners, and building owners to support the alignment of this new category. Our priority is making sure that this works in practice. To support that work, I've also developed some recommendations on operator standards, conversion pathways, and long-term affordability. I'm happy to share that with the committee as well as HPD as the framework moves into implementation. This is going to finally give essential workers affordable, high-quality options built to the New York standard, a standard that once again positions this city as a leader in solving one of the defining housing challenges of our time. The Shared Housing Bill provides a foundation for that ecosystem to emerge responsibly. It's a necessary and timely step, and I strongly support its passage. Thank you for your time.
Thank you so much.
Good afternoon. My name is Tabitha Ward, and I would like to offer some solutions to allow New Yorkers to participate in affordable housing. One of the solutions also will include the repairs of affordable housing is to allow all tenants or all renters, to include those who are receiving housing vouchers or rental assistance, to hire outside contractors to come in and make repairs and or replacements for major appliances if and when the landlords do not respond to the work orders in a specified period of time. These outside contractors could be required to adhere to a specific list of qualifications. The tenants would then pay the rent minus the cost of the repairs and provide the original receipt to the landlord in explanation for the unpaid rent amounts. For large and extensive building-wide repairs, the city should withhold, not just suspend, but withhold any and all federal, state, and city fundings to allow the fundings to pay for the repairs, and instead of sending the bill to the landlord, send them the receipts. Just because you send a bill to a landlord doesn't mean he's going to pay it. However, you should send the receipts. To allow all interested landlords to participate in the city's affordability housing crisis by allowing prospective tenants to receipt their way into affordable and rent-stabilized housing. The landlord should allow the prospective tenants to hire outside contractors to come in and pay for the move-in preparations, the repairs, the cleanups, any major appliance replacements, and bringing the apartment units up to code, and other responsibilities that are necessary to move in and live in the approximately 50,000 apartment units that are unrented throughout New York City. The prospective tenants can then pay to have the apartments made available and to move in and provide the original receipts to the landlords. May I conclude?
Thank you.
To provide the original receipts to the landlords. And the aforementioned will address slumlords, unrepaired work orders, unsafe living conditions, apartment units not being up to code, and it will address the aforementioned that will remedy large building-wide repairs and address the affordable housing crisis that we're dealing with in New York City.
Thank you.
Thank you, Chair Sanchez, for the opportunity to testify in favor of bills being presented today. My name is Logan Ferris. I'm the political director at Open New York, an independent grassroots pro-housing nonprofit working to solve New York's housing crisis. New York is in the midst of a deepening housing crisis, as you know. More than half of renter households are now rent burdened, paying over 30% of their income on housing. And for the most vulnerable New Yorkers, this shortage is not just a financial strain. For many, it means displacement, tenant harassment, and homelessness. At Open New York, we often say that an all-of-the-above approach is required to solve the housing crisis. We need more supply, but we also need deeper tenant protections. We need new, diverse housing options like those allowed in Introduction 1475, but we also need anti-discrimination laws such as what is being proposed in Introduction 407. I'm here today to speak in support of both of these bills. Introduction 407 is a common sense solution that simply seeks to require co-op boards to provide a specific reason for the rejection. Co-op boards acting in good faith should have no issue complying with this law. If we're serious about making homeownership more equitable, we must eliminate the practices that have made it inequitable in the first place. We urge the council to pass Introduction 407 to make it clear that the city will no longer tolerate housing discrimination. Turning to Introduction 1475, shared housing, more commonly known as single-room occupancy hotels, SROs, has a long history in New York City. Though SROs were readily available and affordable housing type for newcomers to the city for the first half of the 20th century, their construction was banned in 1955, and tens of thousands of these extremely low-cost housing options have been lost. We applaud the work that Councilmember Bottcher and HPD are doing to bring back this inexpensive housing option in the midst of a historic housing crisis. While we support the intent of the legislation, we're concerned that some of the requirements outlined in the bill could increase the cost of construction and make their design less feasible, leading to higher rents on units that should be the most affordable option. We look forward to further conversations with the council and HPD to ensure the bill will encourage as many affordable new homes as possible. We'd also like to express our support for Introductions 438 and Introduction 1120. Thank you for the opportunity.
Great. Excellent. Thank you so much to this panel. Appreciate you. Richard W. Mark, Christopher Leon Johnson, and Martha Greeno.
Martha Greeno, I'm the president of a 50-unit co-op, Upper West Side. We've been on the board 25 years. So many people have talked about the admissions. Let me talk briefly about your bill. And I absolutely agree that someone entering the biggest financial decision of their life needs accurate information. Here's the problem. Rand, big New York engineering firm, said our facade project would cost $900,000. 3 years later, it was $4 million. If I am on the hook to somebody who bought in the interim for misleading them, for making the biggest decision in their life, I quit. I cannot afford to continue to be board president. I can't afford to serve on the board. It's too much risk for me. So capital plans, as someone said earlier, are highly variable. It's New York, stuff happens. And the Landmarks Commission, God save us, happens. So annual reports, no problem. Minutes, no problem. Capital plans, not feasible. Let me talk briefly about the admissions. As someone said earlier, nuance and flexibility is really useful. And as the original guy on the screen said, if we are required to be consistent, it's much harder to give people slack. Examples. Before gay marriage was legal, we had a couple who wanted to buy, but in a trust because gay marriage wasn't legal. We don't allow trusts. For them, we did. One African American, one. And they've been wonderful tenants for the last however many years. Another gay couple, guy inherited from his partner after he died of AIDS, who he had nursed him through. His finances were not within our parameters, not even close. We made it work. Third example, current. Young couple got in a graduate program, wanted to be able to swap with another couple so that they lived in the new place during the school year, and another couple who was going to school nearby, near Columbia, they just switched. Not normally acceptable. For them, we made it work. Young couple, they really wanted to keep the apartment. If we can do nuance like that, great. But if we have to be consistent, one, we're going to up our standards. We're going to require more down payment. We're going to require higher financial requirements so that we are not taking on risk, and we will not be able to create individual flexibility that reflects people's situations. So thank you, and thank you for a really impressive hearing.
Good afternoon, Madam Chair. Richard Mark. I am currently the president of 390 Riverside Owners Corp. I've lived there since 1984. I've been on and off the board many times. And I'm a longtime litigation practitioner in New York City, now in private practice, but I have extensive experience also in government, working both for the U.S. Attorney in New York and for the New York City government at the Department of Investigation. I come to speak against 407, 438, and 1120. In particular, for 407 and 1120, I would reiterate the issue of cost that is imposed and the inappropriateness of the remedies. Costs are not just financial, costs are to board recruitment. I have heard already from people, it's hard enough to recruit for the board in this building. The reason I've been on so many times and that certain people serve and serve and serve is because they are willing to undergo the stress. And it is incredibly hard to recruit for these boards. To have that additional layer would make it very difficult. The remedy section, the business of signing the proposal that you sign a statement under penalty of perjury, that is an incredibly serious thing to do, and to do it while making a representation about what you know is in someone else's mind that doesn't really fit a good legal construct in my view. So that also is a non-starter, but it will scare people off. It will undoubtedly, I have already heard this, it will undoubtedly increase insurance costs. And it's not as if you can get actual insurance for, discrimination, committing willful discrimination, but you would have coverage for litigation costs. And again, a lot of the purpose behind bringing lawsuits and whatnot is not necessarily to win, but it inflicts tremendous costs, and people will settle because of that, whether they have a good claim or defense or not. And so it will undoubtedly increase insurance costs. Last point I'll make on this, the structure of a co-op and of the way people want to live in a co-op means that boards are incredibly incentivized to approve deals. We want people to be able to transact, to do the transaction, to get a good value, and to have the sale go through. People aren't sitting there in the back room trying to figure out how to deny their neighbor the ability to move out when they want to move out. They want the deal to go through. They want the price to go up. They want they want that to happen. And so the notion that people sit on these things forever and let them ripen until they rot or something like that is not something that I have seen in my experience and is contrary to the basic financial interests of the co-op. So I don't know that that works. Last point, I agree with the witness to my right. On 438, the business about the capital plans, we had a similar experience with our facade renovation, which happened during the COVID crisis, and the way that the work had to happen drove the cost of that up significantly. And to end up being on the hook for that with the way capital plans go and the way renovations go is just nuts. So unless you have further questions.
Yeah. No, thank you. We're going to move to our third witness, but I just want to say thank you on that specific point on capital planning and also the flexibility. The examples you gave are very helpful. So thank you.
Yeah, hello. My name is Christopher Leon Johnson. I am here to show support for these items on the ticker. But I want to say this right now. My concerns is that I think that you, Mrs. Sanchez, should start making sure that people are really protected in these co-ops. Because there's certain co-ops that are not safe. I used to work in UHAB. I used to work as a security guard for UHAB a couple weeks. And I will tell you that, like in Harlem, that it's a war zone over there. It's a big war zone. And what needs to start happening more in the city council is that they need to start make it where that organizations like UHAB are held accountable for their actions, because UHAB does a lot of things where it's really counterproductive to the tenants. And what it does with UHAB is that it hurts everybody. It hurts the tenants. It hurts people like here that's opposed to this stuff, because they use this as a reason to say, oh, we don't want this, because the people that UHAB allows in are the ones that they don't want, because those people are like I call them undesirables. Like, they're just people that, like, they should not be living in places like that. But I'm concerned with the safety when it comes to this bill. This is going to hurt these people here more than everybody else, because if they open up with these laws where you can't discriminate against pedophiles like Douglas Powell, you let these people in, they go live next to your kids. And I know you have kids, Mrs. Sanchez. You don't want no pedophile living next to your kids. That one day you're home and then you heard that they sexually molested your kid. But this is a concern here. One more thing I want to say is that I know you have a constituent in your district that lives in a co-op that's under UHAB. And I think that with this conversation going forward between these guys, these people that's opposed to the bill, and these people that are for the bill, need to have her in that conversation, because she lives in the UHAB development, and it's at 1103 Franklin Avenue in the Bronx. Her name is Lydia Galapa of the Worker Justice Project. And I think that you should have her in that conversation, because she actually owns a co-op in the Bronx, which is under HDFC, which is under UHAB. And I know she's an influential labor leader in the city. Y'all all listen to her. So going forward, I think you should have her in this conversation too, because I think that she could probably be the voice of reason between the two sides, because she works closely with the city council.
Thank you.
So thank you so much.
Thank you. That's not my district, but thank you so much.
Yeah.
Appreciate it.
No problem. No problem. Sorry about that.
No worries.
I'm sorry, Councilman, there's one point I forgot to add, that if you would tolerate just 40 more seconds, which
I
is...
will tolerate it.
Thank you. There had been discussion during the day about the remedy and whether it was individual liability or not for certain situations. When we saw what was in the bill, that there is individual risk that is presented there, but also it was often met with the comment, well, it goes against the corporation, it's not against an individual, as if the corporation was something else. For these nonprofit co-ops, every one of these costs that has been discussed today, increased insurance, litigation risk, and so on, is paid by your neighbors and shareholders. It's not as if there's some big corporation with huge capital reserves sitting out there that has money to, sitting there. One person mentioned earlier saying, I'm going to have to create a litigation reserve now for this kind of thing. These places operate on break-even budgets. And with all the costs that have gone up, as you have heard in this, the idea that saying, well, it goes against the corporation, as if that someone else is going to pay it. When you say it goes against the corporation, it's the shareholders, it's the neighbors that you're with, and so on, and they're all paying for that. So the idea that, oh, I'll feel okay because I'm not going to pay it, you are paying it. Very important point. Thank you very much.
Thank you. Thank you. Thank you so much to this panel.
Thank you. Thank you.
All right. I am pleased to announce that we are now moving to remote testimony. You thought it was over? No, it's not. We will now turn to remote testimony. Once your name is called, a member of our staff will unmute you, and the Sergeant at Arms will give you the go-ahead to begin. Please wait for the sergeant to announce that you may begin before delivering your testimony. Okay, so first up we have Julia Engel, followed by Mark Schneider.
You may begin.
Hi there. My name is Julia Engel, and I'm the president of the Association of Riverdale Co-ops and Condos, which includes up to 130 co-op and condo member buildings in the Bronx, mostly within the 11th and 14th district. Thank you, Councilwoman. And as a co-op board member myself, thank you for the opportunity to testify in opposition of these three proposals. I will focus on 407 because of time constraints. As a co-op board member, as we all know, right, as a volunteer position, we've heard that several times, of the over 1,300 apartments which make up just my personal co-op, only 10 shareholders make up my co-op board. We should have 13, and again, that's less of 1% of all apartments. It is increasingly difficult to find volunteers for co-op boards as it is, and adding a requirement of a 5-day turnaround for a signed affidavit submitted under penalty of perjury would frankly probably cause me personally to resign as a board member. It was said that the law is not being proposed to attack boards or individual board members, and while I understand that, it's no more risky than already exists. This is false. I'm sorry to say that. But I, for example, am a licensed lawyer. So submitting an affidavit under penalty of perjury for an unpaid volunteer position, regardless of what it says or why it's being put in place, could frankly jeopardize my law license and my entire livelihood. And this would absolutely deter shareholders who are currently in the workforce or with young children to be on co-op boards. Co-op board members are an elected body. There are laws protecting elected officials. At a minimum, there should not be laws jeopardizing the livelihood of a co-op board member volunteer. It was stated earlier that the board could submit its minutes as a path forward. Unfortunately, prospective shareholder approvals are generally not required by law or co-op bylaws to be placed in the meeting of any minutes. Folks should be a little bit careful when they're submitting testimony like that, because it's just not true, unfortunately. Further, it's likely the managing agent who is making these determinations in the name of the co-op board. Why is the obligation not being placed on them as the paid representation of the co-op? The realtors are also being paid, and those who spoke today are supportive of the legislation. Why are they not implicated in the process? Or the lawyers, or the banks, or everyone together, et cetera? Why are
Time
the
has
unpaid
expired.
volunteers?
Thank you for your testimony.
Thank you. Thank you so much, Julia. Is there any other title that you wanted to mention that potentially should be named in any legislation we consider moving forward, aside from realtors and managing agent?
Yeah, the lawyers, the banks, or everyone together, frankly. I understand, why this is being put in place. It's a team effort to get these approvals through, right? And each one causes delay, right? That's uncontrollable by a board member. Why isn't it taken together? Why is it the unpaid volunteers and frankly, the shareholder homeowners who are the focus of this law? Why isn't everybody the focus?
Thank you. And does the idea that, or the concept that clocks start ticking after a complete application is received by the board, does that help with that concern that the realtors and others are causes of delays?
That's a great question. Received by the board is what I wanted to take issue with. It is not received by the board. It is received by the managing agent to process, right? And so again, there are, many steps in this process, right? Goes to the managing agent, then possibly it goes to the board, right? Doesn't necessarily go to the board. A lot of times it's the managing agent who will automatically reject because they didn't meet the debt to income ratio or something like that. So again, to focus on the board has received is unfortunately just not accurate. But I'd be happy to discuss more about what the process is and how many people have their hands, right, and their fingers in the pie, so to speak, because I really think that is the downturn, right? And in terms of timing, whether we talk about 5 days or 45 days, it doesn't necessarily matter. I understand 45 days seems extraordinarily generous, but I think the issue is that it's just so many different links, right, in the chain of needing to get it to an approval. So it's not always the board, right, that's just kind of sitting on things. Maybe something gets stuck under the managing agent's desk and it just, gets misplaced, and that should not happen, frankly, right, because they're being paid to do a job, and this is the job they're being paid to do. But I guess my point is it really should not fall to the volunteer members of the co-op boards.
Got it. Okay. Well, thank you, Julia, for taking the time to listen in today and participating. Appreciate your time.
Thank you so much.
Next is Mark Schneider, followed by Miranda DeNovo.
Good afternoon, Chair, members of the council. My name is Mark Schneider. I'm the CEO and managing partner of Schneider Buchel LLP. I also serve on both the New York City Bar Association's Cooperative and Condominium Law Committee, and I am one of the co-chairs of the New York State Bar Association's Condominiums and Cooperatives Committee. I'm here today on behalf of the hundreds of co-op buildings and co-op boards that our firm represents, as well as the shareholders and residents, all of whom will be directly harmed by these bills. I too testified in connection with the earlier attempts to pass similar laws. It is important to note New York City co-ops are not for-profit landlords. They are self-governing communities where their shareholder residents collectively fund every expense, from the co-op's underlying mortgage to the electricity and heating bills for the building. When an applicant is approved, the existing residents are quite literally taking on a financial partner. When an applicant becomes a shareholder and then fails to pay monthly maintenance, every other shareholder must shoulder that burden. And that is why co-op boards, acting under fiduciary duty, must have authority to evaluate whether a prospective purchaser can meet the building's financial obligations. The reality is this: the overwhelming majority of applicants are approved, and you've heard that today. The small percentage denied are almost always due to a financial risk, not discriminatory reasons. If you look at the discrimination claims brought against co-op boards, they're almost never related to a purchase application, and you heard some support for that today. They're typically centered around other issues involving existing shareholders. The simple fact is the legislation before you does not reflect the reality. Let's look at the first one, the 407. This bill would force volunteer board members who are volunteers and neighbors, not corporate landlords, to certify detailed reasons for denial under penalty of perjury within 5 days and to expose them to statutory damages and nearly guaranteed litigation. We heard about the legal fees provision. What's that going to invite? Lawyers who are going to say, I'll take that case because there's a likelihood it'll settle. This places volunteers in legal jeopardy simply for fulfilling their fiduciary responsibilities as volunteers. And you heard people today say they
time has expired.
Okay.
Thank you. Thank you so much.
Any questions that anybody has?
No, but if you could follow up with written testimony, that would be helpful.
Can I give you a concluding paragraph?
Sure.
Thank you. So taken together, these bills assume systematic discrimination or mismanagement where none has been demonstrated. They are overcorrect a perceived, not actual problem, using punitive mandates that will destabilize co-op governance, increase litigation, raise insurance costs, and ultimately harm the very residents they claim to protect. I urge the council to reject the bills. Thank you for your time today.
Thank you. Thank you. That's a privilege for people in the room who are hungry and have to use the bathroom like I do. I'm sorry. All right. Next up is Miranda DeNovo, followed by Alexis Foote.
Whoa. Hi, I'm so sorry. 1 second. Oh, okay. Hello. Sorry, I've been waiting a long time, so I had to pop out and find my testimony. Hi, my name is Miranda DeNovo. I'm a community organizer in Ridgewood. I'd like to tell you a personal story about living in shared housing and how I became homeless as a direct result. I moved to New York City in 2016 with no family and a serious undiagnosed medical condition, earning just above the poverty line. I've lived in all kinds of quasi-legal shared settings, mostly in and around Bushwick, with a revolving door of women and queer people in similar financial circumstances. In 2020, I was sharing a 2-bedroom apartment on Myrtle Broadway with 2 strangers. When the pandemic hit, both my roommates moved home with their families. I had nowhere else to go, so I stayed. My rent went from being $600 a month on a $40,000 salary to $2,000 a month on a $40,000 salary. If you're familiar with the math of rent burden, that's 60% of my income all of a sudden. I applied for the Emergency Rental Assistance Program, ERAP, but was rejected, and so I left and availed of the only lifeline I had, which was moving in with a friend and her husband. That was stable until it wasn't, when I got in a fight with the husband and he kicked me out. A stranger from social media let me stay with her for 2 months, and then I had to move again. There's a common argument that doubling up with family or friends can be a protection against becoming homeless. But in my experience, it's just another kind of homelessness, one that may keep you out of a shelter, but also keeps you in limbo with zero access to services. 5 years later, I have my own one-bedroom lease in Ridgewood, but I'm sharing again with a homeless friend who was rejected from the shelter system for being, quote, too disabled. I cannot stress enough that a 350 square foot apartment is not appropriate housing for two people who both have complex medical needs. But more to the point, it's not appropriate housing for anyone. We should not be normalizing the idea of a city in which 30 and 40-year-olds cannot afford to rent their own apartments. At least when I was sharing with strangers, we were able to work out informal deals among ourselves. By contrast, legalizing SROs will fuel gentrification in neighborhoods like Ridgewood and Bushwick by allowing landlords to charge even higher rents than they already do. Creating a system of regulations to legitimate overcrowding is not, as supporters are calling it, quote, a dignified alternative to shelter.
Thank you.
As someone who has lived in overcrowded
Thank you,
apartments
Alexis.
for most
Sorry,
of my adult life, the serious
your
impact on
time
my
has
health,
expired, and you can
I do
submit
not feel
written
dignified. I feel abandoned by the city.
testimony. Thank you. You can submit I'm sorry, Miranda. You can submit the rest of your remarks. Thank you. Alexis Foote is next.
Good afternoon, everybody. Thank you, City Council, for having this hearing. I did write something, but as someone who was an at-risk youth who grew up in foster care, I'm here to advocate for shared housing. Um, and I say that because my mom, Kimberly Queen of Jones, may she rest in peace, she died July 22nd of this year due to depression and the fact that the city does not take care of its most vulnerable. And I say that as someone who is actually in a shelter with my 20-year-old because I'm a domestic violence survivor. The police forcibly arrested me due to allegations of my husband, and families don't want shared living. Shared living is really for single adults, like the woman that spoke before me. Um, Adults like my mom who are older and have mental illness, LGBT from the ages of 18 to 24. But women like me with children who have careers, we need real housing. And this falls on the shoulders of HPD and the Departments of Homeless Services. And I need the city council to hear me. I need the mayor to hear me, the one right now and the one that's coming in. And I need Kathy Hochul to hear me. We need real housing subsidies. Housing subsidies. We need you to cater to housing subsidies. We need housing for mothers like myself. We need more 1515 housing. We need supportive housing, which is what my mother was living in, which is on 162nd, which is owned by L&M. It is supportive housing for those who are formerly homeless and for families with mental illness and families. We need shared housing for people like my mom who need a roommate. When you have shared housing, you don't have to worry about the utilities all on your own. And not only that, but the person that you share your housing with sometimes becomes your accountability partner. And what you have to understand is that when you have somebody coming out of recovery and they don't have
Your time's
kids,
expired.
they need, okay, I'll submit extra testimony, but please support real housing.
Thank you.
We need more vouchers. Thank you.
Thank you. I could not agree with you more. Thank you so much, Alexis. Daniel Arno, followed by Kevin Wolf.
You may begin.
Yes, thank you, Chair and members of City Council. My name is Daniel Arno, and I'm the Executive Director of Actors Fund Housing Development Corporation. Our mission is to increase access to affordable housing for people in the performing arts and entertainment. I'm pleased to provide this testimony in support of the Shared Housing Bill. Thank you to Council Members Botcher and Ressler for sponsoring legislation that would lower barriers to creating shared housing units in New York City while establishing design and operational requirements for these units. The Shared Housing Roadmap, produced by HPD, takes a thoughtful approach to re-envisioning the SRO model that can fill a gap in the market while increasing tenant protections for renters. Shared housing can even increase social connectivity and combat social isolation for vulnerable populations. We know this firsthand as an owner-operator of shared housing. the benefits and challenges of this important housing model. The Dorothy Ross Freeman Residence is an affordable and supportive shared housing residence, including 178 units on West 57th in Manhattan. We provide on-site social services. Apartments at the Freeman are mostly 2 and 3 bedrooms. In shared suites, each tenant has their own rent-stabilized lease, individual bedroom, and shares a living room and kitchen with 1 or 2 other people. Some apartments have shared bathrooms, others have private baths. Since opening in 1996, the Freedman has been a unique community asset and provides community and services for individuals who may be isolated or vulnerable in traditional housing. Shared housing also creates unique challenges, especially around roommate conflict. We have created a robust tenant handbook with info and resources, including a guide for living with a roommate guidelines, and conflict management. It's critical to have a strong on-site property management and social service team to successfully execute a shared housing program. With good legislation like Intro 1457,
Time has expired.
Financial tools, last line, and guidance to align building operations and management policies, we can reinvent shared housing to serve future generations. We're happy to support this bill. Thank you.
Thank you. Thank you so much, Daniel. We're going to have Kevin Wolf, followed by Rachel Bradshaw.
You may begin.
Good afternoon. Good afternoon, and thank you, Chair Sanchez, for the opportunity to testify. My name is Kevin Wolf, and I'm the Deputy Director of Advocacy and Public Affairs at the Center for New York City Neighborhoods, which is one of the largest homeowner service organizations in New York City. We support both Intro 407 and Intro 1120A. Together, we believe these bills will increase transparency, accountability, and fairness in the co-op market, which is especially critical for Black and Brown home buyers who face ongoing and historic discrimination. The center has a Black homeownership project that works to promote and protect affordable homeownership for Black families in New York City. BHP provides services such as estate planning and landlord-tenant mediation to help Black homeowners maintain their homes and build generational wealth. During our research phase, the BHP program conducted extensive interviews and focus groups with Black homeowners and home buyers in New York City. All of them reported experiencing discrimination. Some of them felt that they were treated differently by realtors and housing professionals because of their race. Several homeowners shared that they were steered towards specific neighborhoods and properties, often in disinvested areas. And one interviewee even reported that a co-op board ceased communicating with him after meeting him in person and discovering that he was Black. Despite existing laws, the evidence is overwhelming that many New Yorkers continue to face systemic barriers, including discriminatory lending, appraisal bias, and predatory real estate practices. We support increased data reporting and transparency for co-ops so that policymakers, fair housing advocates, and law enforcement can better address racial discrimination. By passing these bills and supporting homeowner services, the City Council can take a meaningful step towards closing the racial homeownership gap and stabilizing communities of color. Thank you for your time and for considering these crucial reforms.
Thank you so much, Kevin. Really helpful to hear those examples from CNYC. Thank you. Rachel Bradshaw, followed by Reuven Gilman.
Yes, hello. To Housing Chair Pamela Sanchez, Public Advocate Jamani Williams, Majority Leader Amanda Ferris, and all members of the New York City Council. So my name is Rachel Bradshaw. I'm an African-American homeowner in the Bronx, the household on food stamps. Through education, hard work, and saving, I became a first-time homeowner. For 8 years, I've served as Vice President, Secretary, and Board Member of my cooperative, Fordham Hill Owners Corporation, a majority minority corporation. I'm deeply concerned 403B and 1120A unfairly target homeowners and threaten the stability of cooperative housing, one of the strongest affordable homeownership paths for working families. In New York City, Black and Hispanic residents make up roughly 44% of homeowners, including many in mid-income co-ops like Co-op City and Fordham Hill. Cooperatives are built on values of democracy, equity, and community. They rely on volunteer boards, people like me who receive no compensation, yet carry the responsibility of protecting financial solvency, quality of life, and safety. Intro 47 attempts to solve a problem that barely exists. Rejections are rare, and when they occur, they are mostly due to financial risk. When buyers cannot afford their units, arrears can reach millions, leaving remaining shareholders to observe rising insurance, taxes, and compliance costs. Intro 403B would force cooperatives to release confidential or incomplete documents, including unaudited financials, to individuals who are not shareholders yet and may never close. This creates unnecessary liability and undermines proper governance. Intro 1128 imposes unrealistic timelines on volunteer boards and managing agents. Most delays come from incomplete applications, not board review. Smaller and self-managed co-ops would disproportionately be harmed. Collectively, these bills send the message that City Council does not value homeowners who invest in and remain committed to New York City. Cooperative housing is not the problem. It is
Your
an
time has
affordable,
expired.
community-driven model that keeps working families here. My last line. I urge the council to reconsider these bills and stop policies that weaken cooperative housing that have served New Yorkers for generations. Thank you.
Thank you, Rachel. I just want to clarify that you mentioned two bills in your testimony, 1120, and what was the second one?
Yours. Is it 40?
438?
Yeah, 438.
Okay. So you are not taking a position on 407 on the public advocates bill?
Yes, I oppose all of them.
You oppose all?
Threaten the stability of cooperative housing.
Okay. Okay. Thank you so much for your testimony. Appreciate it. I will next call Ruvim Gilman and Sergey Starostin. Sorry, I'm saying that poorly, but you are after Ruvim. Ruvim?
Thank you. Good afternoon, New York City Council members. My name is Ruvim Gilman. I'm here today representing myself as a resident of a co-op building in New York City and a former co-op New York City board member. While the intention behind the drafting of 407 may be laudable, the bill is fundamentally flawed. I urge the council to reject 407. The bill, with its expectation that co-ops provide a list of reasons for why a purchaser was rejected, tries to color the experience of purchasing co-op shares as a purely legal transaction, as if the purchaser is before a court of law and entitled to a full legalistic explanation for why they were rejected. Anyone on trial should expect such an explanation from a judge, but purchasing a co-op share is not like being in a court of law. It is so much more than a financial transaction. Buying into a co-op is about joining a residential community. In this way, the co-op approval process is more like entering into a relationship. It's a decision that, in addition to reviewing someone's bona fides and credentials as listed on pieces of paper, also involves assessing how someone portrays themselves and whether you feel they are compatible. Would you marry someone based solely on their resume and the size of their bank account? Boards have a fiduciary duty to assess whether an applicant will be a responsible neighbor. This often involves the good faith judgment of the co-op board based on interviews, demeanor, and intangible cues. And no, this is not code for discrimination. It's code for people having the right to choose their communal partners based on more than what their paperwork says. Can a board reject someone because they were argumentative in an interview, or because they were evasive, or even because there was a suspected substance abuse problem because of the smell of alcohol on their breath? And if they do reject for such a reason, can we really foresee boards writing this out in a formal documentation? Ultimately, unless the board has a clear financial reason for rejection, the rejected applicant is likely to see the explanation as a pretext for an unlawful, unstated reason. Boards will be damned if they do, damned if they don't. This bill, in essence, could be a plot line out of Minority Report. Why? Because this bill polices thought. It erodes the business judgment rule by undermining the genuine, honest judgment of a community, treating intuition as suspect, and demanding rationalization where sometimes instinct needs to be applied. I urge the council
Your
to
time has
reject
expired.
407. Can I just finish my sentence? Is it okay? Can I finish my sentence?
Yes, please. Yes.
Thanks. This legislation would be better focused on ensuring a fair and uniform application process across all co-ops rather than attempting to mandate and police the inherently subjective outcome of that process. Thank you.
Thank you. Thank you so much for sharing your perspective, Reuven. Next up is Sergey
Yes,
Starostin.
I'm sorry. I wanted to testify for 1475. I mistakenly raised the hand, so I'm sorry. Probably later.
No problem. You can testify on 1475.
Okay, so thank you, council members and the committee. And first, I want to commend you and your colleagues for recognizing shared housing as the essential component in addressing New York City affordability crisis. I'm here on behalf of Outpost and June Homes and its subsidiaries, and we collectively manage more than 4,000 housing units across the United States, including approximately 2,500 in New York City. For over a decade, Outpost has built a reputation for providing safe, high quality, and affordable housing options and are deeply valued by our residents. So I want to say that currently the shared housing is not a new or experimental concept. Roughly 40% of the New York City households are roommate shares. And this model has long served as practical market-based response to a city's high housing costs. And with today technology, like from roommate matching platforms to flexible leasing management system and building a brand in this domain, the shared housing is a safer, more transparent, and more efficient than ever before. However, the proposed legislation has some, in our opinion, some flaws that some requirements that would discourage both property owners and developers from participating in shared housing programs. And few key concepts that, in our opinion, need to be revised are number 4, exclusion of framed dwellings, number 5, mandatory cleaning requirements, number 7, the increased minimum bedroom sizes, and also limitations on bed counts, because the apartments of 4 or more bedrooms are among the most cost-efficient housing options currently. So I submitted the written testimony to the hearing, and would be glad to continue and be a part of the discussion further. Thank you.
Excellent. Perfect time. Thank you so much. Sergi, am I saying your name correctly? Sergi?
Yes, that's correct.
Okay.
Right.
Thank you so much for your testimony. We'll look forward to your written remarks. Next up is Grace Rao.
You may begin.
Sorry. Thank you. Thank you, Chair and members of the committee. I'm Grace Rao, the Executive Director of Citizens Union, which is now home to the 5-Borough Institute at Citizens Union, our public policy think tank focused on solving some of the big challenges facing New York City. I'm here today to speak in support of Intro 1475, Councilmember Eric Bottcher's legislation, and in support of the HPD Shared Housing Roadmap. Together, they represent one of the smartest and most cost-effective strategies we have to expand housing options for New Yorkers. We all know the problem. New York simply does not have enough housing or enough affordable housing. And additionally, we are not building the kinds of homes that people actually need. With millions of square feet of office space sitting empty and hundreds of thousands of new residences needed, now is the time to innovate and embrace new approaches to housing. At 5-Borough, we have been calling for this shift for some time. 2 years ago, we released our Flexible Co-Living Report, which urged the city to legalize modern dorm-style units with shared kitchens and bathrooms in office to residential conversions. Essentially, we viewed this as a way to make office to residential conversions happen more affordably. And we are so thrilled to see our research and ideas reflected in HPD's roadmap and Councilmember Bottcher's bill, which seeks to bring many of those ideas to life. Due to the design and layout flexibility, this model has the potential to add twice as many housing units to the market compared to traditional residential conversions of an office. This approach also lowers housing construction costs by maximizing the existing plumbing infrastructure.
Your time has expired.
Our report found that flexible co-living is expected to cost about half of the typical $300 to $500 per square foot spent to convert offices into traditional apartments.
Thank you.
Thank you so
Grace.
much. We encourage the City Council to pass this legislation quickly so that New Yorkers can benefit from the additional new housing.
Thank you, Grace. Appreciate it. I want to take a moment to just shout out HPD for still being here. Mia Perez, I see you. Thank you. I hope you've eaten and gone to the restroom. Thank you. Okay, I'm gonna call on Leo Brazil. Tice Routledge. Connie Erlinger. Gal Ozana. Daniel Arno. Bake Tiam. Tara Stackholm. Veronique Monier. And someone also signed up under just Sarah. Sarah, are you here? Okay. If we have inadvertently missed anyone that has registered to testify today and has yet to be called, please use the Zoom raise hand function if you are testifying remotely, and you will be called in the order that your hand has been raised. If you are testifying in person, please visit one of our sergeants and fill out a slip. Do, 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 do. Seeing none, I will now close this hearing. Thank you to the members of the administration and the members of the public who have joined us today. The hearing is adjourned.